And good afternoon, good evening, and good night, and welcome to the continuing coverage of the Kyle Rittenhouse rewatch party, which I've been apparently sitting doing here by myself for the last 10 minutes because I didn't hit the go live button. Hope everybody's doing well. I've moved it back to where we started, and I'm going to get stuck into this, so just give me 2 seconds and we'll get right back to it. Alrighty, I'm going to finish getting myself set up because as you can see I'm wearing the hat because my hair is terrible, and I will let the video play and I will make sure now that we are actually going out live. Yes, it's going, so I shall see you all soon.
Right.
I assume that's not something you can do instantaneously. That'll take a little time for us to put them on a hard drive or something along those lines.
If you give me a hard drive, I can do it whatever instantaneously.
We can work on that.
If you give me a skateboard, I can do something interesting.
Videos. Did you change anything other than the color and contrast?
The speed.
We've already talked about frame rate. Poor question, long day.
Right.
You changed the frame rate
Correct.
on some of them. You changed the color and contrast on some of them, correct?
Well, I didn't change the color. I changed the brightness.
Color.
No.
I'll ask it this way. Were any of the frames color added or subtracted?
No.
Okay. When color is added by either the operator or the program, that's called interpolation.
No.
It's a term, but yes.
And those are done through various different ways. Is that a fair statement?
That's fair.
Okay. One of them is bicubic.
That is a type of interpolation. Yes.
Okay. Can you name the types of interpolation?
If you're using the word
I can name some of
interpolation,
them.
you should
That's
stop.
The ones that this software allows me to be aware of or qualified in.
Go
Let's
ahead.
talk about
Three of them would be,
trilinear
for
aniscopic
example, nearest
filtering.
neighbor, bilinear, or bicubic are three specific types of interpolation or algorithms used in that. Now, something that should be known about this is these are done primarily when enlargements are being done.
If they want to hurt the jury, I'm sure the bailiff's got some pepper
was the
spray. They
first
could
one,
just
the second one you
cut out the
said?
middleman here.
Bilinear,
Bilinear. And the third?
bicubic.
You do that on an
Does
RTX
nearest
3090 because
neighbor
I'm trying to
change
find
the
one
color
and I can't.
composition of something that's blown up or magnified.
No, what nearest neighbor does is it takes existing values within the frame already and uses those existing values to fill it out, so to speak. If I had something that was pitch black here, 100% black, and it said, hey, we need to get bigger, it would fill it out only using that color of black or white or whatever else happens to be within the frame.
Bilinear, does that add colors?
To some degree. In other words, if you had something that was, well, let's just use like a line of blue, and you had a line of red, there would be something that exists between the blue and the red value here that would not necessarily have been there before, so to speak.
So the computer, through its program, fills in the blank, so to speak.
Yes, sir.
Bicubic, does that add anything?
Yes, much in the same way as bilinear does, but the difference is, as it sounds, linear is more, think straight lines, and bicubic is if I had something in the middle, it would basically gradually go out to match the other color. So if you were to think about it like a progression, you would start here, and if I have so far to go to get here, it would take a little bit more of each of that color. So you'd have a much more seamless image. You'll get much less jaggedness to it, that type of thing.
And as you sit here today, is there any clip that you could take and just show by moving the bars, color and contrast, what happens? Not color, brightness and contrast, I believe.
Yeah, I can actually.
Could Could you demonstrate that for the jury? Take one of the standard clips.
See, this might have been okay if it was used to block Binger's, video, but that's already admitted.
And you just want the idea of
Now they're
brightness
letting them
and
play.
contrast.
They're
Correct.
saying we can play around with the video when they've already got the concession that they got the concession. Don't take away the win from the concession.
It's a waste of time. The jury either wants to hang themselves or hang the attorney at this point. Like, why are we watching this guy do this?
Yeah, I feel like right now they're all thinking about the conclusions that they've already made at this point about Kyle.
Look at this fine new rake. Look at what
I'm sure
happened.
they're
when I
thinking
step on it.
they're thinking about the fine technical
Oh.
details of how images are manipulated, which is basically what I do with my career all day long in patent law on fine technical distinctions of how things are done. So they're thinking about what I do for a living. Yay.
Can we? What the fuck?
Probably more than just thinking about.
PBS did
I had a
this.
delicious Asian lunch.
Yeah.
PBS knew that we were watching, Nick.
I might be actually more qualified than this guy to talk about this.
Oh, we're back
And all
now.
I'm going to do is I'm going to slide this in that direction, and you'll notice it lightens up. If I were to keep sliding in that direction, it lightens up some more. If I wanted to get a little bit more contrast to it, and then as Mr. Binger has already described, I move them around to a place where I can get hopefully a little better understanding or clarity. And
So what you
Did you
just
do
did
that
on-
with the
on
video where he
slide on
says
top
the
of
N-word?
screen, that was doing both of those manipulations?
yes, sir, one from one side, one from the other. Those are the two values in the report.
And so basically what you've done is taken a video that is dark and unrecognizable and turned it into something that's useful.
Yes, sir.
And you haven't added anything to it?
No, I haven't added anything to it, nor has the computer added anything to it. There's no interpolation being done with this other than the lightening and the algorithm for the lightening and the contrast, but there's no additional pixels being added. I'm not affecting the pixel count.
And you did that on some of the videos that we've shown this jury previously.
The two videos that have been demonstrated to this jury that I worked on, that I did the clips from, this is all that I did. There was other videos worked on that I did do enlargement and these type of things. They were done by
Maybe
nearest
you
neighbor
could do
law
this with
solicitors.
Corel
As
Draw.
far as I know, they have not been presented to this jury.
Understood. Thank you.
I used WordPerfect.
Microsoft Paint.
Thank you, sir.
We bring in a fax machine here
Some
somehow.
housekeeping
Law
matters.
needs more fax machines.
About 10, 15 minutes, so please don't talk about the case during the break.
Is the defense's
break.
case over?
Nothing happened for 20 minutes.
Yeah.
Did they rest? And if not, why not?
Well, that was, I guess the state gets to have re-rebuttal, or not re-rebuttal, recross again, because that was redirect.
Yeah, I guess.
Okay, so I'm just
Can we just go to closing arguments now?
Yeah.
while we have a break here, I'm just going to ask that you guys. I know I made an offer. Send me memes and I'll vet them. We're good. We're good. We're covered.
We got our names?
I had like
enough
140
memes?
message requests.
I also got the astronaut
God.
meme. So
Nice.
I would also like to request that people send more memes to Good Logic.
Thank you. Thank you so much.
Yes, I would like to second that motion.
Don't let this man weasel out of his words.
This is like a full-time job now.
Oh my gosh. Oh, no.
Make your offer. You can talk about it now so that we can tell whether there'll be an objection. But make the motion in front of the jury, because when I give the instructions, I'll tell them that they're only to consider things which have been received.
Okay. I would make Dr. Black's CV, and I would submit Exhibit 142, the timesheet. And I know that Mr. Binger has objections to that, and I would have that changed to use the method that I use to identify them, but the times would still be the same.
I don't have an objection to the CD. At this point, I'm not in a position to comment on 142 until I see the final version.
All right, what else?
At that point, we would rest.
Is there to be a rebuttal
Yay.
case?
All right.
How long?
Well, we have one witness simply to verify 2 photos. That is what the defense wanted to report on. The length really depends on how long the defense wants to cross. I have like 3 minutes of questions.
I didn't hear the last thing you said.
I probably have about 3 to 5 minutes of questions for him. Based on the information I know now. I don't
So funny.
Okay.
On your honor.
Well, let's have them have their break, then we'll come in and take care of that. You ready with your witness?
He's here. The defense had asked for these reports. I don't know how long they want to review them. He brought reports for almost everything he did. I think they're mostly interested in just the 2 most recent things. If there's going to be a fight over this, I'd prefer to have that fight before he testifies. So I guess I just don't know how long the defense wishes to review these documents they requested this morning.
Well, why don't you give them, or if you have not already, give them the material now. They can look at it, and is there going to be a need for a lengthy delay?
I don't think so.
Okay. Let's aim to start at quarter 2, and then.
All right. All
Got
these
20
streams
minutes.
are doing great.
Well, if they're to be believed, it looks like the closing arguments will
Be
probably start first thing tomorrow,
Okay.
and the jury will get this case by
Have
lunch.
to be done with evidence by 3:15 or so, and then we can start talking about.
How long do you
verdicts
think
and-
deliberation will take?
Oh yeah,
so,
unless they are going to talk
go
about
to the jury tomorrow.
directed verdicts and stuff for the rest of the day, which would make sense too.
That would make sense.
Oh,
Can we discuss that in more detail after the break, Your Honor? The timing?
I mean, my thoughts are, there's been a lot of evidence. A lot of people are real tired. I spoke to Mr. Binger, and miraculously we agreed.
Whoa.
We'd rather do it on
Wow.
Monday.
We'll do what
See,
Monday?
I would like to start another jury on Monday, number 1. Number 2, where the jurors are here, and they've been here, it's a long trial, and
Do it tomorrow, you cowards.
yeah. Respect the jury.
Yeah.
I didn't hear you.
I see, that's worse than Monday. Whatever the court says, I'll make myself available.
Yeah.
Yeah, because you just extend the
Where we're
risk
headed
of
right now, it's
jury
gonna be,
issues.
He's got a more important trial on the books, so he's got to focus
I
on
was just
that.
thinking the same thing, like Monday's worried about Monday's jury trial, really? Just give
Oh,
an
but
adjournment to Tuesday on that.
Best case scenario, I think we're looking at beginning instructions tomorrow morning, first thing, and then closings, which I think that process between the 2 of those things could take us well into the afternoon tomorrow. And then we're starting deliberations at 3 or 4 on a Friday afternoon. I think that's less than ideal.
Well, but the alternative is to send them home until
Especially if
Monday.
you don't have a 30-minute,
Then we'll have the same issue. We'll have the instruction and the argument on Monday.
I think having them come back, if they need to deliberate further on Monday and into Tuesday, it's, I think, preferential to having them deliberate.
He's more worried that
Friday
they'll rush
because
through a not
Friday.
guilty
Why?
verdict.
I mean, I'm a dick, but why?
well, judges don't like to work on Saturdays.
Tentatively, I'll say yes now until I
Nobody likes to work
go
on
back and
Saturdays.
have buyer's remorse.
Yeah, I don't think a jury would want to be there on a Saturday.
But let's
Get this thing done.
Let's finish up, and then I will want to talk about instructions somewhat today and verdicts. So, okay.
And
Quarter 2.
Nick, this means that you can grift longer.
are we not doing
Yeah,
a
but
motion
there's
for
nothing to
directed
grift
verdicts?
tomorrow.
We're not doing that.
Yep.
They're gonna
We're
give me a
griftless.
day off. What? There are 3 days in a row of no.
Yeah, you're never gonna
Rittenhouse?
get back
that
75,000
means
tomorrow.
we can all go to Eric Hunley's channel.
Yes.
There you go.
Yeah, that's right.
Here. I gotta.
Or we could go to
gotta
Nate's
share.
channel and pick up the mod case,
God,
figure out what's
yeah,
been
that's
going on
right.
there.
Is this the one? I think. Yeah, this is it. Here we go.
Oh,
someone sent that to me. Not
Binger's seen that face before.
Very unprofessional of them. I can't believe they would do that.
If you've got 3 days off, you can catch up on some sleep. But remember, don't stop drinking all at once. That can
Oh, that's good. That's good.
That's Binger's nightmares right there. Why does this guy keep saying I suck?
Yeah, make sure to invite Binger on to the panel next week. That'll be good.
Oh yeah, I'm sure he would love that.
In theory, not here, not with Rittenhouse, just for all you in the back. But in theory, that's a situation
here we go.
where someone can have perfect self-defense.
Okay.
While recklessly endangering
So
the
Attorney
public.
Tropsy suggested maybe we, I guess, ordeer the witness ahead of time, just see if there's any issues, so that if there is an issue that arises, it won't be 5 minutes after the jury comes in. So I expect this to be a very brief witness.
Makes perfect sense to me.
Excellent.
All right.
Hey, seems like they could have done that on previous witnesses.
Move the voir dire, and then the jury come down, and then
Yeah, I mean,
rest.
then you rest, then the state will do its rebuttal, and
I would move the two exhibits into evidence in the presence of the jury and then arrest.
rectamundo.
we've seen this where the state has brought in experts and not voir
He was
dired
in his
them at all.
office.
Did he say correctamundo?
Yes, he did. Yes, he did.
In the office with the rabble. I've only got.
You just doxed your kid, Viva. Yeah.
Did you guys see the petition to disbar Zinger that's floating around?
Oh, I haven't
I didn't see it.
It's great.
I messaged it to you, Nick.
Did you see that the Illinois State House has made a movement to remove Judge Schrader?
No.
The Illinois State House.
Okay,
to be
fine.
clear.
No, like I don't agree with a petition to disbar Binger because
I do.
Well,
it should not be a question of public opinion. It should be a question of the bar doing it.
It's going to have no impact on.
Well,
what
yeah, I
the bar does.
want the bar to disbar Binger.
Of course.
No, but
That's what I want.
This idea of like we're going to disbar lawyers based on the public opinion. I mean, that blade cuts both ways depending on the political
Yeah,
time.
that's bad news for me
Definitely.
potentially. Let's not do that. So
That's happened to me 11 times, Viva.
Kind of the, I don't want to say the notes, but the work that you had done.
Get on the mic.
In terms of the images that you had blown up at his request. Is that, I know it's a rough way to say it, but is that fair?
It is fair, yes.
Okay. And I don't know if you have the report with you, but if you do, could you just turn to page 7 to make sure I'm.
This witness breathes so heavy into the mic.
It's difficult.
And
It's
when
like they made
Sheriff
him
is
jog
he's
up
so
the
far
stairs.
from his.
They made him jog up the stairs before he got to the stand.
There's very few people left in the courtroom, in the background.
We're speaking to the clerk.
They're playing Squid Game in
Did
the
you just
background.
say A? God, you're Canadian.
Done in reference to the latest, I think, 8 photos that were asked to be enlarged.
Is that page 7?
What was that?
I'm hoping that was the witness.
I think
chupacabra.
His stomach.
On the top of that page, it says.
That is fair, yes.
And then as we move down, there's a portion or a headline or a title in bold that says interpolation, right?
What the hell is that?
Yeah.
No, I'm not seeing it.
It's a headline in bold that says interpolation. That doesn't look like other words.
Oops. Page 7? Oh.
Maybe this
Sorry.
helps. I'm
Yep.
asking, does the R20,
2992, yes.
does that help? Okay.
One moment, please. sorry, I need to see, and may I see what you're referring to again?
Those better be jalapeno Pringles legal bites.
Yes,
This is riveting. This is riveting.
Thank you.
The jury's not in there yet, so
What's the object
forgot.
of this guy's testimony?
This was the guy who introduced the drone footage with the edited clips of it. So now they're voir diring him on interpolation because, he said, well, Binger said that pinch to zoom doesn't change any of the elements of the video.
That's
And
like
so
a
now they're
magnifying glass.
Yeah,
It'd be-
Binger's going to get corrected again.
Yeah.
Is this guy? Is he FBI? This
Sorry,
guy?
I'm there. Thank you.
I think he just works. I think he's with the Wisconsin State Police.
Okay.
It says
Their crime lab.
interpolation, right?
Yes,
And then next to that, it says bicubic.
that's correct.
And what does that mean?
Means that the interpolation algorithm that was selected was bicubic.
Are there other interpolation methods that you could use?
There is, yes.
And what are some of those?
For example, nearest neighbor is one. Bicubic, bilinear.
And can I just ask you to do this so we understand this? The photo that you enlarged at the state's request, how much, is it pixels that you expand? What do you do to make it bigger?
It's based off of the enlargement is the interpolation that is used. So with regards to this references a video that was interpolated and outputted. Are you speaking to the photo?
He sounds nervous as
Speaking
hell.
of photo, what number is it?
He's
He did
seen
the
the
first time
previous
he was up.
crosses.
Yeah.
He's got to explain what interpolation means, but I hope he uses the magnifying glass
I'm
analogy.
going to ask specifically about that one.
Okay.
Okay.
I hope he uses
So
it to say it's
you had
not like a
taken
magnifying glass.
Yeah.
A still of a video and you have zoomed in on it, for lack of a better term.
I would not say zoom. I would say it would been enlarged.
And how do you do that?
Binger about to get
We
binged.
use a algorithm, bicubic algorithm, for that. For this particular, are you referring to both images or just one?
They're both the same, right?
This one was used with a smart resize algorithm, and then this one is used with bicubic.
I'm sorry, you said this one was smart size?
Smart resize.
And what is that?
That is a algorithm that is part of the AMP5 software that resizes that image.
So, I don't know if this is gonna be, it's easier for me to do it this way, I don't know if it'll be easier for the court, but in my, tell me if this is right, can you just turn the thing for a second? Okay, so, when you are making things in large, right, you are you adding pixels?
Yes, I am adding pixels.
Okay, and so, tell me if this is bicubic.
Excellent.
And I know this will be rudimentary,
Yeah, that's
but
the key.
forgive me. So if these are pixels, R is going to stand for red, okay? And these are red.
Just remember, this is entirely for the 9,000-year-old judge who remembers hanging out with Jesus.
And
the
the
Roman
jury is
Empire.
not in the room.
Blue.
But is
Those
this
em-
relevant?
those empty. Yeah.
Is this relevant
ahead.
on the substance of the video? Because
An image.
It's relevant on
What
whether
is
they
the
can get in that
Pinch
pinch
and
and
zoom.
zoom.
Yeah.
Algorithm do to these pixels.
The bicubic algorithm is taking those pixels and resampling, or
He
I'm sorry,
literally
is-
pulled this
is
off
basically
Wikipedia.
duplicating those pixels into another area. Beyond that, I cannot say.
Do you know, based on
Can't
your
say.
training
Bad
and
expert
experience,
answer.
Yeah.
what
not an
color
expert.
the bicubic algorithm makes these pixels?
I do not know.
Do you know if it makes, if we know this is a red pixel and we know this is a blue pixel,
Sheriff
and those are
Fees
real
Sheriff Fees is the most competent lawyer in that room by far.
will it
It's not even close.
combine
Yes.
these two pixel
I mean, to be fair,
to actually
Yeah, this
change
it's not a hard
of
it's not a
the
hard
image?
accomplishment, but still,
You know what I'm saying?
he's actually
I can't speak to that.
he's
Wow.
he's very
I
solid.
want to be clear.
oh,
The unassigned ones that you have in the middle?
Yeah.
Those are the added ones?
Yes.
Okay.
So the added pixels, and what, to be fair, in terms of what we're looking for, to make sure it's the color's correct, that we're not distorting the color of the thing we're looking at, it's adding pixels, and my concern, my question for you is it adding the correct color of the original image?
That goes beyond into the algorithm of the program that I do not have that information for.
Okay, so
Wow.
if I can ask you
Next.
this,
And
And
prosecution
there's
has been
other-
burden here.
photographs that you have enlarged.
this is the expert they
Okay, so
brought.
you
He's not an expert.
added.
Notice
he's
how
saying,
John Black explained
Correct.
everything
Okay.
asked without
And-
hesitation.
Are you able to
He's
tell
saying
the
I can't
court
answer that without getting the same look that Gaige
were
Grosskreutz
there
got
originally
when he said
are
yes.
actually
that's
the same
correct.
colors
Witness, would it help you
when I
if I gave you the
expand
Wikipedia
or
article to check
enlarge
right
the
now?
photograph
All right, gentlemen, I'm going to
with
keep
the
watching.
added pixels?
I'll see you in the
Are
chat.
able to say that?
I'm not
Okay.
able to say that. No.
Steve Viva.
So you,
Gentlemen,
I'm not-
come on,
tell
Viva.
me if I'm right.
What about me?
So the things that the court would be looking at here,
Mhm.
and the colors that the court would be looking at, you can't tell the court that in fact that's the color from the original picture, correct?
It comes down to the programming, the algorithm. I cannot say it.
Mm.
Maybe say 1 second here.
You lose.
Yeah, and remember, the prosecution has the burden here to get this admitted.
Yeah.
So if their expert can't give enough information
Or
in order
qualified.
to show that it's reliable,
Yeah.
Another
No longer an accurate depiction.
wouldn't have changed the potential color of the pixels that you added.
Not
There's no testimony that the color has been changed.
I didn't hear you.
There's been no testimony that the color has been changed.
Doesn't matter.
I said we don't know what the color is.
Oh, the witness is looking
It was my
bad.
impression that
Yeah.
in the effort to enlarge the image, that the individual is inserting some
Worse, there's testimony that he
Call
doesn't
them
know if the color was
uncharged
changed.
pickles that
Pickles.
He said pickles.
the
Oh, for
algorithm is
God's
going to
sakes.
assign colors
Piccolo.
beyond his control.
The
Where am I going
uncharged
wrong?
pickles.
I don't.
He's training
Those
Gohan.
Negative ions
Could he have
on
used
the
a
pickles.
different algorithm?
No, I'm not, you're past me. I'm just trying to understand if I've got the basic concept down.
They plucked him out in
My
1924
understanding was
he's so cute.
and said, "Hey, run our trial, please."
his expertise. I heard the.
No, I'm back, way back.
He thinks pinch and zoom is a vaudeville
I'm
act.
still using watercolors.
Somebody please make a Piccolo
He
meme out of this
is
judge.
enlarging-
I love
he
it.
wants to enlarge
I thought
the
he said
image.
pickles.
I
Yeah,
got pickles.
pickles.
He is-
I got
Yeah,
pickles too.
he's inserting
Charged
Subtitle said
Pickle Rick.
Piccolo.
Hit him with
Subtitle
that
said
special beam
Piccolo, I
cannon.
read it.
And so he gives it a command to insert the pixels.
No,
And
I
he
got it.
doesn't know what color they're going to come out. Is that it? Is that it, sir?
I would say, Your Honor, it's as to
Don't
how
confuse the
that
judge, just say
algorithm
yes.
interpolates those pixels and where it places them goes outside the scope of my knowledge.
Well, what do
So yes, he
Well,
he
what
doesn't
do
know.
you know?
The answer is
What
yes.
I
I don't
know
know.
is that the process that I use to
Do we think he's going to
expand
get qualified as
or,
an expert? What
enlarge
do you
this
know?
image and the interpolation method
he never
that
was qualified.
used. Anything beyond that within my software, with the software I use, I do not have any additional
and
information.
competing.
I'm the guy who bought Photoshop for the department.
Yeah, that's basically where we're at.
We could find a random 10-year-old who could explain this better.
Different colors.
He's your expert.
It's possible.
And you wouldn't have any way of knowing.
I would not. I do not have any way to know.
Poor guy.
If those different interpolation methods.
If they
This
qualify,
happens
would it,
sometimes. Prosecutors
issue
try to bring
different
in
colors
cops
to
who are
different
not
pixels?
witness or who are not experts.
What were you telling me?
What I had asked him was, I wasn't telling you anything. What I asked a question I was objected to, which was there another method that could have been used? Which
I bet they're regretting that
the word
objection
that I
now.
had said was, would you have changed the pixel colors? Which I drew the objection.
And what was the objection?
The objection, there's not testimony that any colors were changed.
Oh, geez, he's pissed.
How would you know?
Yeah, because he
He
just,
may or may not, but the way he asked it is assuming that colors changed.
well, congratulations, you've now
ahead.
completely spiked
there
your
another-
argument.
Interpolation type of program
When Kraus
that
gets
you're
angry, he
aware
sounds
of
autistic.
that
He's
when
just hungry.
pixels are expanded,
He should stick to what he knows.
He hangry.
would keep the color constant through the expansion.
The buffet.
I cannot speak to.
John Black answered this
Would you
and said,
agree
yes,
the
there
more
is.
pixels that you add, the more.
It's bilinear versus bicubic, I think.
Yes.
So the question that I have, and then heard is when you expand photograph, you're adding pixels, but you can't tell the court what color is being added, if any.
I cannot speak to that. No, that comes down to the programming the algorithm on the software.
So the original.
Look how angry the Black is back there.
Yeah, because this is his area of expertise, and he's watching this guy slaughter it.
Those pixels expand. The question is, do the colors stay?
Same reason we get angry at bad lawyering.
I do not know.
please don't qualify him.
No, there's no way.
From the chat, nearest neighbors. The chat says nearest neighbor is the answer. That doesn't change the color, and I believe John Black testified to that. So it wasn't the bilinear that I said,
The software you
which is great.
use similar to the Input ACE software.
It's similar.
But it's not the same, so it's irrelevant.
And methods, as far as you know, are also in that software.
It's both softwares are made by two different manufacturers. I can't comment on whether they're the same.
So
He's dying up here.
enlarge these images.
Help me.
Are you
I'm
changing
melting.
any details?
I'm not changing any details.
What are you doing?
We are simply just adding pixels to
That's changing
make
details.
the image larger.
I'm hitting enter.
Because when you're looking
And I
at
guess
a smaller image on the screen, say it's
I mean,
20
look
by
at Black. I mean, his brow is like completely furrowed back there.
You're using more than 20 or 20 by 30 pixels.
Like he is like mad.
All in the same size.
That's correct.
So
I think afterwards he's gonna wait for the guy outside the courtroom and give him a couple of shots.
He's got T-Rex arms. He's not hitting them.
video with this Input ACE software. Would that
Good news
also
is
be
that
adding
if the
pixels
wings,
there?
collapses on the stand, at least they've got a medic in the room at the defense table to fix him.
I'm trying to understand. I mean,
I beg pardon?
I'm trying to get an understanding of how this works.
Oh, go ahead.
Then you're asking the wrong witness.
I do not know as to input is and how their interpolation for if any
Not good.
is seen by zooming in on there.
So
You're either going to get fired or have new training after this,
the
homie.
only way to enlarge an image is to add pixels.
Correct.
Now, you
Can't
don't
have a witness say, "I don't know" when you're bolstering them that many times in a row. I mean, it just doesn't work as a practical
correct.
science.
The software program does that.
That is correct.
And it has to do that to actually make the image larger.
That is correct.
Now,
this expert was prepped by
The
Lionel
opposite of what
Hutz.
Binger said yesterday, by the way.
Yep.
Yeah.
called AMP5, the gold standard of video editing.
But I mean, they also were told that they needed an expert yesterday at like what, 4
in-
p.m., 5
It is a
p.m.
program that we use at the.
So
Yeah.
they
This guy was probably
definitely
coming
had
off
no
a
time to
shift.
find anyone.
And they go, yeah, by the way, you need to be in court tomorrow.
They already had this guy.
They had this guy to talk about.
And he responded, that's what.
He's the guy who edited the video.
That's not
Right.
or it doesn't establish that it is in fact the best.
I understand.
I can tell you, not everything the state supplies is top notch.
Including you.
Damn!
Oh,
Pizza
God.
slice is top notch.
That needs the
Like
arrested
your audio,
development.
Judge?
So you get like full screen on your computer.
No.
Now, this AMP5 software has an algorithm.
And it was speaking to exactly.
When you interpolate, there's an algorithm that fills in the image so that you can actually see it, so that it's magnified.
When you are dealing with looking at it from a preview,
Morning, Andrew.
it uses its own nearest neighbor, but it does not add pixels in that preview.
So these processes you use, are these the standards used in the forensic imaging that you do?
Yes.
And this is the kind of software that you are trained on?
Yes.
And this is an accepted software program.
One of the commenters say this is longer than 3 minutes.
Yeah, that too.
Because they're getting ruined.
And
This is another 4chan photo chat moment.
Kraus needs to go for an STD test because he just got effed.
Ian. We're supposed to be kinder to great victims, isn't it?
That image didn't add color into pixels that weren't there originally.
I cannot definitively say that because I did not write the software program.
So it's possible when you enlarge an image and add pixels that you're adding colors that weren't there in the original photograph. Correct.
I do not know.
You see, no, you should stop right there. Just stop right there.
Yeah,
and
don't-
sit down. Leave it with an I don't know and sit down.
Tell me, what color goes in here on a nearest neighbor?
It utilizes. I'm sorry, I do not know.
Oh God.
Would it become purple?
Please say
The
yes.
defense expert knows
Oh,
more.
Purple is nowhere on here, is it?
That is correct.
Nothing else.
The defense lawyer out-experted the state's expert?
Well, I mean, would it be purple because
Well,
that's the
the-
nearest of
Needed
two
to-
neighbors?
So-
hold on.
in the software program.
I would need to and see exactly how those programs are interpolating those pixels.
Which is proprietary.
do
Was
you
I the
ever
one who
check
actually heard?
the enlarged image against the original image and see if there are consistencies?
Yes, we can certainly compare the original to the enhanced version.
Kraus,
is
get up
your-
and get to the podium.
Is your work, and were these images and your work on these images peer reviewed by another forensic imaging specialist?
Yes, that's correct.
Forensic.
Nothing further.
Who's just as incompetent?
Who is that? Who is this peer? If they're as good as you are, then what's the point?
You can step down, sir.
Don't suffer this guy.
Sheriff Vesey was done. I actually heard someone say.
So what the state is trying to do is introduce a photograph that has been enlarged where this person, Mr. Armstrong, cannot testify that in fact colors weren't added that weren't there originally. And the photograph, I'm going to tell the court that the photograph that the state intends to offer, I believe they will be arguing, shows Mr. Rittenhouse doing something with his firearm. If it is not the same as the original and colors were added to that, that is a distortion of what in fact the original photograph was. It should not be admitted because it's not relevant if he can't testify. And there's been no appropriate foundation that in fact it should be admitted if he can't testify that it didn't add colors, that colors that originally weren't there still aren't there.
Say it.
And I think under
It's
the
not-
circumstances, based on the evidence that you've heard today, you should not admit those photographs because they are not what I would consider to be mirror images.
Fair
of
and accurate
what the
depiction.
original photograph was.
Just say it's not a fair and accurate depiction.
Judge, all due respect to your honor, I think the defense is trying to take advantage of your lack of knowledge about technology.
Oh my
Oh,
God.
You son of a bitch.
With the defense argument, you could never have an enlarged digital picture.
Not true.
All of Nathan, and I
Why?
understand we didn't object to them, but all of Nathan DeBruin's pictures that he brought in on his own on these prints are enlarged digital images.
You didn't object
If
to
the
them.
defense
You
is
actually
now
didn't
trying to
prove
argue that enlarged
don't know that
digital
either.
images are not reliable,
Is he testifying?
I mean, it's
Are you
first of all
testifying, that
hypocritical,
boy?
but second of all, this is just not the age we're in. We're
Hypocritical.
in an age where software is able to enlarge and do things. And yes, this image, we
And do
believe,
things.
although
Have you seen
blurry
CSI?
because of the enlargement, does show in rebuttal to Mr. Rittenhouse's testimony, does show him pointing his gun at individuals just before Mr. Rosenbaum chases him. The defense, this is clear of the drone video. We pointed it out in the drone video. The defendant denied it. This is an enlargement of that drone video so that we can
And an
see a better
editing of it.
picture of it. This whole canard of adding pixels and changing color is a dishonest argument. And I believe the defense knows that.
Oh,
Their
What a
expert
lying
used a
son
very
of a-
similar software to zoom in and edit and change things, because if these things are reliable and they are reliable and that this is what is used by digital
that's not what your
by
expert
forensic
said.
imaging forensic scientists.
This is why you're not supposed
the
to
industry
argue when you're
standard.
angry.
So
Right.
if we're going to say that no technology can be brought in, no enlarged images can ever be brought in, that is a ridiculous standard. And that
That's
Maybe
not
you
what
can
they're
brought in
saying.
by a
experts
competent
now
You
legal
have to
team.
about
prove
how
the
these algorithms are
reliability.
used and what they do. And simply because this evidence may be not beneficial to their client, and in fact show their client is lying,
No witness admitted it's not a fair and accurate depiction.
they're stupid to this level to try and keep it out. And to me, I think making a dishonest argument based on
This
a
is
number of
dishonest argument.
forensic scientists that have
Objection.
emailed me to discuss this issue with the Apple Zoom in,
Judge
which I
should
think is
actually
also
tear
very
him a new one
similarly-
for these
Who
arguments.
are
Um,
not being testifying, right?
Yeah,
I don't want to
put
say
this guy on the
dishonest,
stand
but
to argue
inaccurate
that it's
argument.
fair and accurate.
Simply trying to keep out these
I'm glad you
enlarged or cleaned up images that show that their client is lying. He pointed a gun before Joseph Rosenbaum chased him. And this is a rebuttal. This is rebuttal evidence. This is based on someone trained in this area who uses software that is certified in this
He's
area.
not trained.
He's definitely not
He's
He
trained in
certified.
this
doesn't
area.
understand how it works.
This is what these forensic image specialists do. And it's peer reviewed by other forensic images, which frankly, Dr. Black's was not. And so this is actually a much higher standard than the
His
evidence
argument
that
is
Dr.
trust the
Black got in.
science.
I understand we didn't object.
We don't know
But
what the science is. but
For them
trust the science.
to have an expert come in, use a very similar software to do similar things, and then try to pretend this is all voodoo magic is preposterous. And
Well,
I,
wait a minute. A couple of things. Number one.
Oh no! Okay.
You know, this happens sometimes. Lawyers sit there during the trial and all kinds of stuff comes in and out, and there's no objection raised. And then when there is an objection raised, the party says, well, this went on before in the trial and it was admitted. And I think, okay, but there wasn't an objection. So it was never scrutinized by the court.
State's done it twice.
It just came in. That's number one. Number two, you're the proponent of the evidence. You have the burden of proof. They
Yup.
don't have to disprove the accuracy of it. You have to prove it. Number three, the witness was just here, and when he's asked, what does it depict in terms of whether the color is going to change or to what color, he says, I don't know. Now, this is the person who is providing your information to support your claim that it is an accurate depiction.
Not
I
looking
will
good
tell
for
you.
the
Basically,
prosecution.
you fucked up.
Totally
Nope.
agree with your comment about my lack of familiarity with these concepts. Although logic, I have some logical skills, and when you start adding, if I take this piece of paper and I start drawing squares on it, and and then I decide I'm going to put it on a bigger piece of paper, and I want to expand them, but I do it by
Judge knows way
creating
more
even
than he
more
lets on.
squares, and I don't know what's going to go into those other squares. I mean, this is difficult a concept for me. Yes, you know, the fact that I can blow something up on my phone, and it's accurate on my phone, doesn't mean that the particular program used by the crime lab is doing an accurate job of increasing the size of the image.
Well, this is an accredited lab using software.
What does that mean to me?
Yeah,
What does that mean to me?
Damn
What does
straight.
peer reviewed mean to me?
Damn straight.
You haven't presented any evidence as to the science or as
This has
to
been
the
phenomenal lawyering by the defense.
Yes.
Absolutely amazing.
algorithm that's involved.
And the judge is on the right
You
track.
know,
Yeah, he
no,
is.
Just get to the end of the page.
I want to
The
see
judge
the
is just repeating defense attorney's.
Wait,
Let's take a look.
He wants to see
Not
the
that my
images.
naked eye is going to be necessarily capable of making the distinction that I need to make, but you've got the burden here, so you
No, I understand.
present the images, I'll take a look at them.
Would you like them on the printed out paper? Or would you like them on the screen?
How are you going to show the jury?
We have
Look
two
at
of
him.
them marked,
Well,
or we can
let's,
put them on the
let's have a
screen.
look. Show me the paper.
When the judge is repeating the defense counsel's argument, that means defense counsel did a phenomenal job.
Big boy is
repeating
so
verbatim.
butthurt right now.
He's
just,
angry. Yeah.
He's stinging.
He's like,
I wonder-
I'm getting my ass whipped.
I wonder if he's just looking at them just to calm him down. I also wonder if at this point they're starting to throw barbs at the judge to try to rile him up to see if he can get angry and start yelling again so that they can win in the court of public opinion. I don't know. This is
Yeah,
bad.
I
agree
think
with you.
I think he's
So
just
that's
mad as
back
hell,
and
and
forth,
he's just
Yeah.
lashing out. He's losing, and he's not gaining any ground back.
Well,
But, I mean,
think
obviously
he
at this
just
point he's-
embarrassed himself, and
Yeah,
he's angry because of that.
Yeah, true. But you know, he also has seen just how well it's worked for his co-counsel when he's lashed
Yeah,
out
you
at the
better put
judge.
them up. I can't make anything out of these at all.
So yeah, no.
Please put up
Just
the-
no. Say no.
You know, it's funny. I've been in front of judges where literally all the government lawyer would have had to say is he's accredited, and they'd let it in. I mean,
No doubt.
It's fine.
Here's the
Again,
problem.
this judge is one of the reasons this trial might work out for this kid.
Now, what is this depicting?
Well, just they got a fair judge. Is what they got.
This is
Yeah.
Yes, it's fair.
image from the drone video.
Show it, please.
It's the exact area where Mr. Rittenhouse looked and denied that is him holding his weapon, pointing it at.
Look at that
Ziminski.
squint.
Okay, now you tell me, where's Zeminski? Where's the defendant? Where's?
Zeminski is off screen because we asked it to be cropped.
If you can't
The
tell,
defendant-
Judge,
Zeminski is, I believe, off screen. The defendant is right under the sign, right in front of what would be the pole holding up the sign. And right next to him is the fire extinguisher that, as opposed to his actual testimony, is seen on the drone video gently placing on the ground. He then immediately raises up and raises his firearm and points it at the Zeminskis. The defendant denied this even after watching the drone video. This is a blown up image, which obviously
He
it's
said
blurry
enhanced.
because it is
Caught
blown
himself.
up.
Yeah, that was very
You
close.
can see the
see now, a good strategy for
Black
defense would be just
firearm
interrupt him with
being held
anything right now. Just
in
anything to
his
interrupt
hands,
his
albeit
flow of
it
his
is blurry.
presentation right now.
Yeah.
Just yell
Shoot it.
loud noises.
If you'd like to see
Your
the
shoelaces
video on this camera,
untied.
we can show that to you as well.
Let's have that.
Have that up.
Yep.
Number 82, please.
Brian, 82.
And the ridiculous thing is when you have a still photo also, it's so confusing as far as the angle that he's holding the gun, whether it's even in his direction. They spent 45 minutes where they were claiming that Kyle was pointing a gun toward Gaige when from a still photo on a weird angle, when if you actually looked at that same moment from any other angle, it's clear that he's pointing towards the sidewalk and not towards Gaige. So now they want to do the exact same crap with saying that he was threatening Rosenbaum because in this little thing a mile away.
You can't complain about them. How you been?
It's clear on the 4K TV, which is the one that
Remember
affects
that
brought
on
in,
my
but
screen, Kyle's
the,
like
the
this
area where
big
that enhances
on theirs
is
on the.
as the video begins.
This way.
Look at how tiny. Actually,
As
he's
the
like
video
this big.
begins,
Look at how
if you
tiny
look
this
under
is.
that sign, you will see the defendant step into view. He gently places his fire extinguisher on the ground.
He didn't gently put his.
He dropped
And then he raises up and points his weapon at the Zeminski, who I believe you can see once this light traffic light's out of the way.
Gee, wouldn't you want to have Zeminski there to testify about that?
That's
Wouldn't
the
he be
objection
perf-
right here. Objection, Your Honor. Why wouldn't we have Zeminski testify about this? They're going to be faced with the problem of the judge is like, I can't see anything that you're talking about.
I honestly still cannot pick out where they're saying Kyle is.
There are so many videos of this moment from different angles, and this is the only one that they think they can interpret it that way, which means that if you look at it from any other angle, it's clear that he's not pointing towards them, and that this is designed to confuse the jury and make them think that Kyle was intentionally trying to threaten them. This is a BS tactic to spread falsehood to the jury.
The judge is going to be like, I don't see anything. Maybe he won't, but.
Which ant are you saying is attacking the other ant?
The judge is going down to the 4K TV to try and see this. That's how bad this is for the like how desperate they are to get this picture into evidence. Because like Joe just said, there are tons of video of this moment, and none of them show anything even remotely close to this.
I don't see it.
I don't even see Kyle.
Yeah. Oh, he's up there by the.
I thought.
Are
it
you
was the
fucking
block
kidding me?
Next to that.
I thought it was in the intersection.
This insanity.
Not only
Oh,
is
no,
it
they're way away from the intersection.
Not only is it the
Yeah.
furthest thing
That was
away.
like 30 pixels on this screen.
And that's when it's more
And his
dangerous.
gun is
to
like a
expand
pixel and a half.
because you're expanding less pixels.
This is also probably upscaled by the TV already.
Yes.
This is a 4K TV and an 844p image.
So angry.
The judge is like, how can you possibly show this to a jury and expect them to take the conclusion that the state is testifying to?
Yeah, who's going to testify about this?
The guy who cut the video was going to, the expert.
Ridiculous.
That's
the
who they
expert.
questioned about it. That's the only guy they've asked this about.
So
Right.
insanity.
No, because what I was trying to say earlier is that this is the guy that introduced this video previously, but I don't think they anticipated that they were going to have to get into this level of detail to do the zoom in. And so they tried at the last minute when the judge said, no, you need an expert to bring this in and talk about it to make it reliable. And they tried to I would assume that they were trying to find someone at the last minute and couldn't find anyone. And we're like, well,
Let me put it this way. On the pixels available on this image on this stream, I see the price tag on the back of Lunchbox's jacket. Right here. That is my opinion, based on some very small upscaled images. How the hell are they expecting the judge to go, yes, that's the right person, and yes, he was pointing a gun? Are they serious?
you're our guy. Come on in.
Glasses
The guy works
on
for an
and
accredited crime lab. Why can't he explain interpolation on the
What
stand?
I'm going to do is allow it and
No. What?
What?
Oh my God!
No.
Hang on.
Oh
the-
yeah, you see,
you
you
can-
all
you
love
can
him so much.
You can cross-examine him in front of the jury. Also, guys, we're all hold on. We're all squinting at this, trying to figure out where the hell Kyle is in this video. The jury's going to have the same problem.
Yeah, but here we go.
No, he will not be doing that.
Okay.
Sure, Feesy's going to do the exact same thing.
Yeah.
But no, but for anyone who thinks the judge is biased,
yeah,
this is prejudicial. I mean, it can be, because they're going to testify. The attorneys are going to testify that this is Kyle raising his gun without a single eyewitness, without anybody who can authenticate this video. That's what they're going to testify to.
Dozens of people were there from different angles, and not one of them saw it. But the attorneys there, they see this tiny little 12 pixels of Kyle and a pixel and a half of his gun, and they know exactly what's happening. One freeze
frame. We're just made aware of a couple issues with the defendant's testimony. We believe we could potentially get a witness here this afternoon to rebut it. We were just made aware of it. So we may, at the end of this, be asking to keep the rebuttal open.
Surprise rebuttal witness?
Oh, shit.
Well, we're working to see if we can get a witness. It'd be a person from the Grays Lake Police Department to
who'd you coach?
rebut the fact that Mr. Rittenhouse was issued a bulletproof vest by them. They indicate they did not issue him one. Also, I can't imagine we find someone, but the Arizona State or whatever university the defendant claims to be attending says he is not enrolled there and is not going to college there. I don't imagine we get a witness for that, but we, of course, will work on that.
First of all, what's the relevance of that?
Credibility.
Yeah, credibility is always an issue.
Yeah.
Rebuttal. All right, are we ready for the jury?
Yes.
Okay. Come down, please.
That decision by the judge is probably the most frustrating he's made so far to me, because there is no foundation for this photo.
Right.
Their expert completely waffled on the stand, cannot explain any of the methods, despite the fact that the defense's witness just did explain those methods, and now this photo is going to be let in.
Foundation for admission of evidence of a picture, an image, is always that it must be a fair and accurate depiction of what it's purporting to show. And nobody knows if it is. The guy who's testifying, their expert, says, I don't know if it's a fair and accurate depiction. He just didn't use those words. He said, I don't know if it's blue, I don't know if it's purple, I don't know what they're going to do with it, which is a peer-reviewed thing. That's ridiculous. So nobody can swear it's a fair and accurate depiction, which means as a matter of law, it is an exhibit that should never be admitted for the jury to witness. This is, to me, appealable error.
And importantly, merely expanding a photo is not the issue here, because you can expand a photo and have it not matter at all. But when you're expanding this tiny pixelated area and blowing it up and then saying that he's pointing a gun at someone, invoking provocation to potentially remove the self-defense claim, this suddenly becomes a hinge point on the entire trial. And if that algorithm added color that wasn't otherwise there and basically makes a representation that he moved a rifle in a way that he did not do, he can be guilty of something that no one that the state has brought or the defense has brought has actually testified to him doing. And there is someone available who could.
Exhibit 142 and 140, and we would rest.
All right, any objection to 142 and 140?
Subject to final review of 142, no.
All right, received. Did you wish to present rebuttal?
Yes, the state would call James Armstrong to the stand.
I think you get the expert up there and you ask him, first of all, you ask him the same questions. Then you ask him, were you there that night? Were you there that night? Did you see him do this? How are you going to lay the foundation?
Ask him the same questions about the pixels. Ask him the same questions about the pixels and what's inserted in there and why.
It'd be really interesting if he changes his answers.
You're still under oath.
Yeah.
Welcome back, Mr. Armstrong.
Thank you.
You testified a few days ago about some videos from a drone footage that were entered into evidence?
Yes.
Did you do any additional work on that drone footage?
Yes, it was requested that I enhance a person near a vehicle underneath the sign.
So I got my crayons.
And how did you go about doing that?
I took two different approaches. The first one, I frame averaged, which means that I selected a group of frames. From there, frame average. From there, I frame averaged those, stabilized first, then frame average. From there, went through and clarified it, which just means that we're using levels, we just brightened it up, and then enlarged it.
And these practices you talked about, are these standards in the forensic imaging world?
They are, yes.
And so are these accepted practices in forensic imaging?
They are.
The software you used, is it accepted software program in forensic imaging?
Yes.
And was your work on these images did it go through the peer review process?
I went through a peer review process by another qualified analyst.
And did you write this software?
I did not write this software.
And this enlargement, does it use any kind of computer programs or systems to make the enlargement?
Yes, it uses an algorithm to enlarge that image.
And what kind of process or algorithm was used for the image with the individual under the sign?
For the image underneath the sign, the image that is on towards the left, a smart resize, and then the image on the right was by cubic.
And are these accepted procedures in forensic imaging?
Yes. Yes, that's correct.
And did you write the algorithms that do these procedures?
I did not, no.
So do you know the actual specifics of how the algorithms work?
I do not know.
But they're part of a software program that is accepted in use in forensic imaging.
Yes, that's correct.
Sorry, just quickly, someone sent through a super chat there. What would I have done in this situation? I'll be perfectly honest, I don't feel like... Okay, for Kraus, I don't believe I would have been put in that situation because, simply put, it's fairly freaking easy to substantiate the photos and actually have it properly sorted out. If I was in the defense's position, I absolutely would have been hammering home on the fact that this guy couldn't prove that they were fair and accurate depictions. Yeah, 1 minute in Photoshop. But, I mean, trying to bring in this drone footage would have had objections all over the place. I mean, there's... It's really annoying that the judges even let that in, to be perfectly honest. But, I mean, in the situation, all you can really do is roll with the punches that the judge has thrown at you. And hopefully they get another crack at this guy and can actually hammer home that he doesn't really seem to be qualified in exactly what he's saying. And I want to know, A, exactly why they haven't brought in Zeminski. I mean, obviously that's detrimental to the prosecution's case, but if he's the one that could testify that Kyle pointed the gun supposedly from his left hand while carrying it, anyway, doesn't matter. Maybe I should ask the expert to talk about the code written to enhance the images beyond pixels. Well, you'd probably have to get someone in from the actual company, basically, which I think is really the main thing that Kraus should have done. As stupid as it sounds, is get someone in. Because people from those companies do exist. You can get experts in from a specific company for software that you're using in order to actually discuss algorithms and discuss the way that it can be an accurate depiction. This, to me, just seems like they're underprepared, to be perfectly honest. I think this was an argument that they weren't expecting. And the whole thing about it being, oh, you know, if you reject this, then we have to reject all digital pictures going forward and all that sort of stuff. That was complete bullshit. Because you're talking about an enhancement of very grainy footage. But anyway, thank you very much for the super chat. And I just saw another one's coming from Lady Flux. Hello, Flux. How you doing? Leighton Gay. Yeah. Well, we knew this.
Leading.
It is, but I don't know that he's going to get the witness to grasp an answer that he wouldn't otherwise make, so the objection's overruled.
That's okay. Object to Krause every chance you get, because this guy gets pissed off.
Phil down the
Real
bottom
fast.
taking a phone call.
Angry.
Look at this.
What is the software that you used?
It's called Amped 5.
Binger's like, I'm sorry, I wasn't paying attention. I was revising my resume.
Software program called Input Ace. Is that a similar software program, to the best of your knowledge, to Amped 5?
To the best of my knowledge, yes.
But was it the software that was used? No. It's irrelevant. Move the fuck on, Klaus.
To the best of your knowledge, did the crime lab have to choose between those two as to which software they would use?
Yes, the Amp 5 was chosen.
Were you part of that process?
How much you want to bet that both of them were used?
Recommendation.
And Amp 5 was the one that showed the more
my choice, yes.
supportive results for them.
Sorry?
That was my choice. Overall,
I think you said it was your choice.
It was my recommendation to our technical unit leader it was my recommendation to our technical unit leader for my preference of software between the two.
I'll let you what's in March as States Exhibit 155. Do you recognize this?
Yes, that appears to be the report print that I created. A report print?
And this report print has 2 images on it.
That is correct.
And is it a true and accurate representation of the report you created?
Oh yeah, that's a true and accurate
And
representation.
you said there were some differences between the algorithms used on the images.
Yes, that is correct.
And what is the difference?
The difference being is that with regards to the clarification techniques on the image on the left, that was frame averaging. The image on the right, the difference being is that just a single frame was used.
And I put a piece of paper down in front of you. Do you mind flipping that over? What's the number on top of that one?
Exhibit S156.
Do you recognize that?
Yes, that is report print number 2.
And what is report print number 2?
Report print number 2 is clarified and enlarged files or images that I produced.
And where were where were you looking to enhance these images from?
We were looking to enhance the the area where 2 individuals are observed.
And so this is a different part of the drone video than the first exhibit.
That is correct.
What did you do to produce these images?
To produce these images, I just, again, clarified. So I use levels to brighten it up and then also to enlarge as well.
And all the procedures you used standard and accepted in forensic imaging?
Yes, that is correct.
You actually created 6 more reports as well?
Correct, yes.
And just to not go through every one, were they all created with standards of forensic imaging?
Yes, that is correct.
You reviewed them and you know that the ones that the state's submitting are the ones that you submitted to us?
That is correct.
At this point, I would like to move all 8 into evidence and publish 155 and 156 to the jury.
all right. Well, they're admitted, subject to the cross-examination.
How do you admit something subject to cross?
Not yet.
Okay. I have no further questions.
I don't know, but an appeals court might get to find out.
That's a weird way to do. How do you admit something subject to cross? Like the jury's going to determine we don't want to see this?
They're going to bring out the, what is it, that memory eraser from Men in Black.
Neuralizer.
There we go.
Neuralizer, yeah.
It's funny. I've never heard that. It was subject to a cross. I mean, that would be.
Yeah.
What is it that you're going to challenge You're going to challenge the veracity of the evidence? That goes to weight, not admissibility.
Yeah, it's either admitted or it's not.
I'd like to neuralize everything I learned about lawyering from these people. That'd be great.
Oh, don't worry. You didn't learn anything about lawyering from these people.
We may have picked up some bad habits, right?
Yeah, that's right.
Well,
Negative
no,
information. I'm
Jurafe's
worse
been
off.
amazing.
I'm just going to start saying it's an accredited institution.
It was peer reviewed, presumably like by a person like myself who would be a peer, who also doesn't know anything, like me.
Somebody else in our office.
Nick Rakita peer reviewed my legal arguments, so they have to be 100% right.
That's
So,
right.
okay,
terms of
I'm a
your,
cruel mistress.
Enlarging this image. From the information that's been provided to us, you did that through a bicubic interpolation program. Is that right?
I provided that through a smart resize and also by cubic, depending upon the image that you're referring to.
Okay, and
This sucks
when
when,
you're
you've
making
already made your speech and have to make it again.
Yeah, and then you forget all the key bits because you already, or you repeat yourself too many times.
In New York, when a judge admits evidence, you have to object to preserve it for appeal.
This is cheese land, not New York, Joe.
I hope they didn't just screw up their appeal by failing to object to the admission.
Well, he didn't admit. He didn't admit it.
Fully
So
admit.
there's color involved, right?
That is correct.
Okay, so if these pixels are
I actually kind of like that he just did that because we were able to see it. This time we're not able to see it since it's pointed for the jury.
are red, when you're expanding the image, you're adding pixels, correct?
You are adding pixels, yes.
You don't know when you're adding and enlarging that and adding pixels. You don't know what color you're adding to these pixels. Is that right?
I do not know the interpolation, the algorithm what it exactly is doing when it's adding those pixels.
There are
the
programs,
goddamn pen is blue.
programs that will just default it blue.
Someone made a good point in the super chat.
I
just
do not
now.
know.
That motion adds to the blur even more. It makes it that much harder for it to be accurate.
Programs that would take the blue pixel and the red pixel, combine them, and make a color purple when it's actually not purple.
Kudos
I
to
do
the
not know.
interpreter for that.
Does it change? So here's the question I have. So
This guy shouldn't even be on the stand. He doesn't know.
and you expand it and blow it up, it's going to add pixels, so it might change. The pixels could become white for the color of my shirt or black for the color of my tie, correct?
It's going to be sampling the pixels that from your example. And
Yes or no?
And calculating those pixels out and then duplicating those pixels into that image.
What was your answer?
I'm sorry, could you repeat your question?
And the judge is like, it's a yes or no question.
Taken a still photograph, right?
Yes.
Blown it up and added pixels to that photograph.
That is correct.
Okay. Those pixels have to contain or do contain information, right?
That is correct.
Some of that information is color, correct?
That is correct.
Okay, so if the best example I would give you is if you take a picture of my chest, my shirt, and you blow it up, you're going to be adding pixels around my shirt and my tie, correct?
The,
Yes,
the
that is
music is
correct.
me. I can't turn it off.
So mute.
I can mute myself. That's all I can do.
You don't know whether those pixels are black for my tie or white for my shirt, right?
I cannot speak to the algorithm that's being used and how it's interpreting it.
And that, to be fair, that could distort or not make an accurate picture of what we're seeing, right?
It's possible.
Right. So the images, and when we're looking at smaller images that are blown up, adding color that's not actually there can make the photograph not accurate, right?
But all the steps that were taken are repeatable.
Answer the question.
So what does that have to do with the fact that you don't know what the colors are added? You don't know the colors that are added. So how do you know that's accurate?
I do not know to the algorithm and how it's using it.
So when we're doing that on small images, like a marker in my hand or something like that, and you want to see what this is from a far distance away, it might be adding color that's not actually there. Right?
It may be.
So the image that we're asking people to look at might not actually be an accurate representation of the original image. True?
It's possible.
Okay, this is all baffling because
Boom, right there is where it can't be admitted.
Would it take something that was present? So the example I gave you was, if you expand that, is it going to add more black pixels?
It will add, no, it will not add any more detail than what is originally there.
But it's going to add pixels. You just don't know what color.
Correct.
Is it more difficult to do that in situations where you're further away, meaning the distance from the photograph? The further the distance from the photograph, the more difficult it is, or the more pixels that need to be added to blow it up, right?
Saying more distant from the photograph, you mean the object depicted?
Sorry, yep. So the object depicted in the photograph, the further away that is, the more pixels need to be added when you enlarge.
Well, the
right?
judge is
Correct,
paying
if you wanted
attention.
to enlarge it, yes.
And the more pixels that are added, the more availability there is for distortion in terms of the color in those pixels, correct?
In terms of the color, it's possible.
And would that be also true? Would that be true for the size? I think I asked you this, but I'm trying to figure this out. The size of the image that you're trying to make larger. So the bigger the image in the photograph, the easier it is to enlarge.
There's more information. There's more pixels that are present to enlarge in that area.
Holy crap! This guy just can't answer yes to save his life.
So if I, for example, was if I had something on my clothing and you enlarged it, would that make the thing on my clothing more pronounced?
It may not. No,
Would it make it less pronounced?
it may not.
But it might do.
Even though the photograph is bigger.
It does not. Interpolation does not add detail. So if you are enlarging something on your clothing, all it's doing is making that image larger. The detail that may or may not be there is not added. You're not adding additional detail to that image.
You're just adding unknown information.
Yes. No, you're not adding unknown information. You're adding. You're interpolating those pixels, and you're adding those particular pixels.
Right, and those pixels contain information.
Yes.
And that information.
I need to get that as a sound effect.
You're not
Truck
sure
reversing.
whether or not how that color would work in this situation, right?
I do not know.
Okay.
The computer tells me what to do. Unfortunately, that argument might work.
Yeah. No. How did this guy get qualified as an expert?
Mr.
He didn't, I think, right?
No, they should have had a separate Dober hearing on this guy.
Yeah.
Do these programs add detail?
These programs do not add detail.
And how long did you work with this
How can
drone
he say
video,
that?
all told?
All told, I received it on Sunday, and I finished all my work with regards to these requests as of yesterday.
So you worked on it for more than 3 days?
Correct.
Would you have submitted a exhibit that did not seem to be consistent with the original footage?
Yeah.
And foundational.
It is argumentative.
Good objection.
Yeah.
Did you make sure that the
whole point of this is he can't actually know.
if the reports that you identified were not consistent with the drone footage that you become familiar with, would you have produced them?
Objection.
I would not have produced them if there was any information there that did not seem accurate to me.
So you do compare it to the original?
I did not compare it
So
to
what
the original
report
in this
contained the
instance,
fact that he raised a gun that you used as a basis for comparison?
The report of the guy they're not bringing to
Sampling
testify.
that you talk about.
The bicubic and smart resize.
Yes.
Those are two different algorithms that use.
This
to
dude has a low
interpolate
tide
that
wave.
information.
So do these algorithms look at, so let me ask this way. On a digital photograph, to make it bigger, do you have to add pixels?
You do have to add pixels, yes.
So if I take a photo from my phone and I want it on a 5x7, I'd be adding pixels to it.
You would be.
No, you would
So
not.
this is something that's commonly done to photographs.
It is, yes.
That's actually
Now,
not true at all.
These algorithms, how do they know, the best of your knowledge, how to add the pixels?
To my best of my knowledge, it depends on the algorithm, and that's the extent of my expertise on that.
So what is the sampling process?
Nothing.
Sampling
What is he
process
on?
is
Nothing you want to
looking
hear.
at the pixels and providing more data to that file.
So it looks at the pixels and looks at what's around it, and that's how it adds the pixels.
That is correct.
So it's not just arbitrarily choosing colors to put in.
Not to my knowledge.
Nothing further. Thank you.
I mean, that is blatantly
So
untrue
you
on the
never
5x7.
compared The photograph in front of you to the original? That's what you testified to?
I did not compare the original. I did my analysis on that original video, but I didn't compare them side by side. No.
Well, you
I'm
were
getting
asked
messages
to
from
submit it
tech knowledgeable
because
people
you
who are
didn't think
losing
it
their
was a fair
minds.
and accurate
Me
representation
too.
and all that other stuff, right?
Right.
But you never looked at the two of them next to each other to confirm that, right?
To confirm that, to compare the original to the exported file, no.
And I know
How's he
Mr.
representing the-
Cross talked about, you take a photograph of your family or whatever and you make it bigger. Right? You're probably not as concerned in a family photograph that you're adding pixels and where colors are going as you might be in, for example, say,
A motor
Hummer
trail?
right?
That is true.
Okay. So making sure that the information that's added to these pictures, and the information is in the pixels, making sure that's accurate, that's an important part of your responsibilities, correct?
That would be yes.
And you don't know how that happens in this particular case, correct?
I do not know the algorithm that's being used within the software to speak to that. No.
You can't handle the truth.
Oh, I have to.
Good ending right there.
You're gonna redirect.
Just based off the fact that it's a bicubic algorithm is a common algorithm that is used, and it's a sound forensic tool within AMP5.
And how long did you work with this drone video and the different images from it?
Sustained.
You know how many hours you worked on it?
I would say it was approximately approximately 20 hours.
We did a crap job.
You
That's
didn't
20 hours.
compare the final result. You didn't look at the final picture next to the original.
You may step down, sir.
So is this admitted or not? We have no idea.
We have no further rebuttal witnesses.
Any other evidence?
Yeah, I don't like that prior ruling on that.
It's be accepted and published as previously requested.
Any objection?
Yes.
All right. It'll be received and published. Did you have some for publication? Or was that done?
Yeah.
That was completed?
Oh,
Okay.
submitted.
All right, then.
They preserve the objection.
Wow.
The evidence is closed, and I'm going to ask that you return to my, yes, you do. Go ahead.
Can we get the screens up?
Did you?
He wants to show them to the jury, I guess. Is that what he's going to do? Is he going to show the pictures to the jury without a witness present? Is he just going to testify to them?
I guess. This
Is he taking the stand?
wild.
Is this? Are we on close? Like, what are we doing here? What the fuck are
What
we
is
doing
this?
here?
What?
This is exhibit 155.
All of us lean in.
That's the enhanced.
Yes. You can't
Still
see
dog-
anything from that.
Still dog shit.
Now, please exhibit 156.
You can actually see added pixels, by the way, in the 150 in the left side picture. You can see more black across Kyle's chest strap. What the hell is happening?
Steve is now calling crows to the stand.
What the hell are we looking at? This looks like a car accident.
Oh, this is the shooting of Rosenbaum, maybe?
This is the frame averaging picture that he was talking about, where they actually merged two frames that were separate into one, which, I mean, they didn't even hit on that, but you're literally having a computer guess at what should have happened between two moments in time.
That's all. Thank you.
These might as well be Rorschachs.
All right.
What the fuck
All right,
just
folks, the
happened?
evidence is
Like,
closed,
procedurally.
and you know what? I
Showed him
want
the
to talk
pictures.
to you lawyers for a moment. I guess I'll ask you to step into the library for just a
I don't know if you can find two in this room.
Seriously. Sheriff, you seeing who?
Please do.
Kyle?
So they just put the photos up, I guess. That
Yeah.
I mean, you know what? Frankly, I'll take that over them
There's no
having
testimony.
the enhanced
testimony.
guy testimony. Yeah, testify. Although
Why are
still,
you looking so happy, Richards?
I don't think that they actually said he's waving a gun at them in this picture. So I don't know if I think the jury's gonna look at that and say we have no
He's
idea.
going
what
to say
to
it
do
on
with that.
close.
Yeah,
Yeah,
he's gonna
but
say it
like
on
they'll be like,
close.
yeah, okay. I
Sure.
don't remember seeing that anywhere.
Sure, but I mean, keep in mind though, if those photos look completely grainy and incomprehensible to us, it probably will look the same to the jury.
Oh yeah.
We're all much closer to our screens than the jury is to that TV.
Yeah.
But still, like, this is just a baffling rule. Well, it's subject to cross-examination. What?
Yeah,
What do
I
you
don't-
mean?
All right, now you have driven me into submission with your request to argue on Monday, but I'm going to extract something in exchange, which is a cap on the length of your arguments.
Oh.
I figure, well, first of all, we're going to do a more involved discussion on instructions and verdicts. Are there going to be any charges submitted to the jury other than what is in the information? Yes?
The state will ask for that, yes.
How many additional charges are you going to submit? Or request to submit?
I'm not sure if we finalized our request. Certainly on count 3 and 4. I think we've discussed on other counts, but the first degree homicide, first degree intentional homicide, we will ask for all lesser included. The attempted homicide to Gaige Grosskreutz, we would ask for the, I believe it's only one lesser included. We are not inclined to ask for lesser included on the reckless endangering safety charges. At this moment, we're not inclined to ask for lesser included on count 1 to Mr. Rosenbaum, but I think we need to discuss that more fully.
Okay. Are there going to be any special instructions other than what you've already submitted and the 6th count affirmative defense instruction from either side?
I believe the state will be asking, Yeah, we discussed this more, but I think we'll be asking for the provocation instruction.
What?
Okay, yeah, okay.
Provocation defeats self-defense is the instruction
I know.
they're going to ask for.
Well, the reason I'm asking right now, I'm not going to hold you to this, is that I figure that the instruction probably will take 45 minutes, I would think.
To read them to the jury?
Yeah.
Yes, I would say.
I would say easily.
And so that leaves how much of the day, since you scared me off from tomorrow because you said, well, the jury will be worn out by the time we get there. So I think, well, I don't want to wear them out on Monday either. So if I'm going to be instructing them for 45 minutes or an hour, that takes us to 10, 10:30, 10:15 anyway, 10:30. So maybe if you were going to confine your arguments to maybe an hour and a half apiece, is that reasonable?
Very.
I'd request
Total time,
including rebuttal.
yeah, total time.
The state is going to need 2 hours for our primary and I'd say half an hour for.
Wow.
That means they know they're drowning.
I had the good fortune to
I'll give you half an hour.
be across the street neighbor to living across the street to the late Kenneth Grube, United States District Judge, when I was a lad. And
I love these
Judge
stories.
Grube
Back in the aughts.
is famous for his statement that the brain cannot absorb what the seat cannot endure. And
Give him the rope.
if you don't like that advice,
Give him
President
the
Roosevelt,
rope.
one of the renowned speakers of the 30s and 40s,
Quit coaching him. Let
When
them
I was
screw up.
just in college
Yeah.
at the time,
when asked by his son for
Oh,
some
come on.
advice
He was a
on
toddler
speaking,
at the time.
said, be sincere, be brief, and be seated. And so the message is loud and
what's
Oh,
he say?
come on.
Come
Come
on,
on.
PBS.
clear. Are you saying 2.5?
And they wonder why they're losing viewers to you.
I'm saying that I think that the initial closing may take up to 2 hours. I'm not going to aim. For
They're
2
closing
hours.
first? The state closes
Obviously, I
first?
understand that, but I
Yeah.
wanna
Yes,
have-
and then they get a
And then they get a
rebuttal.
There are a lot of
Because they
videos,
have the burden of
and
proof.
we're going to be showing.
I thought they would go last because they had the
There may
burden
be time
proof.
for
No, that's why they get a
Open
rebuttal.
first, close last.
For 2 hours, but there's going to be time when we're going to need several minutes. I don't even know, probably 30 minutes worth of video that they may be watching at various times, which no one's going to be.
No one's talking.
Yes.
I mean, you're not eating time though.
And I certainly don't want to be in a situation where our allotted time for closings.
PBS, get a better cell
God.
connection.
If they're not articulate enough to wrap up their arguments in an hour and a half, they're gonna be wasting.
Hour and a
anyways.
half.
Yeah.
If they can't
They're
do
gonna
this
zone
in,
everyone out.
You're gonna
do
bore
this
the
in
jury.
45 minutes. I mean,
Yeah.
are you serious?
You got to have a punchier argument than 2 hours if you want to convince a jury.
Yeah.
You propose an hour and a half, for example. We do an hour and 10
We're
minutes
beating
or whatever,
PBS and
save
Fox
20 for
News
rebuttal.
combined.
I can't possibly
Shazam!
budget rebuttal
That's
time,
nuts.
because I don't know what the rebuttal is going to be. So I'd like that. We can put a.
I mean,
cap,
that is fair because he
30
doesn't know
minutes
what's going to
or
come up in the
something
defense
on it,
closing, I guess.
I don't want that to come out of the first closing period of time, and I don't want to be limited. I don't want to have to budget that right now out of that.
Well, I
first
don't want
closing
you to
time.
rule
So
against me, Judge.
Yeah.
if the
Richards
court
has a
is
great expression right now.
inclined to go along with that, then I would propose an hour and a half.
He looks
for
like
our
he's about to take a
primary
turn.
Closing, an hour and a half for defense,
Or just
and a
did.
maximum of 30
Be about as good as his arguments lately.
Well, they won't.
This
They
guy.
won't.
Whatever the time
No.
the court says,
Yeah.
I'll deal with it.
I-
I think an hour and a half is adequate.
This judge like, damn, I was thinking 25 minutes.
Each gets
Wanna watch-
65 seconds. Go.
I agree with you that, and you make a good point about the number of exhibits. And so I'm going to indulge.
You have an hour and a half plus rebuttal. Just do that.
Total time of 2.5 hours each side. But with that, I'm usually pretty permissive when people go a little bit longer than they should. I note it to the jury so that the
Judge hates the jury.
Their own, if they get annoyed, they get annoyed. But I just warn the people. But I'm going to be a little bit tougher, and I may tell you to just sit down in mid-sentence if it keeps going. No, seriously. And I did it to one of your one of the DAs that in the last several sequences and mid-sentence. So 2.5 hours per side, and yours is to allocate as you wish. So we need to come back tomorrow. Tonight, you may send me your proposals for lesser included and any special instructions or the numbers of those you want. Well, let's get the jurors in, then we'll take care of these details.
Oh man. I mean, I can't. Doesn't the Eighth Amendment apply to preventing him from making the jurors listen to Binger for 2.5 straight hours?
Cruel and unusual.
Unusual punishment, yes.
God, what a disaster. Monday's going to be a huge day.
Yeah. 5 hours of closing.
Dumpster fire?
5 hours of this argument, plus we got jury instruction oral arguments. They'll be submitting their jury proposed instructions. The judge will be reviewing those, and then they'll argue about them on Monday, probably.
Yeah.
Guys,
at least 7 hours.
To the chat, there's so many of you still here, 71,000 people. If you are following this trial, and I assume you are, looks like as of tomorrow will not have any action in this trial, but it looks like it will resume on Monday. So I will be posting the link for Monday, and I'll probably put it up over the weekend and let people know that it's there, and I'll make notifications every day. But I think Monday closing arguments is going to be explosive. It's going to be very impactful to what happens with this jury.
Yeah, for sure.
Or are they doing motions tomorrow? If they're doing motions tomorrow, then I'll be here, but I don't know that they actually are.
Apologies to the chat, by the way, and to the panel. I live right across from an open-air music venue.
Okay.
So
Folks,
they're practicing, so I'm sorry about that.
The evidence is closed.
So you left to go yell at them, I assume.
We're going to break
they're
for
supplying.
the weekend at this point. The lawyers and I have some work to do tomorrow, and to get the
I
case
wonder if
ready for
tomorrow's
you
gonna
on
be
Monday,
televised.
and then I'm going to ask that you return it
May not.
on Monday. Even though the evidence is closed, it's still not appropriate for you to discuss anything about the case with anybody, not even with members of your household, not even with other jurors. Even if all 12 of you, all 18 of you are in the same place at the same time, you still can't talk about the case. And when you get back on Monday, you can't talk about the case until you've heard my final instructions regarding our law, which will take, I hope, less than an hour. I think that will be true. I think that probably closer to 45 minutes or even a little less maybe. And then we will hear the arguments of the attorneys, and they have graciously agreed that they will not exceed 2.5 hours in duration each.
Graciously.
And may be less than that. And so it'll take a good share of Monday. And then the case will be then the procedure will be that we'll use that tumbler over there, and we'll draw out names of as many jurors as are necessary to get down to 12. And then that'll be our jury that will go into deliberation. And then what happens after that is up to you. Any questions about this at all? We're in the final stretch. Please follow the instructions. And don't read, watch, or listen to any account of the trial. And enjoy the weekend, and have a wonderful evening.
Don't talk about nothing.
While they're exiting, I'm gonna go exit for the bathroom. I'll be right back.
All right.
And while they're doing that,
All right.
I'm just going to
So,
check whether or not there's anything
It's a good time for you guys to pitch your channels.
You start.
Nope.
Why don't you
good.
tell us? Hi,
Oh, hang on.
I'm Joe Neerman, also known as Good Logic.
Oh, no.
I am
never
a
mind.
fiery.
Alrighty. Well, I guess we shall move to Monday, which was closing arguments. Some of the memes that Nick came up with are great. Alright, where are we? It's panel. There's court.
Instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes. I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time, and when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers, and if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And
You think?
This is so typical of lawyers that we're hidebound. We've always done it this way. And I will tell you that for years I have.
I'm gonna switch to the
I
PBS
have,
feed in just a second
taken
because
out
it's
common
better.
elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it.
Oh, there will be.
To communicate. So that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and may end up having a negative effect. But I'm not going to mess around with a case of this magnitude.
Is he describing the
Right.
reading or the whole trial?
The reading.
Proceed as I've suggested, then we'll go with the long forms every time.
So we are doing it.
We have to count on you to make timely objection.
A little late for timely objections, but
Something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without, there's already plenty of repeating going on. But if I have to do a longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, so you're forewarned.
Oh boy.
He just said the magic words like object or lose it.
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. You had, there's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, well, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well.
Here, just a second. I'm going to switch over to
And
the other. Nothing's happening. 1 second.
I mean, their closings are already going to go for nearly 5 hours, so.
So we're probably not going to get through the closings today, people.
We're debating
Oh, my
jury
goodness.
instructions.
Judge
instead of
seems, I may be projecting or seeing things that are not there, but the judge does seem a little more curt this morning. Not curt, but a little more impatient.
I know
this
what you
morning.
meant.
Hear that again? What?
There.
Don't want that anymore.
They don't want it anymore?
I'm going to withdraw that request simply because of time.
Sorry about that, guys.
Wait a
I wanted
second.
to-
He's withdrawing the request to have the thing read every time. He had a win and
Yes.
he's withdrawing it. That's just great news.
Okay.
But I don't think he was going to
And
convince
he
the
says,
judge on that.
But
okay,
in
because
counts
that's
2
what I'm
and
saying.
3, I gave special instruction only with respect to Mr. McGinnis.
The
because
motion
law
for
is different.
mistrial has been filed today.
And we'll get to that.
Oh, thank God.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
The one that I think is where
Did you say
you've done
jumpsuit man?
attempted first
Yes.
degree
Yes.
with self-defense,
Jump kick man,
attempted
jump kick
second
man.
degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me. On page 27 of the final instructions, it simply says, here are the elements. I didn't see self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me see. On counts, the attempt murder and the murder. On those, that's the pattern instruction. If I had my way, I think that's overly verbose. And we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. And that's on 2 also. And that's right after they've just heard it. So, all right.
Well, my only concern is that the instruction makes it clear that self-defense is an issue for first degree attempt and second degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
did you see that under the reckless endangering safety one, Your Honor? Is that what I'm just making. Is that what you're talking?
That's on the, that's on, excuse me, I'm reading from the court count here.
Is this really the trial to play with novel jury instructions?
Or
I mean,
absent jury
arguably any
instructions.
trial.
We'll go with the TLDR version.
Which is 36 pages.
Oh, God.
Well, didn't he specifically say he didn't include a special instruction on count 5? Now he's looking for it?
All that I know, I didn't
Well,
even read the
he-
instructions on the fish tank when I set that thing up. I don't know who's going to read 30 some odd pages of
See,
jury
if I had
instructions.
set this up, I would have put a,
Oh, it's 37. I've been corrected. Okay.
I'm not gonna say it.
Damn.
He said he included not the full
Yeah, you're right.
instruction, but something, but he just said, yeah, you're right.
It's not in
Well,
5.
maybe I misunderstood what you wanted.
Okay.
Did you want the whole self-defense instruction discussed again, or just the cause? And that if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the
as
whole-
long as they're aware that
the whole
self-defense.
We need the
instruction.
word self-defense in
You're
there
right.
somewhere, Judge.
All right,
Yeah,
I just
please,
misunderstood.
Preferably
please
repeatedly.
instruct them.
jury may
I'd want it.
say
I'd want it repeated every time.
If you
I
are
want
not
the
satisfied,
self-destruction
you have
multiple times.
reasonable doubt.
I think the disagreement is the judge was thinking they wanted him to read out
Yeah, the whole
everything
thing.
about self-defense with every cause, which would have been that would have been a disaster in length.
Oh no, man! I think I
There's
want
not
that pounded in the
clause
jury's head.
about-
I think I want that version, to be honest.
If you are satisfied.
Here's the thing, though.
Yeah, I
Does
think
that
I
version
might
include
be with you.
provocation every time they read out self-defense?
I don't know what the deal on provocation instruction is every time or not.
It is an instruction that's been included for self-defense, so I would assume so. I don't know. It's
I don't know legal mindset.
All right,
Yeah,
so
that's a fair point though. If it comes with that trade-off, then you're right.
Page 27, the fourth line.
yeah.
would
I
be,
think I want the
if you are
one full
satisfied that
instruction
all
and him to
three
say
elements of the crime
self-defense
of
with all the rest of them.
reckless
That's what
endangerment
Daddy wants.
Subject to self-defense. Yep.
have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged in the, as submitted. If you are not so satisfied, then you must find the defendant not guilty. Okay, is that satisfactory?
It's not a joke, and I'm not saying this to be glib. 37 pages. Does anyone
Okay.
reasonably think the jury's going to read it or
One
understand it if they do?
That is a lot of material.
He's gonna read it to them, so no, it's gonna be a horror show.
I'm
It'll
not,
be
sure
like
this, I'm not sure this panel can deal with 37 pages of legal instructions.
So, Judge, and this is more for the record, you've already made, I think, preliminarily, you had talked a little bit about the Richie McGinnis instruction,
Right.
which is on page 8 and 9.
Right.
And the position that I had taken was one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in it. I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because he's the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that.
That's easy to understand, right?
It's confusing as hell. Gives him the absolution.
Clear as mud, and that was great phrasing too, Your Honor.
Can you clarify
This is
that
all
for a
the
jury
same.
of non-lawyers, please?
I was gonna say,
I think it's hard enough.
If
for
he's
lawyers.
justified in shooting Rosenbaum, then he's then he's not going to be guilty of McGinnis. That's what they're saying.
you see, Nate, we need you giving jury. We need Nate giving jury instructions.
Unreasonable and substantial
Because he's the only one who
risk,
explains it. In a
Judge
way that
Nate
they'll comprehend.
says then if the jury can't find that, well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Yeah,
Judge,
that's
do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
On
His
what
conduct
point
in-
do you want that put in?
I just think that makes it clearer. I mean,
Where do you want to put in?
Where
On
did
page
you say?
9.
Yeah.
On page 9, it would be the
yes, because
Right,
the
so
jury
there's
does not get this.
subheading
This
determining
instruction
whether
is
the
way
police were
confusing
reasonable.
on the
I think it's
McGinnis
third or fourth,
charge.
The last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
to Joseph Rosenbaum.
Joseph Rosenbaum.
Good. That's a good
Conduct
addition
did
to
not
that
that's a
create
good
an
add.
instruction.
Reasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Yep.
And
Okay.
just,
Oh,
just for
wow.
the record,
Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, two of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime. That's for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What number, what page is that on?
I'm sorry, 34.
34.
Yeah, they're getting all the way through page 34, right?
And we are asking for the
You
cautionary.
want the word some instead of one?
Or multiple? Yeah, some is
Several?
fine.
How many was it? Two.
A plurality.
More than one.
A baker's dozen.
I like the
Well,
judge's
don't
responses
think
there
that's
because
the
multiple
sort of
does
occurs.
include
There
a
was
bigger
another
number.
witness with convictions, but I don't believe the question was asked. So two.
Mads, for Verdict Watch, people have sent me through some timestamps for various things. I don't intend on watching the entire Verdict Watch. So, guys, if there's anything in particular you think needs to be seen, last call, hit me up on Twitter.
Struggle with it.
And we had proposed the instruction to the court, which I think we took off at 2:45 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 2:45 instruction as relates to his terms.
Oh, that one.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction.
While pre-ordering my lunch.
245? I think it's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming was cropping.
There was no objection then, you see,
I
that's.
understand.
My-
No basis for an objection, and they know that.
I don't know that. Maybe they do, I don't know. I can't read their minds.
Yeah.
He's always saying
calls
they
for
don't
speculation.
what they know and what they're
Program
thinking.
used by a forensic analyst who's trained. This image was peer reviewed. If they want to discuss the proprietary algorithms and how a analyst would
Let
not
'em,
know a
it's boring.
proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence
Junk science.
by attorney.
You should have disqualified the witness.
Right.
Yeah,
There
yeah.
were-
Good point, Nick.
So it sounds like you
Companies,
gave a very strong
pension
instruction on
funds,
it.
Individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well,
Judge
this
doesn't
is,
trust the
what
science.
they rely on, I think that's fine, except when my common
Judge
sense tells me.
saw
well,
his
wait,
own
what's
text
happening here?
messages.
When you get an image that is consistent of I'll say it again. Let's say 2,500 pixels. When you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space.
Yep.
That's a little struggle for me.
Which is
And
why it's
this is
reversible
not
error
being
that you let
used
this in.
to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So
Yeah, he
that's
tried
why
to
I
split the
was-
baby
I
with this
was,
instruction, it sounds like.
The funny
when the
thing
witness
is,
answered,
the
he
state
didn't
should allow them to
know.
split the baby on the
And the
instruction
only
because
reason I just- I
otherwise it
left
could be
here and I
reversible error.
troubled about it. And in the end, I decided, well, wait a minute, we allowed this kind of thing to happen in DWI cases where the officer.
See, I don't think he was ever comfortable with what he
asked, well,
did
how
on
does the
Friday.
Machine work.
Yeah, seems like
You
it.
can just undo it.
Oh, I just am trained how to operate.
That they should be bringing the motion now. Bringing everything from God's crypto.
It has already passed judicial scrutiny, and this method has been judicially determined to be accurate.
He's
Has that been done in
clearly
this?
wavering on
I
this.
don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is.
Contaminate. I like that.
If it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards.
Yep.
Just to clarify to the audience, the Daubert
basing
rule is a 5-part test to
is
determine whether
extremely
evidence is scientifically
A
valid or
segment
not.
of the evidence on something that I'm really queasy about. But as I said when I left here Friday,
It's a Supreme Court
this is the
decision.
jury's case, it's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do.
I'm not sure that the guy knows more than the judge.
No, he definitely doesn't.
Nope.
I don't know how this was done. I don't know about interpolation.
High risk that I think it presents.
I'd just use the app and look at the image.
Okay, what's next?
Two last things, Judge. The court had modified a little bit, count 6, which was the.
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at
Nice.
it. Detective Antaramian was asked
On cross.
if this was a
First
short
question's
barrel
on cross.
rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes,
That is evidence
correct.
enough in itself.
Yes, thank you.
Dismiss it
The
now.
jury can measure it.
Okay.
What?
The jury can measure it.
Is that
You can't.
fair enough?
Can't they
I just
measure it?
didn't-
Can they?
Wait,
when
what?
I looked at it, there
Take
was
judicial
no other
notice.
information that
Can they?
that a reasonable juror could believe that
dismiss
count
it.
3's been met. So
So what are you telling me?
then I'm asking that you take it from them.
Drop the charge.
They're asking
Stop
me
it.
Just measure it right now.
to dismiss the case.
If they measure it, they get the result they want, correct?
Failure to prove.
Yeah.
If it's
Judge,
long
yeah.
enough to not be short barreled, then the
There've
charge will be
been-
dropped based on what's happened so far.
Many
Which is the
discussions
case.
about this
Whip it
count.
out, whip a
I'm not gonna
ruler out.
rehash everything.
I
The
sound like I'm
state
talking about something else.
disagrees with the interpretation. The court.
You already lost on
That's
this.
a question of
The court
law, not
has
fact. That's not for the
established-
jury.
Yes, correct.
We do not believe the jury
It's a terribly
instruction is
written
appropriate.
statute.
We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly
Kraus
raised.
really wants a second bite
We
of the
argued
apple.
about all that on Friday. I'm not going to rehash it.
I see what you
I
did there.
believe it should go
I
to
see
the
what you
jury.
did.
And if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury.
For what? What finding?
We would like standard instruction. Clearly the
Juries
court's not
don't know
gonna
how
do
to
that.
measure barrel length, by the way.
Yeah, that's true.
Yeah.
Up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these defensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I made no bones about that from the beginning. And
just dismiss
there
it,
always
Judge.
was
Yeah,
access to the
seriously.
Court
There's
of
always this
Appeals all
long
along here.
explanation.
Well, I guess that's.
And when he
He's got to make
writes-
he's got to make a
Felix, think of his
record. He's
reasoning,
got to
though.
make a record.
I don't mind the
Yeah.
explanation. I
Yeah.
just don't mind the
Shame
conclusion.
on me.
Half the time he
But,
concludes the opposite way of what he's saying.
I mean, if it's just down to barrel length, I'm not even sure it's a jury question. He's
is.
under 18. What's the length of the barrel?
Ultimately, read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense. But there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Does the
Yes.
statute
Just so
provide
people
how to measure the
understand.
barrel?
Measure it.
Just so people understand, the
Or
motion to dismiss for the
You
complaint
can
was based on
stipulate
probable
that it
cause.
does
That's a
not
lower
meet what
standard.
I've
Now the motion to dismiss is
stated
based
are
on whether they can go to the jury,
requirements.
if the jury can find it to be under reasonable doubt.
Yeah,
So
let's
that's
measure it.
why
Let's
it's
do it right now.
changed.
Take judicial notice. Do it.
Compliance.
That's what he's saying.
But
Yeah.
do they know how
If
to
it-
measure
if
it?
it is-
Does the statute provide the
barrel length
measurements
is less
for
than
how to measure the
16
barrel?
No, Viva, he wants to
It
measure it right
does.
now.
It provides where to go from.
Or an overall length less than 26 inches, then I'll deny the motion. If
Measured
it
from
does not
closed
meet those
breech or
specifications,
bolt
then
face to
this
muzzle.
Defense motion will be granted.
We are not
Great, let's measure it.
disputing that the barrel is appropriate.
Oh,
Is it
well
legal?
then dismiss it.
Then that's it. Game over.
That's it.
Yeah. What do you
Not
do?
a short barreled shotgun or a short barreled rifle. Yes,
Then that's
Dismiss
Okay,
it.
then. Done.
correct.
All right, and then count 6 is dismissed.
Yes.
All right.
Jesus.
There we
That
go.
was his biggest problem.
Win
Boom.
for Team
Finally.
Rittenhouse.
On
Yeah.
November
How-
8th,
Imagine what
we
just
had,
happened there.
addressed a motion
The
to
prosecutor knew it wasn't illegal
a motion for mistrial.
Yes.
and was going to argue
Yeah.
it anyway for a
The
jury.
court had taken that under
The
advisement.
judge
That's
should
right.
be
What I
breathing
did from the
fire
court,
down their necks right now.
Was so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know. I'm
I
assuming.
haven't even seen it.
Okay, I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
Preserving
I
your
will.
appeal. Yeah, preserving your
It's necessary. Okay. Came in this morning. Okay. Okay, anything else?
Were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive
Oh,
that.
by the way, law
I did
Twitter,
receive that.
BTFO, you
Relates to the
bitches.
motion,
I
that's
told
what
you
we
that
want.
law was not valid from the
You
start.
did.
Yes.
Dumbasses.
Yes. Yes, he did. That's right.
You did. You called it right from the beginning.
Half of them aren't even
Overlaw'd
lawyers.
Twitter.
Ricky.
What a stupid way to write
I
a
just
law.
knew there were typical problems. I just wanted to make sure they were ironed out.
I did receive it. Okay. Anything else right now?
Attorney Charles. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the statute.
Right, because they need that for
But
provocation, and they didn't prove it anywhere else.
Under 941.20 is
He never
a
established that he
crime.
did it.
We would like
Oh,
to
that's
point that
question.
out, and we just wanted to preview that. So if there's objection, we can handle it now.
There's no evidence. There's no legitimate evidence.
This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I
This is the
specifically
game right
asked
here.
Detective
This is going to be
Detective
it.
Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked, I asked about it. It's in the record.
You know, the struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs.
Good
Zeminski?
question.
You have a theory that it's pointed in that direction. I agree with that, but the statute's prohibition is pretty explicit, and I'm not sure that the evidence that you have, especially because it's just the, well, not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area in which the firearm was aimed. Even if you see the firearm.
Again, the photograph is
suddenly
perhaps the fifth or sixth most relevant piece of evidence on this topic.
The most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos, I'm not going to go over that again.
Okay.
The defense
Attractive
submitted
testimony
their own
because it's from a
exhibit
detective relying on the video.
FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window, and so there's no real dispute that they are in that area, and that is where
That doesn't mean he's waved at them.
he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate.
Fair enough.
Yes. Thank you.
That's a good place to start.
What about the fact that there's no evidence that he even saw it?
Zero.
Yeah.
Well, but Nate, you're ignoring that a detective watching the video with pinch to zoom saw it. So very.
Yeah. But one problem here, right, is that
brings
they're
up,
saying
you know,
pointing a
it's not
gun is an
usual
unlawful act. There are ways that you can be justified
what
in
is
pointing
the
a gun,
role of
like
Mr.
self-defense, for instance, and we have no
Rosenbaum,
other information as to
assuming
that
the
pixel video
defendant
as to what
violated
the heck's
that
happening on the other side of even where they're
It's the
claiming
very
it's going.
theory that the state has proceeded on in the first
They're
place.
saying exactly what I'm saying.
The defendant was a
Gee, if only we had these Zeminskis to testify about what they saw.
Seems
Now you're
useful.
telling me that would justify Mr. Rosenbaum's actions?
Ooh.
I'm kind of
Yes. How do you get to Rosenbaum even if you pointed at
How would that
Zeminski? That's what he's
justify?
asking.
I mean, what does the jury do with that?
Please fix this. That'd be just great.
I would love it if they talked about the provocation instruction at this
I
point.
don't fully understand the court's question. I would also
What
note that
is the
At that point, Kraus should just go for lunch.
he also pointed the weapon at Mr. Rosenbaum. Before the shooting, while he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased.
Pardon me?
He's being chased by it.
They're going for the provocation. How did Rosenbaum know that he even pointed at anybody else? There's no evidence to that. So
Yeah.
how do you get provocation to Rosenbaum? There's no evidence. Even if the judge is saying, even if you do see him pointing it at Zeminski.
In fact, they should be prohibited from raising and closing arguments
Firearm at another.
because there's no
Not seeing that
evidence on
exact
it.
language anymore,
That's
but,
what they should be asking for. Because otherwise, the DA is going to lie about it.
I'm not seeing it here in the statute, that there'd be a broad enough sweep to capture.
In other words, he's saying that you can't just say he
some
pointed at
wrongfulness
somebody
in
and
just
everybody's
pointing
provoked.
the Firearm towards the west without evidence that it was pointed specifically at or toward another.
Boom!
Do it. Do it.
Bounce it. If this is bounced, it's over.
I'll be so happy.
They need,
If this is bounced, it's over.
If this is bounced, I open up a bottle.
What
This
am I-
is
what am I missing?
Yeah, right. I'm going to
Dangers another safety by the negligent operation or handling of a dangerous weapon. Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a
Well,
crime.
where was the firearm aimed?
you say at the Zeminskis. I didn't hear the Zeminskis come in here and say that.
We don't know what.
Hold on.
Yes, finally.
Yes.
A convenient omission is going to come back to haunt them.
Except for looking at the video, and that's who's over there.
They got
That
nothing
would be the
else.
only
I
other.
mean, pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only other.
I can't say it. I'm not saying it didn't happen. I'm saying
saying you haven't provided evidence to say that it had.
He couldn't even find him in the
telling
picture of
them,
Zeminskis.
something. When I
Hold
don't
on, we
see
might have a
this
big win here.
statutory,
This is gone. It's over.
We're asking for instruction. We just, in our closing, in our arguments, we
Look at
just wanted to
Binger. Look
say
at Binger's face, by the way.
that it's.
I think it
The
would
whole
be okay
argument is
if you
based on
say-
this. That's why.
state what the law says, but you have to be careful because the jury cannot be invited to speculate.
Right.
So I don't want to, there's such a universe of possible statements that could be made, but I don't want to try to, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind, but, so I'm not going to say he can't mention that at all, that it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds.
Drop the provocation.
But why
I don't
can't
think
you
he's going to drop the
direct
instruction.
them to that
They're not dropping the provocation.
Okay.
from
prohibit the
From the jury?
state from saying it was
close.
waived at the
Probably take a
Zeminskis?
break after these.
You were so close.
Oh God, Mark Richards, I hate you.
It'd been a really good
That
time
was
to
the-
renew that provocation
Yes.
objection.
Yes,
Yeah.
that was the entire basis for it, was that he pointed
Yeah.
the gun at the Zeminskis. And
At
So
the
just
very
for
least.
for people, I've gotten a few questions. So count 6 was dismissed. That was the charge of possession of a dangerous weapon by a minor.
Yep.
So so there's no, there can be no allegation that he was not allowed to be carrying the weapon that he was, which is a huge win for him, because that would be a highly prejudicial charge for all of the other, especially in context of the provocation charge.
Yes.
And especially because everyone's been hearing that it was so wrong of him to carry this gun. It was illegal, that he was acting illegally. And now that's off the table. And that whole, anytime you hear from someone ever on the left telling you he was illegally carrying a gun, you say, you're wrong.
Nope.
That's just not true.
And
That's
by the way,
not legally carried.
you could probably have heard Barnes shouting in the distance, because he and a bunch of others, Nick, you as well, have been saying it from the beginning. The crossing state lines was a lie, or was factually incorrect for those who didn't know it was. And now unlawful possession of a firearm, which people have been repeating from day one, is off the table and factually and legally incorrect. So two of the underlying premises of what made the conduct so over the top wrong have now been factually and legally disproven.
Yeah,
Right,
and
the makers remain. So-
they've got to hit the fact that he was not illegally carrying a gun to the jury.
Yes.
Remind the jury, you've been told this whole time that he wasn't allowed to be there because of curfew, that he wasn't allowed to have his gun. We now know, as we've always known, that those were wrong. They were overreaches by the state, and he was legally allowed to be there and was legally allowed to possess his firearm. And guess what? That's probably why no cops even said a word about it all day long. In my opinion, you gotta remind the jury that he was legally allowed to carry that gun as much as possible.
big time. Because if you let it sit, if you just let it sit without more, they're going to draw the wrong conclusions. But if you really hamper you're right. People said he was wrong for being there because of curfew, because of illegal weapon. Both those charges no longer exist. He was allowed to be there. He was allowed to have that firearm. So you have to really hammer home that that's not provocation. If you really make that point home, then my odds of conviction are going to flip back over into the defense's favor. So it depends how well the defense doesn't close. But it was a potentially huge win for the defense if they can really make it work.
But still, that provocation is out there, though, and that's why they really need to hit on the fact that they should have moved to prohibit the state from implying to the jury that at any point that gun was waved at the Zeminskis, because that will be the ultimate crux of what the state wants.
They needed to renew that objection.
I think they're going to object during, if they're smart, they'll object during the
They don't
state's
object
argument
to
if they stray
anything.
to it.
I
object
think
to
they
that.
need to
said
be on
they
their
could do it.
toes. They do.
I want to add something. Correct me if I'm wrong. The judge also indicated that he might still give a limiting instruction as to that freeze frame pinch and zoom video, right? Because of the whole junk
Yes.
science issue.
I think there is a limiting instruction.
Yes,
That's what they were
there is one.
discussing. So it's currently in there.
Yeah,
Okay.
that's in there.
Yeah.
Is it?
That'll be interesting to see what he actually says about it.
People are asking about, and I'll know nothing about this, the idea of malicious prosecution now. If the DA knowingly pursued a criminal charge that they abandon after 2 weeks of trial.
Well, you lose that on the complaint, right? Because the complaint itself was legally sufficient to go to trial, right? So they only the bar is probable cause, right? Do you have probable cause? So
As my memory of the case law serves,
have it.
I think I'm trying to remember if as long as you have one ground, whether or not you can get the malicious prosecution or not for the other grounds. I'm trying to remember the case law.
And you have to remember, they're trying to take a different interpretation of the law. They lost on that. The defense's interpretation was the one that carried the day. So saying, hey, this is how we thought the law was interpreted, they're never going to find malicious prosecution on that.
That's right.
The worst one. The most egregious part to me was the fact that they had no dispute that the gun barrel was length was an issue, and yet they knew, the judge told them on Friday that that was the only issue. They were not disputing it, but they were going to let it go to jury anyway. That was a dick move.
Which is my instructions.
It's bad
I'm going
faith.
to instruct you on the
Bad faith.
principles
Yeah,
of
that's
law,
bad faith, yeah.
which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense.
On the one hand, I'm annoyed that he didn't say
The
that
law
count
of
6 has been
self-defense allows
dismissed.
the defendant to threaten
On the other
or
hand, I'm well aware that
intentionally
would be
use force
prejudicial.
against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts,
There is
not
Manny.
from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was
Order on
necessary
you, member. Thank
to
you very
prevent
much.
or terminate the interference. You may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible,
and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed.
She's still got the cough, but the antibiotics seem to be working. Thanks, Mandy.
Considered or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the
excuse me.
Circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct. If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved, and that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not. The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means
Well, it's more than that. There's 16 of us currently silent.
Death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
These instructions are kind of confusing.
Even for the
It's harder
judge.
when you can't read them.
It is harder when you have to flip through the pages.
People.
Yeah.
Shout out to my Odyssey people. We got 400 people watching over on Odyssey also. Thank you for supporting Alt Tech over there as well.
Viva, I appreciate your ability for that understatement there. That was...
I mean, but the jury's going to have to take away a bottom line here. Even with the reckless endangerment for which McGinnis testified, I think that he didn't feel threatened, that it still can be justified under self-defense. I mean, bottom line, they have to understand.
But actually, they don't, because if they find him justified in Rosenbaum, then even if they find him guilty for the beginning, it's legally inapplicable. Because of the way it is, just they're gonna throw it out.
They should be able to motion for a JNOV on that one. Like the jury just doesn't understand the law. If,
JNOV, for those who don't know,
is judgment notwithstanding a verdict.
Okay.
Yeah.
Which basically means setting aside whatever the jury decided, and the judge acting on his own.
That no reasonable jury could come to the legal conclusion based on the facts that are present.
You know, just like
Extremely rare, but does happen.
From a I won't say kid because he's young, but from an individual who showed up to administer first aid, and all the evidence is putting out fires, administering first aid, and now they're going to say that he had the malicious intent to kill. I don't see any reasonable jury getting there, but even especially with these instructions.
Well, it's Call of Duty, Viva.
Yeah, and I played Duck Hunt growing up, so you know the wanton disregard for duck lives. Hernandez also testified that he did not feel threatened by Rittenhouse as well, correct?
McGinnis,
but did not Hernandez also testify something to that effect? He felt threatened by the mob, by the riot,
Yes.
but not by Rittenhouse.
Maybe, but I would be suspect that the jury believed anything Drew Hernandez said because he came across so overtly biased.
He was a little too willing to give friendly testimony, it seemed.
He was very hostile to the state's questions, like overtly hostile, and I think that came across. I respect him for standing up for what he believed was right, but I think it came across a little bit too brash, in my opinion.
He was a witness that should not have been there. They shouldn't have put him on. It was ridiculous.
Well, they could have tempered him down a little bit because like there's a leitmotif and then there's just robotic repetition of rioters, and he was eager to continually repeat that leitmotif to the point where it became irritating to hear even for those who were on the same side.
Nate, normally I would disagree with you saying he shouldn't have been there because he was necessary to lay foundation for the video, but we learned from the state that he actually wasn't. So I agree with you.
Rules of evidence.
Side, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime.
Oh.
And I also used the word both of the elements.
You got to watch those paragraph
It's actually
breaks.
3. So I apologize for that mistake. And
They're going to be like, we don't know what you said anyway. So
yeah, read them to us again. We're fine.
We'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are
The jury's not allowed energy drinks or coffee at this point, so
that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all 3 of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense.
There you go.
Is that clear?
Nope.
Thanks. Thank you.
Start from the beginning. I wasn't paying
Getting back to
attention.
the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum.
Needs a cough drop.
Coof
The
jokes
fact
in
that
the
the
chat
law
right
may
now.
have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However,
the worst jury instruction.
He is confusing the hell out of this jury.
To me, that sounded like
you must consider the law of
opening
self-defense
a
in
door.
deciding whether
He
the
made that
defendant's
worse.
conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But he does not have a privilege of self-defense as to Richard McGinnis. The
That
law of
doesn't make any
self-defense allows the defendant to threaten or
You would think it should be
intentionally use
lesser
force
than a
against
regular
another
criminal
only if the
reckless.
defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In
So you did wind up
determining
repeating
whether
it
the
at least
defendant's
twice.
beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the
the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now.
Did he just lick his thumb to change the page on his iPhone?
Yeah.
He did say he was bad at that. I mean,
That's weird.
Look, it increases capacitive receptiveness.
You should
Viva.
consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another.
See, that's
The burden
just a
is on the
terrible
state
set
to
of
prove
instructions.
by
That's a
beyond
horrible
the
instruction.
the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life.
Based on the chat, it seems a lot more people are confused now than they more so than they were
You will be
earlier.
asked to consider the privilege of
These are-
self-defense
these are
in deciding whether
torturous
the elements of
instructions.
first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail.
Oh boy.
First degree intentional homicide is defined in the criminal code as
Very
committed by one who causes the death of another human being with the intent to kill that person or another.
Yeah, but Mandy, that's
In
just because
this
I'm still
case,
small
first
enough
degree
that I can't
intentional
engage with the
homicide
chat so
also
much.
requires
I don't think
that
that's
the-
on Nick.
that
I
the
think that's
defendant
just
did not actually believe
something that
the
happens
force
with
used
growth.
was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second degree intentional homicide. If as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, that this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intentional homicide. If you are not so satisfied, then you must
we're
not
still
find
here,
the
boys.
defendant guilty
We're
of
still here.
first-degree
It's okay.
intentional homicide and must consider whether the
You
defendant
missed
is
nothing.
guilty of second-degree intentional homicide
This is also why I usually have graphic text in
as
most of my
defined in the
videos.
criminal code, which is a lesser included offense of the first-degree intentional homicide. There are hierarchies of cases in the law.
Oh, good, a story.
History lesson.
Typically first-degree.
He knows they're bored.
Yeah, trying to break it up.
offense, Then lesser
Oh,
included
Rittenhouse
crimes
Young. That's it.
that are of the
He-
same
headlines.
nature.
Oh, there goes the
many
neck.
common elements, but some differences.
I take
So,
that as a
there's
positive.
sequence
Kyle
of
Rittenhouse yawns
verdicts
over the
that
death
must
of
be
his
submitted
enemies.
to you with respect to this
The
count.
fact he has to explain the
And
jury
that's what we're
instructions
going
within the
through.
jury
So we'll take
instructions
on
is
now
not a positive sign.
The,
Nope.
Juryception.
Yeah,
Let
really.
me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree intentional homicide, you should consider whether the defendant is guilty of second degree intentional homicide.
Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second degree intentional homicide. The third element of second degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent
Is the jury
imminent
even
death or great bodily
alive
harm to
at this
himself.
point?
It does make you think there's got to be a
Judge
better way to
needed
do this.
coffee
This
to get
requires
through
that the
this.
state approved one of the
To be
following.
fair,
What's he on,
this
page
one is
First,
always
five?
that
kinda
a
boring.
reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was.
And look, for the 120 odd of you watching and wondering why the hell we're enduring this, I need personally to hear the jury instructions so that I can understand exactly what the hell happened and what was going on in the mindset, presumably, of the jurors. But we're also trying exactly to do what I just said and put ourselves in the mindset of what the jurors were thinking going into the deliberations. That includes the boringness, but look at it this way, guys. It's Saturday afternoon. If you want to drink, you can. It's Sunday morning for me, so I'm sitting through this with... Anyway.
In danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense
Canadian
of
fever dream?
first-degree
No
reckless
clue.
homicide. However, if after a full and complete consideration of the evidence, you
And Mads, I
conclude that
would, but I
further
don't want to blow my
deliberation would
brains
not
out right now.
result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm.
You should consider the evidence relating to self-defense in deciding whether the
Mimosas
defendant's
doesn't sound too bad, actually.
conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gaige Grosskreutz with intent to kill that person. A crime of attempted first-degree intentional homicide. With respect to this charge, you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into two degrees, there are certain elements that are common to each. Both attempted first and second degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force
Don't
used
be. It's
was
because I
unreasonable.
have a mild level of
The
OCD.
defendant is guilty of attempted first degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilty on a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify finding guilty for attempted first or second degree.
Yeah, if you fell asleep 10 minutes ago, the jury
If
fell
the
asleep
state
15
does not
minutes ago.
satisfy you that those facts
I'm
are
gonna have to get coffee
established
Legal
by
minds
evidence,
that went to bed.
you will be
He'll be
instructed to
back.
find the defendant not guilty.
This is, they have to put
The
this on the
elements of
record.
each crime
though.
will now be defined
So
for
this
you in
way,
greater
on the
detail.
record, it's clear that
Before you may
jury-
find the defendant guilty of attempted first degree
the jury
intentional
was
homicide,
informed
the
of all
state
this
must prove
information before they
by
reached their
evidence which
decision.
satisfies
So
you
they need to
beyond
put
a
this on the
reasonable
record.
doubt that the following three elements were present.
I'll be right back because I've
First,
already
that the
heard this.
defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the
No,
defendant
Mads,
did
you
not
can't
actually
impeach
believe
the
that he was in imminent danger
judge
of
like
death
that,
or great
unfortunately.
bodily harm, or that the defendant did not actually
Much as I'm aware
believe
some
that
people
the
would love
amount of
to.
force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you were satisfied beyond a reasonable doubt that the defendant intended to
Coming
kill
to be
another human
interesting
being,
instructions soon.
and
the
that
ones
his
that are
acts demonstrate unequivocally
especially highlighted,
that
like
the
the
defendant
provocation,
intended to kill and
downward.
would have killed the other, except for the intervention of another person or
Man,
some
he's right.
other
I need the green
extraneous
juice.
factor,
I'll be back.
and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the
Did you guys
defendant is
notice that
guilty
he
of
changed the
attempted
tissue box?
second-degree intentional homicide.
No, the brewer's rum was there. That was always there. There was
Before
another
you may find the
American one
defendant
on the
guilty of
left.
second-degree intentional homicide.
I didn't see that one
The state
before. I
must
only saw
prove
the
by
American
evidence
one.
which satisfies
saw that
you
one
beyond
before.
a reasonable doubt
Hmm.
that the following three elements were present.
It's so boring. You're actually looking around
First,
his
that the defendant
background.
intended to kill another. Second, that he did acts which demonstrate
Wanna know who gave him that,
unequivocally
that
under all
Mickey
the
Mouse pencil.
circumstances that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor.
That's why
The
when
third
you're
element
one of
is
these
that the defendant
attorneys
did not
trying
reasonably
a case,
believe
you also
that
don't want to
he
be
was
dressed
preventing
too
or terminating an unlawful
in
interference
too
with his
complicated
own
of a way,
person,
because that's exactly what
or
the
did
jury's
not
going to do. They're going to
reasonably
start
believe
studying all these
that the force
details
used was necessary to
instead of paying
prevent
attention to what you're saying.
imminent death or great bodily
No
harm to
courtroom
himself.
peacocking.
Exactly.
Ada in the chat says
You have already
26
been
more
instructed on the
pages.
definitions of intent to kill
Do they
and
read these
equivalent
jury
other
instructions
person
or
and
anything
extraneous
similar
factor.
to the jury
The
before
same
the trial
definitions
starts?
apply to your consideration.
He gave a
Attempted
summary
second-degree
of
intentional
the
homicide.
charges.
The third element of attempt
No.
to second degree intentional homicide requires that the defendant did not reasonably believe that he was
My mom texted
preventing
me.
or
She was
terminating
like,
an unlawful
"This sounds
interference
like
with
this
his
feels
own
like a
person,
rosary
or did not
cadence."
reasonably
People are like,
believe
"Yeah,
that
we're
the
all
force
doing
used
our own
was
penance."
necessary to prevent imminent death or great bodily harm to himself.
I was
This
thinking it
requires
was
that the state
catechismal
have
here.
proved any one of the following. First, that the reasonable person in the
I feel
circumstances of the
mostly I feel
defendant
bad for Nick because
would
he
not
has that
have
issue with his
believed that he
fake
was preventing
narcolepsy.
or
I
terminating
don't
an
know
unlawful
how he's
interference
standing up. So
with his own person, or that a reasonable person in the
Well,
circumstances
I certainly
of the
understand needing to
defendant
put this in the
would not have
record, but I don't
believed
know
that he
how
was in
helpful it is
danger
as
of
part of the
great
jury
bodily
process.
harm.
So,
Right.
Or that that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is when a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, you must determine whether the defendant is guilty of the lesser included offense of first-degree reckless.
No, Mandy,
endangerment
those
of
were
safety,
mission
recklessly
taco
endangering safety,
tortilla triangles.
as defined in the criminal code, which is a lesser.
I was hoping that'd be nice.
offense of attempted
I was
first or
wrong.
Second-degree intentional homicide.
Is your cat asleep
First-degree
too?
recklessly endangering safety, as
Yes.
defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm.
No, we have Doritos.
Great bodily harm means.
In fact, I'm waiting for my next
creates a
drinking stream to
substantial
crack out
risk of
my
death, or which causes
2-in-1
permanent
spicy guac
serious-
and chili
serious permanent
Doritos.
disfigurement, or which causes a permanent or protracted loss or impairment.
I'm a
of
cheese supreme guy
function
though.
of any
Oh,
bodily
wait for
member
this.
or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt,
Okay, we got
and
this
that
part.
the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted.
Someone asked if Kyle can
If
get
you are
time
not so
served for
satisfied,
this
then you must
reading.
find the defendant
Sweet Jesus,
We're
you
not in
should.
any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of that,
At what point does
highest
this
degree
start
of crime,
violating their Eighth Amendment rights?
you need not consider lesser
30
included
minutes
offenses.
ago.
If
You need a flow chart. You need a flow chart for this.
did not
You really
commit
do. I was
a
actually
greater
thinking
crime
what they need is
and
check
was
boxes,
acting
if then
lawfully
statements.
in self-defense.
But seriously, this is why most of my videos that are non-live streams have text graphics, is so that people can actually follow along, because law can sometimes be very boring.
Sometimes I tweeted this out.
Is he waiting for the jury to respond?
Yeah, I was like,
Somebody's poking them to wake them up.
It specifically says
he never
taco
mentioned
flavored
provocation.
tortilla triangles.
Is he done?
He mentioned provocation.
He did.
earlier.
Yeah.
I just said
Oh.
I tweeted this out. They should read this to the jury before the trial starts, so the jury can digest the evidence properly, because this would change how they would see the evidence in real time, in my humble opinion.
But you don't know what the charges are going to be though before that.
Yeah,
You
but
wouldn't know
it
what
might
the-
be
you
worth
don't
it
know
anyhow. But
And what's in evidence to sustain the jury instructions?
I don't know.
You think
it
they would
seems like
retain
more-
this information for 2 weeks, Viva? They wouldn't remember this.
I think they would retain enough of it to know what to look for in the evidence being presented to them. Now they have to go and reassess in retrospect, knowing, I agree, they may drop some charges, and so it would be superfluous to read charges that are no longer there. I think it would be value added to jury digestion of evidence.
Someone in the chat, FSX239 says, at Ricada Law, while I respect your efforts in providing the stream, your panel isn't useful on using this trial as a learning experience due to the extreme bias displayed by each lawyer on the panel.
I'm
to
the
which-
most neutral one here. I understand where he's coming from. The rest
Hold
of you
on,
are
wait.
ridiculously-
Finish the chat there, Nick.
No,
Was that it?
that was it. My response was,
Are you fucking kidding me? Okay, I'm going to address this because, let's face it, we've seen it a few times. Every defense attorney is going to be biased in favor of the defendant. As should every individual human being be biased in favor of the defendant during every criminal trial. Because they're supposed to be given every benefit of the doubt. Because that's what innocent until proven guilty means. So, yeah. When you're in the States, you try nacho cheese flavor and compare. We have nacho cheese flavor. Okay. Let me clarify. I went out and bought these because I wanted to try something that I thought might be similar to Taco Bell. I was wrong. I wholeheartedly admit that, okay? We have cheese supreme flavored Doritos, we have nacho cheese flavored Doritos, we have original flavored Doritos that's just salted. We have Doritos, okay, people? I'm sorry that I messed that up. But that's nacho cheese. That's not how outrage thinking works. So, anyway. Take it off solo mode. There we go.
because we're not biased. The facts are biased, but that's my interpretation. I don't know. Does any of you want to say anything about your ridiculous bias?
I will say that accusing someone of bias based on one example is itself biased because you have nothing to compare it to. So one would have to have a consistent pattern of behavior to qualify it as bias and not a one-off.
Yes.
And I can safely say that I've taken positions on other high-profile cases that would contradict any.
Sorry,
perceived
thank you for
bias
correcting me,
in
Solomon.
my
Unless
view of
proven guilty. Thank you.
I'll
Yeah,
confess to a
here's a
strong.
I've been up
challenge.
since 4 a.m. It's currently 8 a.m. I made a mistake. Thank you.
Here's a challenge. How about, in order to support that assertion, you go and take a look at all of our videos on all of our channels and try to find our bias.
There you go. There you go. We all just got one
I
extra
actually like
view per
that.
video.
This would be the same person. This would be the same person who watches my Arbard Arbery coverage and then tell me that I'm a left-wing lunatic, right? And
Yeah,
then watches
right.
this coverage and say I'm a right-wing lunatic. You know, they don't know anything about what they're talking about. And the fact of the matter is, even the left-wing media is saying the same thing we're saying. So it's not like we're
Concern
not
that I
saying
have,
anything different, right?
And I've worked with the instructions all weekend, and we discussed them by email. And then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually.
I don't actually even know who Nancy Pelosi is.
Except in the context of charged offenses.
Like, I know she's somebody,
What I
and
was
that
about
she
to
supposedly
say
has
earlier
huge
is
tits,
that I'm
but
talking
that's about all I know.
Is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example. And they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count one?
This is not great, by the way. He's had to dismiss the jury.
And decide that the elements are there,
Yes.
but they all decide it was privileged under the law of self-defense. They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's what I used to construct these from scratch.
Oh, good. He'll say it separately. This is a
I
good
would
thing.
tell the jury, which I was just
Used
doing
to etch
now,
them into stone.
that, once you have exhausted this, you're done.
Once you
As
establish
opposed to
self-defense,
having
you're
them
done,
needlessly go
and he's
through
free
this lessons if they've
of that
already
charge.
concluded,
That simplifies
and this
things,
is a
which is
case where
not what
this
the
could happen.
prosecution
I'm
wants, but is
saying
the way that it
shorter
should be.
I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of valid self-defense, then they really should not be considering
The lesser includes.
lesser included. Am I right or wrong about that?
You are
So
correct.
if they find
We all agree.
perfect self-defense on the charged count,
Just say self-defense.
they should be told.
You see what this?
Well, the other counts
Yeah,
are not
I'm sorry.
guilty.
I mean, I understand.
The obvious
where the
answer
court's
is yes.
from.
Obviously,
I guess
this
they
should
could
happen.
consider the other ones in 30 seconds and just go down to be not guilty. But
They're so complicated as it is.
Thank you.
I feel,
Yep.
I feel terrible about it.
Mandy, it's worse than that.
It's like that's the way we wanted it.
Grosskreutz
So-
deliberately left
Anyway.
shit out of his complaints on multiple
see what
occasions.
the instruction is telling them that, kind of cryptically. It says if after, it tells them if after a full discussion,
I think what's really going to make things easier to understand is going back and changing it now after having them leave the room.
Yeah, that'll be good.
But it's good
If
in
we
that
could somehow make this another hour, that'll really help.
This is
I'll
this
tell
is
you, I'm
the
happy to do it.
congressional problem, right? Like this is the problem that Congresses have when they name a bill one thing and then they lump in a whole bunch of other stuff, and it's like eventually everybody's
It says,
eyes
however,
glaze
if
over
after a
because
full
it's
and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide. I'm going back to a different count. You should consider whether the defendant is guilty. So it is telling them.
Yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. They all agree the elements are met.
Say it
and there's a
properly,
privilege.
Richards.
You don't go any further.
This is great having it separated.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward. They going.
Where does it use?
Not, don't have to, but prohibited from going forward. That's what they need to be told.
It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide. before considering the offense of first-degree reckless homicide.
That's just
However,
the
if
charge,
after
not the
a full and
defense.
complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So there, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone did deliberately is trying to make things unclear.
That's what lawyers are for. What's funny is you wrote it, right?
Don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count, there's no need to go to the lessons.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count.
I don't think they should include the unanimous statement on
Either way.
self-defense, personally. If you
Then
find
they're
self-defense,
done.
then don't include the lessers.
That makes sense?
Individually.
No, Mr. Binger's having a problem with that, and let's see what he is.
Mr. Binger's having a problem with that.
I don't like
He was
the way I
making
said
Binger
that either.
face.
What's his lapel pin today?
Oh God, the lapel
This
pins.
judge needs to stop reading the news. That's what he needs to stop doing. The judge should have sequestered himself like he asked the jury to do. Because there he just checked himself on Mr. Binger has a problem with that. Oh, I don't like the way I said that. And he looked up pensively like, no, shit, that's going to be in a CNN headline.
I think he meant he didn't like the way he said what he was phrasing as the new jury instructions. Or did he?
No, I think it was his Binger
Think is that-
statement.
I think that's right.
Yeah, I think he.
Yeah, he's regretting the whole
realized.
Asian food comment.
Which you
And just,
shouldn't. If your
Yeah, he
Asian
shouldn't
food
at
is sitting off the harbor in California, you definitely don't want to eat it. It's been there a long time.
Right next to the Oriental rug.
Oh, here we go. Sitting
You
here
did it.
next
You
to-
went there. Very uncouth.
Yeah, Mr.
How about this?
Superhuman over here,
In any
weighing in
count
with his
where-
comments.
In any count where there are multiple verdicts submitted to you, if at
No.
any point in your deliberations you are unanimous either as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
Boom.
The reason I
Okay, and
is because let's take Anthony Huber's counts, for example. If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
What a
Only if
sneaky-
they're not satisfied that it was done in self-defense. If they, for example, if in your example,
This
if they
eliminates the lesser included
discussed it and
altogether.
said, well, sure, the elements of attempt murder are there. And then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say, we don't think it's.
See, I think one of the things that's happening
if they
here
all
is
say
that
we don't
the
think it's
statute itself has, as a mitigating
it's not
circumstance, something that looks a lot like
And what the
self-defense.
jury is
That
being
kicks
told
first
is if
down
you
to
can't
second.
agree,
But there's also a privilege, what I think the
then consider
prosecution
these
keeps referring to
lessers,
as
but I don't
perfect
think it's so clear
self-defense
as it should be.
that gives you the right to do all of these
If
things.
you
That's
are
where
not so
provocation comes in.
satisfied.
I know it.
Um,
That's at the very end.
I think what the court was originally proposing is telling the jury unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on,
So for example,
if you're unanimous on the legal question,
Back that up, Binger.
intentional.
Well, he's
Well, you're
disregarding
right,
the
because it could
self-defense
be an elements
qualifier.
issue.
Yeah, Binger's saying
Maybe the construction.
Binger wants clarification
Jury
that it's
only goes to
self-defense
lesser
only.
included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count, then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But
I
that's
do
not
think
true,
this is
because if
useful
they're
for showing
unanimous on
people how
first-degree
messy this can
intentional
get on the
homicide,
ground.
what they're concluding at that point is that the defendant Either the elements aren't met, or
Oh,
the
hell no.
defendant
I
actually
specifically got into law to get away from meth.
that deadly force was necessary. They would still then have to consider the second-degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
That doesn't make any sense.
How would they find no self-defense on assault, but yes self-defense on murder?
Because he doesn't have to be reasonable for first degree.
Yeah.
He gets kicked out of first degree even if he's
On
unreasonable.
first-degree intentional homicide. They're specifically told
Well, yeah, there, you're right. He's right.
they're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they're certainly correct in what they say. I just think that they're not.
No, I think the prosecution's
clear.
right, but I think it's because Wisconsin's a little weird on these.
Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Can we rewind the tape, please?
Shoot, I'll be right back.
I like the fact that provocation got lost in the middle of those instructions, rather than being highlighted at the end.
It's good we haven't heard it yet, and it's not being repeated over and over again.
Several of us never noticed that it was there.
Chat, let us know if you think Judge Schroeder said, I don't like the way I said that in terms of what he said about Binger or how he phrased the new instructions. Because having watched this now, I think he said, I didn't like the way I said that in terms of how he rephrased the instructions. But I see how Nick might have heard it that way.
Defendant is guilty of the highest degree of crime.
Hang on, let's just clarify this. Audra, yes. So as it turned out, there are at least 2 instances that gave some very clear indication that the court was watching at least one, if not more, of the trial coverage streams. Recovery Addict's stream was specifically heard in the court over the speakers. It's unclear whether or not the judge himself was watching it or if it was someone else in the court and it got played over the audio. Then there is a very, very convincing scene where Recovery Addict actually says on the stream to Schroeder, Judge, if you're watching this, scratch your ear. And then after the mandatory delay between the streaming and then when it goes through, you see Schroeder just go, and everyone loses their mind. I've got no doubt in my mind, though, that they were watching at least Recovery Addict. I believe that there were other individuals that were watching Jeff's and my coverage. But it does go to show we are having an impact on how people view things. So it's just interesting. My only concern was that if someone like Gravely or Binger then use it in the future as a reason to exclude having cameras in the court. So that's why I've always just been very careful about promoting that. But I can't say 100%, but I'm like 99.9999999% sure.
You need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right.
That's what I thought.
Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over.
Yeah, how do you get assault or something from that?
Yeah, what were you saying, Rick?
I think that's correct. Even your suggestion is seductive, Mr. Binger. But
yes, he's always wrapped around.
But see, they're not asked to consider that. That's where I'm having the problem.
I think the judge really is mixing up the mitigating circumstances prong and the privilege prong.
They even make reference to it. I think maybe I read one of the comments. They talk about how we don't have.
Actually see what Binger is saying.
Question. Right off the
But
bat.
I distrust
was
his
the defendant
motives
acting
anyway.
lawfully in self-defense. They answer
That's,
that yes.
that's fair enough.
All done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury? And tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's
Correct.
over.
He should say that.
I understand what
That's right. That's the
perfect
privilege.
self-defense means, but we haven't told the jury what that means.
Tell him that.
We're deviating from the standard instructions here.
So
And
what?
The words perfect self-defense don't have a meaning to ordinary people.
Actually,
Would require
I would
further definition
suggest
from the court, and now
that
we're
Binger
going
does not
much
know what
further
perfect
afield.
self-defense means.
I also have a
Good God, he's a
problem
piece of
with
Or else we wouldn't be here.
the wording of, do you find, if you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide, and then we've given them the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Phantom Court reporter doesn't delineate between those two things, and I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has
Yeah, 'cause the
asked
standard
you
instructions
to
are
read
beneficial to you,
the
you dick.
self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well,
So again,
it is if you're talking just about an individual count.
But I was saying blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing a count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's
He always
causing
cuts the
confusion.
judge off.
What Madam Court reporter just read back, for example, could be construed as saying,
And Shona lets him get away with it.
with regard to any count, you find justified self-defense, he walks on all 5 counts, and that is absolutely not true.
That's not what he said.
That's not
Nobody
what he
said
said,
that.
and that's not what he's suggesting.
Tell that, but what's
That's not
already
even
been
close to
said
what it was said.
gives that implication. And again, I just
No,
worry
it
that
doesn't.
the more we deviate from these standard instructions,
Shut
the more we get into these issues.
I love that
should
Carl.
stick with what you drafted.
I love that Carl's done for the day, or is he taking his tie off, or is it? No, it just matches the shirt. My apologies. Never mind.
Which has been sent to the parties. We've all agreed on them, and I
Placing
am
blame.
leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well, I can say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty. And I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense.
That's even better. That's even better.
Instructed on that. So I think the correct statement is, if as to
Yeah, because
any
perfect
of the
self-defense, I think,
cases
means
with
something different to the
multiple
jury than it does to most
if,
lawyers.
Yeah.
On any individual count, they find
Am I the only one? It sounds like he's asking Binger permission
Consideration
rather than
of
just
the
making a
charge of
decision for
offense.
himself.
A little bit, yeah.
The defendant
But he has to get
lawfully in
both sides to
self-defense.
agree though before
They're done.
And he knows Richards is down.
Or a
Any
risk
objection?
reversal.
Okay.
While
Look
we're
at
talking about the
Binger,
jury
look at Binger.
instructions,
Yeah,
it
can't
was
even
noticed
concede with
as you
pride.
read them on page 10, which is
Assault
count
incarnate.
3. It should be first degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
On page 10,
it's on page 10 on count, still at the end of
no.
count 3.
Typos in the
It
jury
says you
instructions?
should
That's not
find the
good.
defendant guilty of first
yeah, you're
degree
right.
homicide.
You're right.
Yeah,
It is in there as homicide.
And someone was asking
we
if they're
didn't
going to
catch
have a
that
copy of
last
this
time
in
we
the
talked
jury
about it.
room.
I sent you 3
I
drafts.
think so.
Yeah.
But you know what?
I would
Should I
hope
just
so.
leave that alone? They'll know.
They
that.
have to.
I'll change it in the
Yeah.
printed copy.
There's no way that they can follow
In the-
all of this.
I'll
just by
change
listening
it in
to
the written printed copy. He just said.
Okay, yeah, they
Serendipitous
actually are.
timing.
After
So,
11.
so they are, yeah, they are going to get it.
How long are you gonna talk in your first sequence?
I'm trying to limit myself to 2 hours.
Are
Try.
you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon because the lunch has already been ordered. So, and I'm not
It's
gonna-
lunch being ordered business.
Love it.
Don't want cold lunch.
Law and crime stream just got suspended for policy violations.
So let's ask the jury.
What's the policy?
So I'll take
I
a
don't
break
know,
at-
but I got a
why don't you
warning that says
around
heads up, we've
whenever you're
detected
comfortable, around
copyrighted
noon,
audio in your stream. Your audio may be
just
temporarily
ask for
blocked,
the-
or your stream
Oh,
may be
no.
temporarily blocked.
It's because
I
it's got
if
to
we
be
talk
long
over
break.
it-
He's the commander of the.
Law
I
and
don't wanna
crime got a
interrupt
similar
him at
thing,
that
I'm
time.
guessing.
Want to be-
Well, if we
my
continually
goodness.
talk over the original audio, then you should be safe on that.
We'll
Yeah.
just get a lot of
happened to me.
complaints in the chat, but you know.
That
I don't
happened
know
with the
what-
Chauvin trial. With the Chauvin
what-
trial, I
what's-
don't know what it was like. Maybe a ringtone or something, but it happened to me too, and they cut my stream. Then I had to
Oh
redo it. So
no.
it does
It
happen.
was
So-
the judge's pew
so-
pew pew ringtone.
Oh yeah, probably. So to clarify, what they were just discussing was how self-defense works with these other charges and whether or not they can dismiss the lesser included charges if they found self-defense. And it sounded like what Binger was saying that it sounded like Binger thought that the judge was proposing that if they found self-defense for one of these incidents, for one of these charges, then they found self-defense for all of them. And that's not what he was proposing.
So, folks, what I was talking
So,
about.
but
with
it
the
sounds like
cases that
they
you
finally
have,
came to an agreement, right, guys?
multiple
Sounds like
possible
it.
verdicts submitted to you for consideration. When you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that?
I don't think the state can
It
like how that
hopefully will
wound
become
up
clear. I'm
sounding.
going to give you written
Makes it very
instructions.
easy for them to quit this.
Yeah.
Because I know this is arduous going through this, but every bit of it is important. And but you'll get written instructions for your
Not to mention that
reference
long
in,
break basically highlighted that
considering
now.
these things.
Kyle's trying his best to stay awake, and I mean, everybody's going to be posting pictures of him yawning, going, "Oh, look, he's such a bad
Yeah.
guy" or whatever. But how do you stay awake during something like that?
Counts
Yeah,
1
we're-
through
we're all
5.
bored during
that's
these
all
jury
that counts.
instructions.
Each contain the guilty verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crimes while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may find answer the question yes, you must be satisfied
beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made.
What happened?
By allowing testimony or
stream is blocked.
received over objection.
Yeah, I just see it now,
I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight.
What do we do now?
I don't know.
And
Hold
during
on.
the PBS stream.
At the beginning of the trial, I described the charges
No, but
against
it's not.
the defendant.
It's not then.
counts 6 and
It's
7,
our stream.
which respectively charge possession
Yeah,
of a
I'm
firearm
saying
by
it
a
might
minor
like if
and
he's like
curfew
a
violation.
I changed streams.
Have
Like when
been
it happened to
disposed
me,
of
I
and
just
are no
changed
longer
who I
part
was
of this
watching.
case.
And it
The
was
other
all-
counts
it was all right.
remain. Do not guess about or concern yourselves with the reasons for
Wait,
these
what do you mean?
dispositions. It must
Like
not
at
affect
first,
your
I was watching
consideration
like
of the
Fox
charges
26 when I was
that
doing
remain.
the
Do not
Chauvin
consider
trial.
evidence that
Then they
related
bounced
only
it.
to the
They
counts
cut my
which have
stream,
been
so that I went to like another stream. I forgot what it was like.
During the
2
trial,
years
I
like
have
that.
ordered certain
And then
trust
I was able to
testimony
do it, so
stricken,
it might just
and
be who you're
must
who you're
disregard
watching.
all such
That's
How
first
can there be
material.
quote privacy violations
Exhibits become evidence only when received.
I
by
don't
the
know.
during a
court.
public
Exhibits
trial?
are
Question
marked
mark.
for identification, but not received.
I'm just
Evidence.
tweeting YouTube.
Whether or not
There's
no is not
copyright issue.
An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the
Hold on.
lawyers are not evidence, and if the remarks suggest certain facts not in evidence,
God.
disregard the suggestion.
Well, we've
You should
learned a lot
consider
since this
carefully
trial. Let's put it
the
that way.
arguments of the attorneys, but their arguments, opinions, and conclusions are not evidence. Draw your own conclusions from the evidence.
All right.
I've
Is there
taken
any way?
judicial
Oh,
notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how
Oh,
much
it's
weight,
no
if any,
longer
to
being
give to the
blocked.
statement. In
back
evaluating
up?
each statement, you must consider 3 things.
We're
Whether
back
the
up.
statement was
I
actually
switched
made by the
windows
defendant,
and it worked.
only so much of a statement as was actually made
Well,
by
I got the tweet out in time. It's a funny tweet as to how there could be privacy
whether the
violations
statement was
during a
accurately
publicly
restated
broadcast
here at
trial.
the
but
trial, whether the
Okay.
statement or any part of it ought to be
So you're not
believed.
distributing PBS.
You should
anymore,
consider
is
the
the
facts
point.
and
Only knocked off
circumstances surrounding
30,000
the
live
making of each
viewers.
statement, along with
Jesus.
all other
They'll
evidence
be back.
determining how
They'll
much
be
weight,
back.
Yeah.
if any, the statement.
Yeah, let me retweet. Let's retweet this thing back.
Yeah,
out.
I'm gonna
The weight of the
amazing.
evidence does
Tweet this
not
out,
depend
too.
on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may
blocked
testify
again, it's
only
blocked
about
again.
facts.
Are you kidding
However,
me?
What
witnesses with
copyrighted
specialized knowledge in
audio?
particular fields may give opinions in those fields. In determining the weight
This is not
that
making
you
any
give to
sense.
these
So they're saying the
opinions, you
court
should
audio is
consider the
copyrighted audio. This makes no sense.
and
Some
reasons given
jackass has
for
got
the
to be
opinion evidence
filing
was
copyright
received to
claims
help you
on
reach
public domain info.
Now it says, quote, policy violations.
a conclusion. However, you are not bound by any witness's opinion. It is your duty as
Law and
jurists to
Crime is
scrutinize
using
and
like
weigh
their
the
own
testimony
feed.
of the
I don't know how
witnesses
they got
and
blocked.
to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. The outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections,
This is
the
fucking
opportunity which the witness
infuriating.
had to know and
This is
observe
bullshit.
the matters
It
and
is,
things about
absolutely.
which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has
Hold on, I'm
testified
looking
in
for
this
another
case,
feed.
and you should not discredit
PBS
his
is
testimony
apparently running.
because he is charged.
The
All of a
PBS
sudden,
is the one that I
Use
got
the same
blocked on
factors
first.
to determine the
Yeah,
credibility
PBS
and
is now up
weight
to
of the
91,000
defendant's
viewers,
testimony
which is interesting.
that you use to
PBS is
evaluate the
copyright
testimony
blocking everyone else.
of other witnesses. There is no magical way
that
for you
makes
to
sense.
evaluate the testimony. Instead, you
Pathetic.
should use your common sense.
PBS
and
has no
your
copyright in
experience.
this.
Is it because,
They
is it
In
don't.
because we were
everyday
too
lives, you
quiet?
determine for yourselves the reliability of
It doesn't
statements
matter
made
though.
to you
This,
by
you
others.
can't copyright
should do the
public
same
domain.
here.
This is public
Right.
domain.
Yeah.
Evidence has been received that two of the witnesses in this trial have previously been convicted of crimes. This evidence was
If it is
received
PBS,
solely
we might
because
have a
it
lawsuit
bears
against
upon their
PBS.
character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay, we're going to hear the closing arguments of the attorneys
Oh, no,
now, and,
come on.
Come the fuck
the,
on.
We follow the classical
Well, here we go.
debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument.
Try Yahoo.
So,
Yahoo's up,
I,
but
I
their audio
actually
may
just
suck.
switching to them right now.
Yeah.
It must
I'm
not
just going
be
to check
used
with my
for any
overlord
other
as to how I'm
purpose.
doing on time, whether or not we
We're going to hear the closing. You know what?
whether or not we
Does
stop
anybody
here
want a
or if
break?
I can
I'm
get
gonna
to the
email my
Yeah,
YouTube
take a
rep
break.
right now.
Anybody
No,
need a
that
break?
me a
we
second.
already asked
Okay.
this.
We're going to hear the closing argument.
Oh, no.
Did they get blocked?
PBS looks
The
like it's
attorneys now,
still up.
and
Yahoo's still up.
they
Now there's 93,000 on
we
PBS.
follow the
fucking
classical
killed us.
debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So, Mr.
I'm
Binger
still
will
up on
address you first
Odyssey.
on behalf of the state.
No, Odyssey crashed
then
too, apparently.
Mr. Richards for the
What did they
defense.
DMCA
and then
Odyssey
after,
itself?
His
I
remarks,
don't
one
know.
of
Somebody
the
somebody
attorneys for the
tweeted
state will
a
be
reply to my tweet that,
addressing you on behalf of
that
the state
Odyssey
in
crashed
rebuttal,
also.
limited to rebuttal of things stated by Mr. Richards during his presentation.
Wow.
The break, obviously, I'm not going to make you sit there for 5 hours unless you want to.
Come on, man.
So we'll break. I
think Crowder.
I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take a we'll take our lunch break and.
Oh, is
then,
Crowder still up?
Pick up this afternoon, and after all of the arguments have been presented, I'll give you about
Crowder's still live.
3 or 4 more
He
minutes of
actually jumped
instruction.
from 70 to.
And then.
Crowder's at 100 now.
Yeah,
Yeah,
all of our people.
Everybody,
Throw
who knows who's issuing the copyright?
So,
It would be very funny to see who's issuing the claim.
I
Which
didn't
one do you
get.
want?
I got
sisters?
the email says due to a copyright match, your stream was interrupted.
Who asked for the match? Gotta
Doesn't
get that
say.
info.
We'll take a vote right now.
Now somebody said
Supposing
Odyssey is up and working.
Arguments are finished at 4.
It'll be interesting to find out who. Let's just see if Twitter.
And we'll
versus
be
responded.
working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning?
If they stay tonight, that means they know already.
So I don't know how much you get done, but you'd have the option to get started this today.
Actually,
Or we just start fresh in the morning if we finish up anytime after
I'm
3:30 or 4 o'clock.
livid.
So how many would want to continue on today? 1, 2, 3, 4.
That means they already know what they want to do. Because if you had a lot of work, you'd be like, let's start fresh in the morning.
What do we got? 18.
8 out of 12.
How many would rather go back
We know
fresh
we
tomorrow?
want to start tonight.
Knowing that somebody weren't coming back. But okay, let's.
Let me,
of course, as always, I'll make the final decision. But I
That's
certainly
a big tip
try
to the
follow
hand
your
right there.
wishes. So okay, with that, Mr. Binger, it's yours.
We want to do it.
Thank you,
tonight.
Judge.
I can't believe this.
Good morning, ladies and gentlemen.
All right, you know what? Maybe
I want to
stop-
assure you that
stop,
everything that the
go
judge just
back,
read
and
to you,
then
you'll get a
put it in
copy
the
out,
frame,
so
and
you'll
then
have a
let-
chance
and
to
then
look it over
let-
yourself.
I'm
You don't
gonna.
have to-
Yeah, I'll pause this a minute. Let's see if that brings the stream back. I mean, I don't know how to articulate how angry I am right now.
What happened?
YouTube shut
No,
the stream down.
cut.
Mother.
I mean, we're still live on Odyssey, so everything we say is still being broadcast, just as an FYI.
That is
You're on
good to know.
speakerphone.
Oh, why don't you do this?
Oh,
why don't
phew.
you?
I thought that I'd frozen the video before I left.
Why
Shit.
don't you use your
I mean,
Odyssey
you-
stream? Well, no,
You
because
could link out to a different video and just have the heads talking at the same time, like you do with like a movie commentary, but it's all bullshit.
I've changed the stream 4 or 5 times now.
and it's not even coming up. It just
I'll be back in 1 second, guys.
I mean, should we start a new stream?
Hey, Chris, give
Yeah,
me one
that's
second.
probably be the best thing.
I think that's
Like
probably
shut this one down and then bring up a new one really quickly.
The question there is how do we avoid the same problem?
Eliza's blocked?
Well, we don't know what the problem is.
Oh, well, I
right?
guess we could just do it with the subtitles. That's fun.
No.
Well, I'll say
didn't-
this.
I wasn't,
when,
yeah.
When it happened to me, I went through like 3 or 4 different streams. Eventually, I found one and it stopped messing with me. So maybe that just might be the way you have to go through it.
I mean,
Wow.
I have the audio paused right now, so it should be clearing up. Long Crime's back up. I don't know why.
Oh, here we go.
Oh, there, we're back.
We're up.
Now we're
Yes,
back.
okay.
Oh, Jesus Christ.
You're back.
Thanks.
You're back. You're back.
All right. So
But when I start
Shoot it,
playing it
you're
again,
back,
it's
you're
going to
back.
happen again.
You're
I mean,
up.
unless we keep talking over it, right?
Yeah, play it.
You just have to talk a lot.
Here, we'll get it started up and see.
Real low volume, and we'll talk a lot.
Sorry, guys.
So I don't know how much
What's
you've done, but you'd have the option to get started this today. Or
I
just
mean,
start
of
fresh
course-
in the morning.
of course
if
we
it's-
lost
if we
40,000
finish
people
up
now.
anytime after
Everybody,
killed
it.
that's on everybody. All of us in
So how
here.
many
So
would
we should all be
want
trying to
to
tweet this
continue
out and
on
maybe put it on a
today?
community path.
Of course.
Everybody know we're back.
And we're a couple
Get
minutes
everybody
behind.
It just takes a
okay.
second to do.
5, 6,
Grab the link to the stream and just tweet it back out. We're back. We're back.
Yep.
8
Yeah.
out.
My goodness, YouTube.
How many would rather go
Wow.
back fresh tomorrow?
That was harsh.
Knowing that somebody weren't coming back. But okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
All right.
Thank you, Judge.
So we're a few minutes behind, but
Good morning, ladies and gentlemen. I want to assure you that everything that the judge just read to you, you'll get a copy out, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you.
What a smart.
I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
No.
Did they show the curfew part?
Curfew's
Oh,
done.
again.
There's no
Thank you.
gun
There you go. That's a good.
Although he claimed
charge, but and
Do you want the bad news now?
We're down again.
has been
Yep.
some
Oh,
discussion about the lawfulness of the curfew,
You
not in
gotta be
this
kidding
case,
me.
but elsewhere.
Nick, I just
So
messaged
it's-
you on
there-
Twitter.
but there had been a
Have
curfew
lost his info
announced.
from. You can
that
contact
does
Rumble
not mean
and see what you can do there. I don't know. Are you on Rumble now?
it was technically
No, I
lawful.
don't have anything set up over there.
Okay, well, message him and give him the
Legal
RMTP, and they can set up
But
a
there had
stream
been
right now
announced curfew, so
as a backup. Not
and
as
it was a
as
curfew that
subject.
all the rest of us here in Kenosha
check
were
your
aware
email.
of.
You got a troll
And I
that
think
goes
most
on.
people, most reasonable people, obeyed. Although the
I don't know what. I mean, I can get up on Rumble, sure, but I'm sort of. I don't know.
We'll have 14 followers there. We'll have 14 people.
I'm assuming I haven't gone down.
Well, first of all, it'll be just. The
I'm really.
subject
This
of
is
the
really entertaining.
What is going on?
Apparently, long crime is up.
Well, of course, long crime.
We
is up.
are up on Odyssey, so
Rumble.
But apparently-
Rumble is better than
Apparently, long crime is back up, or is up.
So I'm just
Yeah,
gonna go
that's
tweet this
helpful.
back out. Nick, what warning are you getting now for this
Same thing.
takedown? Policy
Same thing.
violations?
It's the detected copyright audio.
Can we co-stream it on Twitch as well? Because I mean, you got 10,000 followers over there or something.
I can't.
Okay, yeah. All right, just thought I'd ask.
Yeah, Twitch has got issues.
It's because I'm partnered on Twitch. I have
Yeah.
I have a 48-hour thing. I get exclusively streamed to Twitch, but.
And this is why you don't become a partner on Twitch.
Got to get back to this
it's so wrong.
spot.
This is classic
It's-
fair
it's-
use.
It's it's not even fair use.
Yeah, it's not even
Yeah,
fair.
because it's not
copyright.
copyrightable.
It's not.
Well,
it's not-
looks like we're back up.
we're back up again. All right, because
Hold on, I'm
Stop
switching
it.
to.
Because we're paused.
Back up, people.
I'm switching to law and crime.
Yeah.
Here.
We'll change it over. We'll do 2 minutes at a time. That'll make Binger's speech a little bit longer.
Yeah. That'll be good.
I.
Oh, God.
This is how they do it, though. I mean, this
Yeah.
is
Go
how
back to
they.
1.5.
We have
I'm
10
looking for
lawyers to tell you
1.25.
there's not a copyright problem here,
Right.
including some who specialize in
killed
IP.
people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Yeah, that was the objection we got earlier.
Curfew charge anymore. There's no gun charge.
Although he claimed
There's no curfew
Damage
charge
the
either.
protector on my
and-
screen on my
and
phone. It's going to annoy me.
There,
He did say both.
there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. So it's but there had been a curfew announced.
Everybody needs to hit
that
up
does not
at
mean
Team YouTube on this.
that-
Yes.
If you're on
Yeah,
Twitter,
it
tweet
was
at Team
technically
YouTube
lawfully
about how
passed.
bogus this is.
And
Feel free to tweet about it and like talk about it having happened in the past, but obviously it's not happening now. So don't turn into a Twitter army just right at this second, okay?
just
might make a
also just go
virtual
retweet the link so we
reality
can get back
There had been
to
an announcement.
pre-shutdown numbers.
And it was a curfew that all the rest of us here in Kenosha were aware of. And I think most people, most reasonable people, obeyed. Although the defendant claimed to be protecting a business that he wasn't familiar with, the
Because the
actual
protesters
killing
weren't
had
reasonable.
nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about Car Source, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help?
Well, he's going to keep hammering.
He's
on
not
that, isn't
there for the same purpose as the protesters. So why was he there that night?
Well, he's the only one not starting fires.
When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized, and there's a lot of political issues back and forth and things.
Like this prosecution.
There is common ground.
Prosecution, I should say.
We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property, and all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life.
He's saying this in case.
Is he seriously sitting there trying to say you don't weigh a child's life? Because let's face it, he was under the age of 18 at the time. Rittenhouse was a child. Is he seriously sitting there going, you don't weigh a child's life more valuable than a pedophile?
Some of them heard about Rosenbaum and the others.
The funny thing is,
I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s.
Someone based on that.
Because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them.
Oh yeah, that was why.
So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT. I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority.
Projection people.
And when you think about the defendant's behavior in this
He's
case,
definitely not on trial for being a hero
with Anthony
or not.
Huber,
If Binger wants to
a
be
man who was there because
that's
he knew
good.
Jacob
That's
Blake,
good. I don't think anyone
who
thinks
carried
he's
his
a coward.
skateboard everywhere, and who rushed towards danger to save other people's lives.
Oh my God!
You better be fucking kidding me.
So when I talk to you here in my closing
Objection,
argument,
facts not in evidence.
I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you. As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you
Some highly
in jury
irrelevant.
selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun
10 minutes
that
down the
wasn't
road.
his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT. There were a lot of people out that night.
Stomach churning.
Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a
Which are
video, you've
entirely
already
legally
seen
to be
it,
do.
of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters. And there's people getting in people's faces, there's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No.
You disingenuous bastard. There were 2 drive-bys that I'm aware of during that. Hey, Alan.
No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Zeminski for arson.
Yeah, where is he?
That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street car source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant.
I called
the defendant arrives at that
like a
location
provocation.
and you hear him yell friendly, 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 because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand. So
I can say it right now, Tweety. I have to be more polite and indirect than that when I'm in court. But thank you.
he can raise the gun with his right and left hands and point it.
Which hands?
This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell gun, gun, gun. And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone.
Yeah, because that's what happened.
So let's take a look at some of that video.
Because you drop a fire extinguisher when you're putting out fires to take the time to shoot people. That's exactly what follows from his argument here.
It's literally.
This is Exhibit 73, the full drone video.
This is galling.
And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that.
At people.
And you're going to see that entire sequence of events here on the full drone video.
Here comes the Rorschach.
Mm-hmm. It looks worse than I ever saw it before.
If there were any holdouts of people out there who didn't yet hate lawyers, this is going to be what pushes them over the edge. This is.
The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns. And before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground.
No, Mandy, it's how I say you're a fucking lying
I don't even know
smunt.
what he possibly thinks he sees there. But
Please disbelieve my own expert.
Yeah, this is like ridiculous.
Also, all of the other witnesses that have testified. Also, all of the other video footage.
Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant.
If he was any closer,
would it be an asshole move just to object anyway?
I mean,
It's like,
they are
I just
allowed
wanna
objecting.
that nobody can see anything.
But you are allowed objecting
Usually-
during closing arguments.
You are
right?
allowed to object, but
Yeah.
generally you don't.
Yes, but it's got to be a good reason.
Yeah.
If he was any closer to Kyle, Kyle would have been another one of his Me Too victims.
I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points.
Trouble is you can't say shit.
He was using the fire extinguisher as a pretext to shoot someone when he had the gun the whole night. Makes total sense.
Yeah.
I can't see anything in what they're
I
showing.
can't-
If they
I
have to
can't
show it
either.
5 times, it's probably
But
not
that-
clearly showing what he says it's clearly showing.
No,
This feels
you can't
like
see
there are
shit.
four lights. Yeah.
Yeah,
You know,
this is good.
but that's
This
but
is
that's
great.
that's another reason for them to not object here, because then it just shows like, all right, we're not worried because it doesn't show what they think that it shows.
Yeah, I would mention it if I'm
Under
audience-
Wisconsin law,
Did
Yeah,
you see
you're
it?
not
they,
allowed
they played it
to
5
run around and
times,
point your gun at
and you
people.
still don't see anything.
This is the provocation.
Oh yeah.
This is what starts this incident. The defendant rushes in and immediately points the gun. And as you'll see in a little bit,
I'll get to it, Julia.
Mr. Rosenbaum doesn't take kindly to
I'm not
people
great
pointing
with that, if I'm
guns.
honest.
I don't think anyone does. That's not
It's-
unusual.
It's interesting that he's
No
making
one
sure they
wants
don't
to have the
attack
gun
him,
pointed
right?
at them,
Because that's
and
not
no
the
one wants to
claim.
watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28.
That's why count
I'm
6
having the
doesn't work.
detectives check it to make sure that it is safe.
Oh, here we go.
Should object to the phrase "someone else."
The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the
Repeat,
gun.
Finger. Look at that. You got your photo op, you celebrity.
Objection, he's
That's an
facing the
argument.
wrong direction.
Okay.
That's an argument.
That's a very
He's
good
holding the-
objection.
So what you see in that video is his left
Very good
arm
objection. Though. Very good
reaching for the gun, holding it up.
There was no need for that.
Keep telling them what they
You can
see
see
in
it
the
again
video.
on the
It's
video
not in
here.
evidence.
His left arm reaching up towards the gun.
He just did it with it. Yeah, he did it with his right arm, which is exactly what
Yep.
Richards
Yes, he
just.
did.
That is what
Wrong arm.
provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim
That's not
self-defense
accurate.
against a danger you create. That's critical right here.
That's not Wisconsin law.
If you're the one who's threatening others,
There should be an
you
objection.
lose the right to claim self-defense.
It should be
You
objected.
don't.
But
Objection.
you do.
Then we have the chase that occurs after that.
Provocation is a-
And we have taken that drone video and we have slowed down portions of that chase for you.
To make it even more confusing.
So what we have right here on the screen, this is exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was
Whose
unarmed.
chat is going in the bottom there on the screen that they're.
There's the
Oh,
defendant
sorry.
turning
I
and
haven't
pointing the gun.
full-screened it 'cause I had
Mr.
to.
Rosenbaum leaps, his hands out to the air,
It's
and then
long
watch
crimes.
here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs.
He is literally telling us not to believe our
That's
eyes.
bullshit.
Don't believe
I'll
what
play
you
that
just
again.
saw.
Or
The
the
defendant
side
is
again.
pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side.
Chasing
The
him
defendant approaches these cars and slows down,
because he's
Uh-huh.
cornered.
and then turns and shoots Mr. Rosenbaum.
Yeah,
3
that's
feet
it.
away.
Yeah, he's-
Yeah, that's actually not what happened, Binger.
fingers
I don't think anyone finds this compelling. I don't think any reasonable human can
Well,
find that
because
compelling.
Finally, I'm gonna
you
play
have to,
every
you have to
jury's
square
gonna
that
be
with the
thinking.
fact that he was shot in the hand.
And the
and
muzzle,
like- and
the
the-
powder, right? that's
Exactly.
on it.
That was so clear. Like, how do you square that? That is clutch.
This shows you the final part of that,
That's
zoomed in
the
and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot.
Oh boy, we saw how close, Finger. Good, good.
Don't worry, we all saw
I mean,
how
how
close he
far
was.
away? I mean, how far away?
You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off.
Except he was.
Wrong.
That's
The defendant fires 4 shots in quick succession.
Bigger. Are you going to be
And I'll come
charging your
back to
expert
this in
with
a moment,
perjury?
but you'll note during this
I hope that
entire
in the defense
sequence,
closing
it's the
that they
defendant
show
who
this in
chooses
real
where to
time.
go.
Because this
He's
is
the
obviously
one
slowed
who
down.
decides to run where he runs. And he slows down right as he gets to these parked cars.
As he gets
That's what
cornered.
allows Rosenbaum to get closer.
arguing two mutually incompatible statements.
We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well.
So his complaint is that he isn't running away. I don't know what the.
Not running away hard enough.
Yeah.
I mean, nothing like seeing all cops are bastards. ACAB.
This is
spray
Exhibit
painted on the car
25.
when the guy's getting
This is
changed.
the annotated aerial footage. You see the defendant approach running in the same direction as Mr. Rosenbaum.
Oh my God.
This is where the pointing occurs in the direction of the Zeminskis. You can see Josh Zeminski's right there on the screen.
Objection.
Yeah,
Can't say
object to
direction of Zeminski's. Come
I'm going to
on,
put the
Mark.
cursor over where the Zeminskis are. They're right in there.
Unbelievable.
You were fighting this before. Why are you caving now?
He's
They've done that on several different
obscenely
things,
silent.
including the use of victims.
They got
He is
The defendant is
so
pointing
slick.
his gun right here, and he's pointing it in the direction of the Zeminskis.
Oh my God!
Because they're standing next to that car.
Objection!
It's funny. Do they not have better footage?
And then the
from
chase occurs.
street that we could look
Now,
at?
what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot.
You mean because they'll?
That's likely
fearful of
because
the
they heard
scenario?
the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum. And I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this. And then he comes upon Mr. Rosenbaum's body. Is that audio playing? Okay, I don't know. Is it coming? Sure why you're not hearing any audio on that. Is Brian around? He's not. All right. Can you text Brian, please?
Why are we texting Brian?
Burn inside. The rioters are saying burn inside. That sounds good.
At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection.
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 Then you can make that dispute in your argument.
Let the judge adjudicate.
And you'll be allowed to respond.
You can see in this video the crowd is attempting to save
testifying in
Mr.
his
Rosenbaum's
oath.
life.
Fucking binger.
Yeah, they're going to try to make this look as gruesome as possible.
Yep.
So expect to see the autopsy photos as well.
Yeah.
Yeah. Oh, I would imagine so.
100%.
Yes. Trigger
So,
warning for everyone if that's
we
going to
have
be too
shown
gruesome
you
for you.
the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat
Did he actually
that
admit
Mr.
that?
Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen.
How?
It is the
How are you going
one
to debunk that?
fact
Rosenbaum's
in this
dead.
case, the defendant wants you to believe that there's no video of. And in fact, I have the video of the entire incident. I've played it for you, and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum ever wanted the defendant's gun. He never said, I'm going to take your gun. He never said, I want your gun. There's no indication of that.
He just tried to take his gun.
Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot.
Because how is he supposed to identify that?
Mr. Rosenbaum's body all the way down, firing 3 more shots.
0.75
A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp, and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the
Well,
one
they did talk about it with
that took Mr. Rosenbaum's life.
one of the medical experts.
But he couldn't determine if the hand or the pelvis was first.
There is no
They could only determine logically that the head. and
reaching
back
for the
were
defendant's gun.
Yeah, that makes
subsequent.
And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back.
To the back.
This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum.
Kyle can't look at the pictures.
Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which
refutes your whole narrative.
Can you get back in the frame?
The evidence suggests that Mr. Rosenbaum's hand was
what?
most likely turned in this position,
Huh?
palms
What?
outward, with his
What?
thumb to the ground. When the wound, the bullet goes through the area in between his middle finger and
Richard's
his
in
ring
the
finger,
background. Just
and
showing me
penetrates
the
the lower
opposite.
knuckle of the middle finger and the index finger before exiting.
There's no.
There was
Dr.
no
Kelly
evidence of
testified
that
there's soot
whatsoever.
in that area, suggesting
no
that the hand
testimony
was close
regarding
to the
his
end
hand
of the
being
defendant's
like
barrel
this.
of the AR-15 at the time of that shot.
On the back.
That
The defense
completely
wants you to
contradicts
believe
with him
it's
saying
there
that he's not
because
within hands of reach
Mr.
of the
Rosenbaum
child.
is deliberately reaching for the gun. Well, that doesn't make any sense.
Really?
First of all, this occurs
Even if he was
after
going like that,
Mr.
he
Rosenbaum
could
has
have
been
reached
shot
for the
in
gun that way and just gone, I'm trying to get it like that.
In a second.
He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be
Was there testimony
effective.
the thumb was down?
I
No.
submit to you, ladies and gentlemen, to the extent
making
Mr.
crap
Rosenbaum's
up.
hand ever got close.
You
to the end of the defendant's
disingenuous
gun, it was
prick.
completely inadvertent, not at all
I think if
intentional.
I think Richard actually objects here, though, the judge is going to tell him just bring it up on your.
Now, we've
your
heard a
own
lot about the
closing.
Zeminskis in this case,
So-
and I just
Do it
want
anyway,
to carve
exactly.
them out of this case right now because it's a red herring. It has nothing to do with any of this.
You literally just
There's
used them
no
as your
focus on
own.
that because I think
Oh
the
my
defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way.
2.5
Were they not
seconds after
suggesting
firing.
Now, the
That's
defense
what
wants
he
you to
was
think
aimed at?
Joseph Rosenbaum was there to attack the defendant.
I mean,
We'll never know what Joseph
Because
Rosenbaum
he's
was thinking
dead.
because the defendant killed him.
yeah.
Yeah, because
So we're
he
just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him.
Don't worry,
He's an
Mandy. I need to go to the
unarmed
toilet
man.
too. So tell you
This
what,
is
we will
a
both
bar
do the same
fight.
thing.
This is a fist fight.
But I also
This is a
don't
fight
want to
that
leave Binger.
Maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever.
Cranium the boy.
What you don't do is you don't bring a gun to a fist fight.
You do when you're
you don't bring
when there's
fist.
disproportionate sizing between the
Is that
parties.
because he's the one who brought the gun. He gets to kill. So I want you to contrast this. Two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here?
You fucking prick. You can easily kill someone in self-defense in a fist fight. All it takes is a well-placed hit to the nose. Are you kidding me? Told man he'd have a bathroom break and then started ranting. I need to pee too, but I know if I go out there, I'm gonna have to talk to my family, which I love and would adore. But I know that I'd leave this stream for way too long. I think Binger's on a roll. Wait till Lunchbox's rebuttal is just simply made. Oh no!
He's trying to take
The only
the gun,
difference
which
is
is
the
a
defendant brought a
reasonable
gun.
threat to his life.
He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this.
Objection! Yes, you can.
You lose the right to self-defense when you're the one who brought the gun. When
Objection.
you're the one
What
who
the
created danger. When you're the one
On
provoking
your
other
feet, Richards.
He's telling him the law.
The defendant fired 4 shots at
Got the
Joseph
wife telling me off for
Rosenbaum
getting a little bit
and
too
caused 5 wounds
emphatic.
total. The first shot fractured Joseph Rosenbaum's
They're not gonna let
pelvis.
this objection go through.
This causes him to be helpless. He's falling face first to the ground, and he is vulnerable.
It's a hell of a statement.
The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground. He is almost face first to the ground. The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp.
Binger's
At this
never been in a
point,
fist fight
as
in
you
his
saw
life.
that
Are you
video,
kidding me?
A crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd,
The
except for
court
the
is
defendant,
currently on break
are all
live,
focused
so
on
we're going
trying
to
to
catch
save
up.
this person's
Good.
life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr.
Well, he was
Rosenbaum
wrong.
was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't.
For any of you that saw my short the other day about the jury of your peers, Binger has been judged by a literal jury of his peers. There are 10 of us saying he's a disingenuous prick.
Doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot, and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this.
Exactly.
How fast he fired, as if that somehow excuses him. Exactly the opposite.
How many thoughts can you have in
He
0.76
controls
seconds?
how quickly he pulls the trigger. He is in
How
control
fast the
of
guy
that
charges.
decision-making process.
It certainly suggests a state of mind.
No one else made him do that.
I'd like to
And
hear
this
them
is
make this
indicative of
argument
someone
for every
who
police
doesn't
shooting
care
now.
about the consequences.
Yeah.
Doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going.
When you're in that situation, you don't stop until you are sure that the threat to your life has been extinguished. Are you kidding me? 0.7 seconds for him to pull the trigger 4 times. That kid was terrified.
Less than a
And
second.
as I said, he tracks the body all the way to the ground with those second, third.
Sorry, I'm
and
smiling because the
fourth
wife's getting
shots.
mad at me.
The only way that you could possibly justify
And there's the little
murder
one
of
telling me I'm
Joseph
very
Rosenbaum
noisy.
is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly
to his chest. Oh, so
would
dramatic.
think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant.
Trying to
If I
divide
got my
up
hands
You
on
have
a
to
gun
believe
after
all
being
of those
shot,
things
I would use it to kill the person who
to
shot
justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened.
According to McGinnis,
That's why
it
they're
did.
trying so desperately hard
And
to
Rambo.
convince you that Joseph Rosenbaum was
Rambo.
reaching for that gun.
According to
Because
McGinnis, he
if
was.
He's not reaching for that gun, and he's not going to use it to kill
Hang
the
on,
defendant.
give me a second.
It is not justified. There is no valid self-defense claim.
Well,
one of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one
could have been-
who
he could have
chose where to
died.
run.
Yep,
He
he could have
chose
just
to
died.
run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape
Reasonable.
before killing Mr.
Well, and that's the
Rosenbaum.
provocation bucket. That's why it's so important. If he didn't provoke that,
Your Honor,
none of that matters.
Right.
I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on. So if, I think this would be a good time
Right.
to pause if that's okay.
You need
Okay,
to work
thank
on
you.
a lot more than that, Binger. He's basically admitting that Kyle was retreating and now trying to hold that against him.
And
Yep.
we will begin again at it's 1:45 too soon.
Why wasn't he a track star? Why hadn't he been working out for the past, 10 years?
12:45. Is that
Why
all
isn't
right?
he Usain Bolt?
Let's do that.
Have you not watched Zombieland? Rule 1 is cardio.
By
Didn't
the
limit
way,
it.
I mean,
Binger has mentioned his prosecution of Zeminski enough now that I have a sneaking suspicion Zeminski is going to, in fact, get off sooner than later scot-easy from Binger's
Yeah.
prosecution. That he's bringing that up a little too hard, and people should be
Yes.
following what happens with Zeminski. Yeah, nod your head,
Liberty,
Binger, I'm right.
Liberty or Death 88 says, why was. God damn it.
Yeah.
Yeah, I lost it right as I was starting to read it. Just a second.
He said
I'll-
something.
Yeah, the chat
Basically,
is
he
going-
was saying, why was he even charged in the first place? Isn't it prosecutorial misconduct to bring charges you can't sustain?
No, you only have to have probable cause to bring the charges, and
Yeah.
they have probable cause in spades. So yeah, it's not.
Yeah, and I mean, with respect to the possession, the state fundamentally disagrees with how the courts read that statute. I think the court's right, but the state has its own opinion.
And to be fair, it was a poorly written statute.
It's a terribly
Yeah,
written statute. It's horrible.
Prosecutorial misconduct is an extremely high bar to get over. So
Right.
as long as you can make a reasonable argument, which I think he is, he's making a reasonable argument, even though I
Yeah.
think it's full
All
of
right,
lies and all that.
Yeah.
True.
When we get to the point of reducing the number to 12,
We have to decide what to do with the other 6. And the alternatives would be to just let them go about their regular business and tell them we might call them if we need them. Or we can keep them here
Please.
Where they can sit and watch daytime TV. I don't know.
They can watch us.
Obviously, they're limited channels they can watch.
I'm pretty sure the one channel they can't watch.
And of course, they will not be permitted to talk about the case. So, any preferences?
My preference is to keep them here.
Yep.
Yes. Okay, we'll do that then. And
Bye.
we'll have to find some way to entertain them.
Sorry about that.
Make sure
Just have them
it
listen to
doesn't
story time with Binger.
involve
Just read them the jury instructions over and over again.
Yeah, then it's good. It's a really good nap time.
Well, we don't need them being brain dead.
12:45.
Wow, already some zingers in that opening hour.
I do have to echo Nate's point, and it's probably an unpopular hot take for this audience, but I really enjoyed the presentation
I think
of
you did a good
the
job.
prosecutor.
Yeah.
That isn't
Yes.
to say that I think it's true or that you have to believe it or that he's not
Right.
misleading you, but from just a technical presentation point, I thought it was exceptional. I thought it was outstanding. It's
And that's the annoying thing is that
I've
I
done
too
lots
have
of
to give him
Toastmasters
props
over
for
the
it.
years, and it's everything you want in a persuasive speech. I really liked his use of the slides. He didn't read them. It was minimal and it just emphasis. And I think he's very, very good at this. And if you're inclined to convict or you're inclined to find him guilty, I think he's giving you a lot of reasons to go that way. So
Right.
I think
Yep.
I think it was a very, very good persuasive speech.
It was fantastic. It just wasn't honest. That's my.
That's
it
the
just
problem.
wasn't persuasive.
I wholeheartedly agree with that. Hang on, I'm just going to. Can I do that? Yes, I can do that. Okay, and I'm cucking myself. Hang on. I wholeheartedly agree with everything that was just said. Admittedly, Binger's cadence, his presentation, what he did during that was quite well done. It's just that he was lying through his fucking teeth. And yes, I'm aware that the audio is a little bit out, but anyway. I'm mildly annoyed because I do think that that would be persuasive if there are jurors there that are politically looking to convict, or were looking to convict, I should say. He gave them ample opportunity and reason by, again, lying through his teeth. Which is very fucking frustrating. But wrapping a turd in a fancy package doesn't make it a gift. It does if you're giving it to Binger. They're going to need cameras in courtrooms for every Kenosha murder trial. Probably every felony trial. I would like cameras in every courtroom. Aside from family court proceedings where there's children involved, I genuinely believe that there should be complete transparency. Have you heard how Hogue is doing after his stroke, I should say, Alan? Haven't heard a mention of him in a while. Yeah, he's doing well. He's back. I think he's done a couple of streams since. And my understanding is that he's doing reasonably well. I personally haven't been too close to him, so it's not... I haven't really felt in a position to be one of the people reaching out and checking in on him and that sort of thing. I get my information sort of secondhand and from seeing his streams and that sort of thing. But my understanding is that he's doing well. So, yeah, that... okay. Alright, how far through is lunch? Wait, is that... Are they watching the stream of a stream? Or is that just... Oh, no, it's because Ron came in. Schroeder... Okay, we'll go for there. And... sorry, Viva. Barnes. Sorry. Oh, jeez. I can never tell.
6 months. Police were going door to door with this man's picture. He was terrorizing this neighborhood. They had a community together saying, hey, if you see this guy, stop this guy so we can apprehend this guy and stop him from coming into our house.
I can't win.
Like all those facts matter, and then you're saying that you're trying to stop him for that reason, and they searched for him with guns with police.
And
right?
the kids
Because
have left
police
now,
were
so if
involved.
Binger gets into it, I
Those
can
facts
go
aren't
off.
good, and I can see somebody saying, well, they were reasonable. They acted reasonably, and that's really what you're looking for. Did they act reasonable?
Oh, looks like we're back.
Yeah, it's hard for people to remember that you have a right to be racist in America so long as you don't use it against someone to the detriment of their rights. Which, you know, we may not like it, but that's not a basis for a murder charge. You got to have the facts in there.
Yeah.
Yep.
Obviously, Kyle's self-defense is much, much stronger.
Oh, he's
yeah,
got
yeah,
one
yeah,
of the
yeah.
best
Night
self-defense
and day.
claims literally in history that's ever gone to court. I mean, it shouldn't be there.
It would be hard to find a better self-defense case that someone had to defend in court.
I can't imagine.
I challenge you to come up with one.
And that comes back to the problem with prosecutors is that, you know, the fact that this is going to be at least a little bit of a roll of the dice because self-defense is just that amorphous is at least somewhat unfair on its face.
Well, yeah, this case comes down to, did they pick a good jury or not?
Yeah.
The fact that this has been prosecuted and gone on this long is just incomprehensible. With these facts.
It's funny. This the one funny thing about this case is the person who was using the racist terms is the one that the only person that's saying he wasn't the racist. It's like, what, huh? Rosenbaum is screaming the N-word all night, and it's like, well, he's not racist. Like, but the person who shot him is the racist. Like, okay,
What's so
I don't get
What's so aggravating is that it's such great self-defense, and the DA is so desperate to convict that they're willing to submit fake evidence and to support a ridiculously fake narrative because
Yep.
they're so hungry to put this kid behind bars the rest of his life.
Thank you, Judge. Good afternoon, ladies and gentlemen. I'm going to continue on. I hope your full stomachs won't distract you too much from the presentation here. So I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to
Where was this in evidence?
through the target
Definitely not.
and continue
Never.
flying on for up to 550 yards.
I don't remember that either.
None of
Richard
that was in
McGinnis
evidence.
testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's
Where
around
was
your
this in
target
evidence?
and know what's behind your target. This is true when you're hunting.
It's argument.
It's true when you're target
It's
shooting.
argument.
And obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared.
Yeah, houses and businesses and cars and dumpsters, they're all on fire. You are not taking into account that it is effectively and accurate to call it a civil war zone. Because that's effectively what was going on, Binger. If you are honestly telling me that a reasonable person would not be distracted in that scenario and is expected to know exactly what is going on around them entirely, again, you're a disingenuous prick. In my humble opinion.
Cared one bit about his background, cared one bit about where those bullets were going to go.
You
And as I
actually
said,
haven't
he
proven
put
that he didn't
Richie
care.
McGinnis in danger.
Inverting the burden of proof.
Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum and has his own video shows when he first gets there, he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
Probably more gruesome detail, guys. Fair warning.
Oh, hang on. Before that gets too bad, I should probably put up the banner. Give me a second. Oh, did I edit it? Oh, I must have changed it. Give me a second, guys. Trigger warning. Gruesome pics likely. Okay, I think I got that. Scroll that across the bottom, add the banner. There we go, just in case.
You okay? Just don't move, man. Don't move. All right, I'm gonna flip you over real quick.
He did buy fronts. They pulled him out for the Anderson trial because everyone else had a link to him.
Yeah, they're going to show this stuff over and over.
Yeah, as much as possible.
Get away on it. Get away. Give me a fucking look. Where? 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 Where's the hole? Get the fucking mouth up. You shot him. I didn't.
You want to talk about medics. You want to talk about people who care. You want to talk about people who are there trying to help. You just heard them and you just saw them. People who didn't know Joseph Rosenbaum. They just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there were just like 6 shots. It went off.
This is actually a mistake in Kyle's testimony, in my opinion. He should not have said that he said he didn't shoot him.
Right.
The defendant says he pulled a gun.
He just said he pulled a gun, and there's a fucking photo of him having a gun in his hand.
He pulled a gun was a lie.
Was that put to him?
No, it wasn't.
Cross?
It's not
Yes.
true.
Okay.
The defendant knew it wasn't true. He's lying to the crowd.
And you're
as
lying
he's
to the
running
jury.
away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun. The
Oh, he's
defendant
talking
is
about
lying to
Rosenbaum.
save his own skin,
Shit.
instead of going and trying to help the person that he has just shot and killed.
Another reason why you don't put him up on
In exhibit number
for
3,
testimony.
Gaige Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exact.
Yeah, because you want to mention in the middle of a crowd in a riot, oh, I just shot somebody. That's not going to antagonize and inflame the crowd around you, is it? And potentially have someone pull a weapon on you when you're not looking, when your back is turned? Jesus Christ.
Exactly that same time, as he passes Mr. Lukowski, he says, "I did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45.
Tech issues.
How do you not have these timestamps? How do you not have these timestamps?
Because he wants to take
This
every
is Gaige
opportunity he can
Grosskreutz
to play as much
running
of the videos
towards
he wants.
danger, running to try and help.
That's why he has his phone out. He's running towards danger to help.
Oh, yeah. Absolutely.
This is exhibit number 3.
He wasn't talking about this. It's like this video interrupted his argument.
Yeah, no, I think it started as he was still talking, so I think this is a mistake.
Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot?
It's hard to tell what he said.
Yeah, play that over and over again on repeat and show exactly what happened. Grosskreutz asks him who's shot. And then he talks about, oh, I had to. And then what's the thing that happens immediately? Stop him! He shot somebody! And someone yells out, cranium that boy! Yeah, there's no reason for him to lie there, is there?
That honestly.
Hey, what are you doing? You shot somebody?
I understand the lying is going towards character, but I think it also represents a state of mind if you're trying to show self-defense and trying not to escalate things.
It's hard to tell what his exact words are. I hear the word
It
not.
can go either way.
Pretty clearly in there. As in, I did not shoot anyone. I did
The
not
jury
do
can't
anything.
actually hear it. Binger's got to make it up.
Jason Lukowski, he lies to. The crowd, he lies to. Gaige Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene. And how are we supposed to know where he's going next? You know, all night that night, the crowd has been hearing the sound of gunshots. They've been
Point
hearing
2 is
fireworks,
actually a lie.
firecrackers.
It's really
Now
irritating me already.
someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still
Objection.
has the gun. He's shot someone. This is provocation to them.
This is not.
This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable
Mischaracterizing the
for
law.
that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun.
Goodness.
He could have raised his hands and surrendered.
Speaking of reckless use of a dangerous
He could have signaled
Yeah,
to this
reckless
crowd that he
endangerment.
did not
That,
pose
that
a
would be
threat.
reckless endangerment.
Yeah.
But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't.
He's
But from
more
the crowd's
threatening running
perspective,
away than
are they supposed to
firing
know any
firing his weapon.
He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter.
Doesn't
They
matter.
have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible.
Yeah, hitting him in the head with a skateboard.
Could
Least
have used
intrusive.
deadly force against him.
They did.
They could have shot at him.
They
Tried.
almost
But
did.
instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down. This man that the defense wants to call jump kick man, he's got no weapons, no gun, no knife, no nothing, comes in and tries to kick the defendant in the face.
This is much
Anthony
weaker than the
Huber
first
comes
half.
back and tries to grab the gun, actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gaige
They
Grosskreutz
call
comes
him
running in,
jump kick man?
stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gaige Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gaige Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but
He did
not.
aim it.
And you heard Gaige Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night, very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would
couldn't get the
characterize as
button.
the least intrusive means possible. Someone knocks his hat off. Anthony Huber comes in with a skateboard.
Gets kicked in the face. Oh.
There goes the arm.
In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gaige Grosskreitz's arm. It's that fast.
His arm's still on.
This is
to be
someone who
fair.
has no remorse, no regard for life, only cares about himself.
And you only care about getting a
And
win.
these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a
Huber's
credible
literally
imminent threat to
armed.
his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation.
He would have run to the
After
cops and they'd all be alive.
Killing Anthony Huber.
Yeah.
After
You
severely
gotta
wounding
incorporate
Gaige
that in your
Grosskreutz,
clothes.
the defendant walks away. Like the hero, like he's some sort of hero in a Western.
Nice line.
Without a care in the world for anything he's just done. You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there.
He was trying to get to the
In fact, they pull
police.
up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself.
No person has any obligation or requirement to render first aid to someone where they're in a situation where they believe it will place their own life in danger. In that scenario, if I had just shot somebody and there was a crowd forming around the person that I just shot, I would not stop and help. I would run to the nearest police officer, which is exactly what Kyle did.
We have taken that video and we have broken it down into individual frames. And I want to take you through frame by frame the incident with Gaige Grosskreutz, because a lot has been made about Mr. Grosskreitz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It is ripped through his ribs, his heart, his aorta, and
his
he may not
heroism.
technically be dead, but he's going to be dead within a few seconds.
Mandy, you wanted a rant. They're
He is
coming, trust
stumbling
me.
away. The defendant has the weapon pointed towards Gaige Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to
Running
go
up to
frame
him.
by frame here slowly as we see the movement.
Ah!
Oh, come on.
This
It'll
is
kick
he's
back
much he's much worse in this half. Much worse. I've found so far 5 errors that Binger's made.
Now we see the gun is moving down towards
They're not
Gaige
errors.
Grosskreutz. It is pointed directly at him from a distance of just a couple of feet.
It's fine, Mike. They've
Gaige
already left the building.
Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gaige Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz.
He interpreted it that way.
At
It
this
wasn't.
point,
He
Mr.
doesn't ever take his
Grosskreutz
hand off the pistol,
is,
off the
I
grip.
think, probably thinking
No-
to
no
himself,
proof.
if I can get away, I will,
Grosskreutz didn't testify to
until
this.
he realizes
Testify for him?
that the defendant is getting ready to fire again.
No objection.
He's basically just making new evidence at this point.
I don't think Binger is doing well. I think he's making errors that are hurting him, and I'll explain it when there's a break. But I found 5 things he did that I think were a mistake to do, and it's alienating him from the jury.
Well, I look forward to hearing that later.
I'll break it down for you guys.
I look forward
Excellent.
to this argument being over so I can smash my head through my glass desk.
In none of these frames is Mr. Grosskreuz's right hand with his Glock pistol pointed at the defendant.
Just imagine who you have to be to suggest that in these frames his Glock pistol isn't pointed at the defendant, therefore he shouldn't have shot him when it was. Like,
And he admitted it was.
Yeah.
And you
Don't
think the
believe
jury
my
doesn't know?
lying
You can
witness.
see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here.
Into a shooting position.
This is frame 444.
this is why frame by frame
can
is
see his
prejudicial
right
to a
foot
defendant
is
and probably shouldn't be
on the
allowed,
ground, but
by
it's
the
starting
way.
to move back. Now, as I move forward,
But where's the
in the
objection?
frames 447, his
They
right
should have
leg is
done
moved
it on
back.
testimony. I don't think they can object to it now.
This
It's
is
all been
someone who's
admitted.
about to retreat.
Yeah.
His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action.
How do you testify
What action does
what
Mr. Grosskreutz take?
Feels.
Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never.
You only shoot
Does he
people with
Does
two
he even
hands.
take the gun with one hand and point it? No, never.
Yes, he does.
Instead,
Grosskreutz
you can
testified
see
to
him
that.
start to lunge in with his left arm forward. The gun is not in this hand. The gun is in his right hand. He's lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun.
Objection,
You can see
speculation.
now he's going to take a step with his right leg across the defendant's body. Not directly towards the defendant, but across the defendant's body.
He
does that
testified it was
mean?
As
towards
he's
him.
reaching in, almost swiping away at that gun with his left arm.
Not in
He has
evidence.
Slap it
bladed his
away.
body in such a way as to
Slap it away.
try
Go plain
and
like
present
that.
as minimal of a target as possible, which is probably what saves his life. His
Nope.
right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's
Shouldn't
trying
he
to
be
shield
sworn in if he's
himself with his
testifying?
left arm. And as we approach for frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant.
Grosskreutz
Frame
fucking
499,
testified that he did.
The gun is just fired. Frame 500, you see the puff of smoke.
That's
501,
a puff of bicep.
the bullet has
brother.
hit Mr. Grosskreitz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreuz's arm with the right hand with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary. The muscle is severed. Now watch. Frame 503.
Where's the medical evidence?
Watch his right hand.
It's an involuntary
503,
action
no
in
evidence.
a frame. In a
505,
30th of a second, he
506,
involuntarily pointed his gun at him.
508.
When was Binger qualified as a medical
at this
expert?
point-
If Binger can't win without being
Absolutely.
dishonest, then he shouldn't have brought the
That right
case.
arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle.
Why not?
And it's
Again,
not
when's-
involuntary.
where's the evidence on that?
It's done because
He
the
wasn't
defendant just
shot.
blew his
He
arm
wasn't
off.
shot after his bicep was blown off.
But
so-
yeah,
This
this
isn't
is
the
the time
bicep.
after the shooting when, yes,
This
the
is in
gun
your
happens
forearm.
to be
This is a
pointed at the
tendon, by
defendant.
the way, not
And I
a
got to
muscle.
stop here for a moment and
You
highlight
should
the
have stopped a long
hypocrisy
time
of the
ago.
defense. Because according to the defense, if someone has a gun, they're a threat. If someone
Maybe
points
stop.
a gun, they're
Never
a threat.
mind. I'm not going to say it.
There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat.
Oh, now he's
He
trying
gets to
say
point the gun at
provocation
everyone.
there.
But, oh, we're
Well,
not supposed
point
to
at
take him
everyone.
as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody else.
Actually,
There's no exception
you
in the
don't
law
want
for
that,
Kyle
Binger.
Rittenhouse. There's no exception that says if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse.
That's
I can do it
literally
all
your
night long.
argument, Binger.
The same
When you guys
rules
see problems,
Isn't
I
that
see
provocation on their
as
side?
everyone else. And
I mean,
everyone
if-
else has a right to defend
If
themselves.
defense was
also,
capable of
not just
capitalizing
the
on this,
I think you'd have to be a fool not
They've done
to.
this a couple of times.
But they are
right? That
kind
he's
of-
lying to save his skin to get away from the mob. I mean,
I mean, the problem is that this defense has not shown themselves to be great at dealing with anything.
it's just so wild because the other people aren't on trial. They aren't.
We have shown
having
you
to deal with the
photos
same defenses.
and videos of Gaige Grosskreuz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant.
It's not so much that he's arguing for the defense; it's that he doesn't. He's hoping to smokescreen the jury, basically. Audra, Binger wouldn't have been in this situation because he wouldn't have the balls to go out there and try and protect the property like Kyle did. He'd be at home, quivering, crying into his fluffer boy pillow. In my own personal opinion. Oh, gruesome. Forgot about that.
Yep, the gruesome stuff.
And they're going to pause there. Of course they are.
But this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like. I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm.
If Gaige had had more muscle, it wouldn't have been so bad.
When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else. That the defendant had put someone else at risk of dying by doing that.
Objection.
The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they
Knowledge
felt
of
their
provocation
lives
isn't
were in
actually an
danger.
element of
That
provocation.
is reasonable.
That's true.
It is also reasonable.
Add another
to
is just so
understand
weak.
that at that point, Gaige Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone.
Yeah,
He'd
so
heard
this
the
is like
defendant
we
lie about it.
predicted that they were going
He
to
saw
try to
the
put the state of
defendant
mind
shoot at jump kick man
into
at
all
close
of the
range.
other people around him.
Miraculously
This
missing.
is not an
Had
issue
seen
here.
the defendant
How do
kill
you attack
Anthony
the state
Huber.
of mind of their right of
Gaige Grosskreutz
establishing
reasonably
their right to
believed
attack him?
his life was in danger at that moment.
Who established their state of mind?
He was proven correct because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs
When did he
away,
become a criminal?
the crowd comes after him. Can he just shoot anybody and claim self-defense?
Objection.
Oh, geez, this
Objection.
Someone comes up to that person and tries to stop them, tries
classify
to
him as a
disarm
criminal
them,
before he-
like Anthony Huber did.
At best, he
Do they
becomes a
forfeit their
criminal
life?
during the first shooting, right? So,
Did
They
Anthony
do get
Huber
some leeway
forfeit
though,
his
because
life
it is an
by trying to
argument.
be a hero and stop an active shooter? And
but he
protect
hasn't even argued a criminal act
justified?
before the shooting.
Can the defendant
Right.
just kill him?
At what point did he become a criminal?
In this case, the crowd was right.
Come on! This is why I preferred to use another stream, but using another stream got me struck down, so this is what we're stuck
Don't worry
with
about
for
it.
now. I'm still salty. Okay, listen here, Joe. I'm still angry. I think we were gonna break 100,000. We were gonna break
Yeah.
100,000 people, and it was artificially tamped down by YouTube.
I think so too.
We were at 77,000 people by 11 a.m. I mean, once lunch, after lunch, if it wasn't interfered with, we would have had it.
They hate you because they ain't you.
I'm going to try and find answers on if it was PBS who actually issued the complaint, because public broadcasting service issuing the complaint is a little bit of a problem for me.
Yeah.
Let me see.
Defund PBS.
I'm going to try refreshing the stream. We're back about a minute 20. Just a second.
Yeah, it's not wise to deplatform a panel of lawyers.
They have just as much right as the defendant.
Hold on. I'm going to go back to where we were. Maybe.
And feel free to like full screen it too.
God, YouTube is busted right now.
Do you want me to break down all the mistakes Binger's making while you're doing this?
Go for it.
All right. So first of all, I think it was a terrible mistake showing Gaige Grosskreutz talking to him, and over again, the jury being reminded that Kyle actually did say, "I'm
Justified.
going
In
to
an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what
Every
was going on
day?
here.
Really?
And that crowd
Nick, bring
Ian
back in.
And that crowd was full of heroes. And that crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy,
I have no doubt on that.
15, and I hear he just shot somebody,
Hey, Nick.
my first instinct is not
Ian
to
wants
approach.
back in, Nick.
Yeah, bring Ian back in.
Anthony Huber was different.
Sorry.
He got bumped out.
It's not personal. It's
Oh,
just
no
what-
worries. My net
It's just
burped,
'cause-
so it kicked me
It's
out.
just because you're
That doesn't
Canadian.
make them a
There's a
threat
lot
to
of
the
that.
defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant.
I think he's stupid. for
That's a
keep saying
bad
that over.
argument.
That's what I'm saying. That's a terrible job. He keeps talking about.
I
Kyle's
told
right
you I
to
wanted to
self-defense.
begin
Just as much right as the defendant.
by
He had the
talking
right
about
to defend himself that
the
day.
murders committed by the defendant.
He keeps admitting that
Now I
Kyle's
want to go
right
back
to
and put it all in
self-defense.
context.
It's a terrible mistake on his part.
And that context starts with, bruh, I'm just trying to be famous.
Oh, jeez.
Oh, Lord.
TikTok profile.
That's funny. That's funny.
4 doors, more whores.
Oh.
Lady Smith, fumbling early May, proudly holding his new
I think that's
AR-15.
endearing. I think it's stupid. I think this is
Up
a
until
bad
August
argument. Another
25th,
bad argument.
2020,
It's
this is
endearing.
He just seems like a 17-year-old knucklehead, you know, like it's just
maybe put
I don't
100
know.
rounds through it or so.
You're so
At
saying
that
it's
property
endearing.
with Dominic Black.
Yeah.
I've had to open up the.
They purchased
Open
that
up the
gun on that
scotch for
same
this.
trip. The defendant admitted
the
he
last
knew
of
as a
my
matter of
Rittenhouse
law he
ride
could not
right
buy
here.
that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't
Because
make
he
a lot
could.
of sense.
You just lost that
We
charge.
don't have a lot of defendants come in and say, well, I possessed cocaine. I knew I couldn't buy it, but I thought I could possess it.
That is
Definitely
so
possess it.
bad.
fuck?
No way.
Check to this.
Dominic Black conducted what was called
That's an
strong
objection.
for the
That's a
defendant.
big time objection right
He
there.
purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know.
No, you
just
aren't.
like I'm prosecuting Joshua Zeminski.
Objection. That's also
Because what
right.
Dominic Black did was wrong. And we don't tolerate that.
Yeah, right.
The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And
Yep.
the defendant knew
And he was legally
that it
allowed
was
to
gonna be
hand it
held
whoever
on
he
to
wanted.
until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because
That's
I think
called
it's
a
important
trust,
when you
by
consider
the
the
way.
recklessness
It's legal.
of the defendant's conduct.
Fully legal
How
to have
much
a gun
he knew,
trust.
cared, or didn't know about this deadly weapon.
I write them.
He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more.
That's not
He
in
wanted it
evidence.
'cause
The
he said
defendant
it
said he
looked
did not
cool.
load it.
Yeah. And
no one
also, I'm
testified
sure
that
he's
he
going to
did.
just
Didn't seem to
bullshit his
know
way
or
through
care
not
much
having an expert on the
about the
FMJ.
type of ammunition
To be fair,
or
I
the
think
type
you'd
of
be
gun.
culpable.
You had a couple of witnesses tell us in this trial, and it just
It's like driving
I could
someone
not
else's
believe
car,
it.
which is full.
A gun is a gun is a gun.
But this gun's scarier.
Don't even start with that.
Don't even start with that.
Don't
Bullet
even.
is a
I
bullet.
can't even.
No, it is not.
Did he full on just white girl? I just can't
Anybody
even.
who says that is ignorant and reckless. Because there are some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars.
Where's that in
And
evidence?
you heard Officer
It's in
Krieger
evidence.
testify
Objection.
that when they heard someone was running around with a rifle, he went and got his plate armor out of the back. Wasn't going to.
I hate Mark Richards.
Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields.
What's your point?
And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense.
His lethal
Yeah,
weapon
but that's
was
because
less
it's a
lethal than the
handgun.
other lethal
Ammunition acts
weapon.
differently. It's going to hit its target. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially
But
on a
how
night
do you
when there are
avoid
hundreds
that,
of
please?
people out on the streets
You
in our
can't
heavy
assume that
residential
with hollow
area.
point ammunition
We
either.
can see on that map.
Yeah, how
The car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that AR-15 had no
I
lawful
submit
or
to you is
legitimate
something you say a
purpose
lot,
that
isn't it, Binger?
Now,
Nice.
the Second
I
Amendment
see what you did.
allows people to carry guns. That is true. There are people who can't carry guns. Convicted felons, for example.
Which
Like
Carl
Gaige
is not.
Grosskreutz.
Generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to.
Self-defense.
So, for
it
example,
absolutely did.
Ryan Balch says the handgun is what he was going to use for self-defense.
Is he an
Several
expert?
witnesses
Was he
agreed
qualified
you
as
can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that?
No testimony that he was protecting a car source building.
The defendant has admitted the gun was useless when he was going to treat people as a medic because it got in the way. He had to take
Got
it
him
off
there.
and hand it to someone.
He's
So you
got him there.
can't
You
use it as a
the
medic.
gun- Right, you
You can't
the
use
gun
it to protect
treat
the building. So what's it there for?
To protect yourself, you.
It looks pretty imposing, and it has some deterrence value. But Jason Lukowski, Dominic Black, and Ryan
What was
Balch
it?
all
Shout,
said they
show,
never
shove,
actually
and shoot?
intended to use their guns.
And so did
No
Kyle.
kidding.
So did
So why is
Kyle.
it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away.
No,
Wouldn't
it's to make
fall
it
off,
easier to
he
carry.
wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine.
Oh, I'm getting
capable
frustrated.
of killing 30 people or more.
It says at
Why
least
do you
30
need 30
people. That's
rounds
not true
a
at
full
all.
metal jacket armor to protect
There's
the
no
building?
evidence about it either.
The least it's capable of killing 30 people? No.
This
The least
AR-15 is
zero.
completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And
So?
certainly when you see someone like that, it doesn't exactly send a warm, fuzzy
He's a
message.
medic walking around with the
Come
gun
to me,
himself.
I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud.
Speaking of
He
frauds,
was not an AMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation.
That's not true.
Everybody's anticipating violence.
It's a flat out lie.
Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go
Shows
there
why he
and
was
walk around
justified for
claiming
having
to
a
be medic.
firearm.
He's like
I
a
mean, at this
quack
point, you could
doctor
test, or you could say that
practicing without a license.
Rittenhouse was a
That put
fire-breathing dragon,
lives
and
at risk.
Richards would just sit there.
And one of the things I had Gaige Grosskreutz testify about is that tattoo on his right arm, which said, "First, do no harm."
yeah,
Which
no.
is one of the precepts, one of the
Which,
fundamental
by the way,
tenets
appears to
of
be a
the
stolen valor
practice of medicine.
tattoo because it was
First,
K-N-O-W,
do no harm.
which is
So how do we evaluate the
military
defendant's
medic
performance as a medic
tattoo.
that night? Well, on one hand, he wrapped up an ankle and I think to maybe help somebody who got a cut on their hand. Yay.
More than you can do.
On the other hand,
Oh.
he killed 2 people, blew off Gaige Grosskreitz's arm, and put 2 more lives in jeopardy.
So he did provide
when we
medical care
balance
to
your
someone.
role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and
Calling
even
the
on the
victims
witness
again.
stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else.
I think
For
Binger's
him
making
to
a
call
mistake
himself
here.
a medic is an
Yeah, I
insult
agree. He's
to
attacking
anyone
him.
like Gaige Grosskreutz,
This is-
who spent
this is his
hundreds of
7th
hours
mistake.
training
So far.
and working hard to become an EMT. It's an insult.
All EMTs that are actual EMTs should be insulted that
The
he
defendant
just
made a
implied
series
that
of
Gaige
reckless
was an
decisions
actual
that
EMT. By the
And all lawyers who have had to sit through this trial, including the 9 on that panel and the one sitting right here, are insulted that Binger still has a license. I assume. I admittedly, I can't talk on behalf of the others. I'm insulted that this fucker continues to call himself a lawyer. The way that he has handled this case, the way that he has lied through his teeth, in my own personal opinion. I'm really annoyed that I have to keep saying that to protect myself from defamation. Fluffer boy, there's a reason you're not allowed in Bruce's courtroom anymore. And by God, you, in my humble opinion, are part of the reason why people don't trust lawyers. This hasn't helped anything in terms of that public perception. You have shown that you have been dishonest in this trial. You have argued with the judge in ways that were completely disingenuous and disrespectful. And you have made my blood boil. And I'm usually pretty tame.
By the way.
Going armed with an AR-15 at 17 years old when he knew he shouldn't have done so.
He didn't know
because that gun is normally locked in a safe that he doesn't have access to. And it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no...
Oh my gosh.
I don't know which is more infuriating, Binger or this stream. The law and crime feed, rather. Well, no, I do. Binger's driving me nuts.
Let's see. I'm gonna see if I can. Last time I skipped ahead 5 seconds.
No, I don't believe that qualified immunity or absolute immunity should exist for prosecution. Absolutely not.
Come on. Oh, it's driving me nuts. I might bring up the PBS stream again.
Might lose everyone.
Well, the stream is like the jury, I think, at this point.
Let's see if I can get it back. I've got Fox News.
Non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did. In part, because we all knew it was going to be violent and dangerous.
Oh, okay.
Most reasonable people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation.
I mean,
Unless
all
you
of your
want it.
witnesses did.
Unless you're looking for it. Unless you want trouble.
Unless your skirt is real short.
Yeah.
Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who were exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too.
So does Kyle.
But that's not what we're talking about.
Isn't it, though?
The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates. All of this was sending the message to reasonable people, go away. Don't come down here.
And yet
Let
Rosenbaum
Kenosha
was still
burn.
there.
Who was left at
Let it burn.
11:45 at night?
Oh, wait, this would be
Most
Pedophiles.
reasonable people had gone home before the curfew or never even came at all.
I mean, it shows that all the other people
the
that are
defendants down
witnesses
there,
were
he
also
says,
unreasonable.
Because he wants you to believe he's protecting CarSource. Even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no idea what's going on here in Kenosha, having no idea what businesses are, having never dealt with CarSource before,
I
just
don't know what a
injecting
business
themselves
is.
into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot. They took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. Just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them to go away.
Except for the
Stay
defendant
out.
who literally worked there.
Did those owners, Sam and Sal, ask anyone to protect their business?
Yes.
Yeah, actually.
Because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them.
I'm sure they did.
They were lawyers trying to do an insurance claim.
I don't think it really matters much, except I wanted you to have a flavor of who these people were.
Doesn't matter what
and
they
what
said.
was going
Please
on
ignore
at that
it.
building. What was interesting to me is that text message from the defendant to Sam asking for the address of Car Source, even though the defendant says he's already been there. It didn't make any sense to me. It's not hard to
There were
find.
3. You
You've
didn't know
driven
which one he
past
was
it every
going to.
day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd.
There was an
It their
agreement now.
responsibility.
Yeah, now
there's an agreement now.
The shootings occurred at 11:45 or 11:50 at night.
10
He
seconds
didn't
ago,
even
he had
know
no
if that other
ties
group
to the
was still
place.
there
Now there's an
or if
agreement.
they'd left.
This is why you have to write all
But
this
crucially,
stuff down. This
you
is
heard the
the
testimony
defense.
of Kriston Harris.
This is gold.
Who's out there reporting.
Yeah,
The defense had better be
Right
writing,
now,
taking
live,
notes.
making some video. And he tells the defendant, stay on your property.
Hopefully the defense
Don't
can
go out in
capitalize
the
on it.
streets and engage with these protesters because you're
Hopefully they're
just
watching
making it
us.
worse and you're escalating the situation. He tells the defendant specifically that. Just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd
Now he
that's feeling
testified.
threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street. He saw guys up on the roof and he felt threatened. These guns, he said,
Rough.
were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said
Those
he
aren't
felt
laser
threatened. He thought
sights,
someone
they're
was
laser
pointing a gun from the
pointers.
roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us. Stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead. So we don't know what he was thinking.
He was
We don't
thinking,
know
I
what
want
was
to touch
going
a
on in his
minor.
mind. That makes him an easy target for the defense today because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself.
Technically, he only likes being
That
piled
happens a
on
lot
if it's
in
by minors.
homicide trials. Blame the victim who can't speak for themselves.
Said victim again.
So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some
He
testimony
said you
about
could
him.
say it in close.
He'd been in the hospital, left
Judge
it that
did.
day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world.
I've
He
never
visits
left the
Carrie Ann
hospital with a
Swart,
clear
his
plastic bag
girlfriend,
with a water
and then
bottle in
happens
it,
to
be
wander
fair.
downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it.
He just
So what
happens
does
to
he
have left
do
a,
that
left a
night?
hospital where he's being treated for.
Let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire.
He also used hard
Oh,
R.
and there's this empty wooden flatbed trailer that they pulled out in the middle of the road and they tipped it over to stop some bearcats and they lit it on fire.
Stop the police.
Oh, and he
His
said
tone
the
is
N-word.
awful.
He said the N-word.
His tone is just
Hey,
terrible
Binger,
right
go
now.
ahead and repeat it.
Yeah, the sarcasm
Say
is
the
not
If he were
N-word,
alive
Binger.
today,
Say
like
it, you
Josh
coward.
Ziminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we
This is
prosecute you.
gold.
We don't
Or the
execute
other
you in the
prosecution
street.
for arson.
Yeah, I don't
And I'm
think
not-
you guys see the gold in what he's
So
saying.
Ju-
This is
I
gold.
do.
What's up,
I'm
everybody?
taking notes. I am.
How's it going,
We don't
Robert?
do that kind of behavior, not at all. but he didn't deserve to die for it.
Hey, Rob.
You can't kill someone for these things.
You left out the part where he tried to kill Kyle
He's
Rittenhouse.
5'4", 150 pounds.
He's just a manlet.
Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum.
Probably because he was over the age of,
the little
what,
guy who just wants to
15?
chatter. But when it comes down to it, it's all bar.
Confession for projection.
No,
Like a little dog.
I'm on
Bark,
Binger's
bark, bark,
side
bark.
now.
Really? Ain't gonna do anything. There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun. Never had a
Tried
knife.
to.
Never had a bat. Never had a club.
But he did have a chain.
And in the Drew Hernandez
It's a
video,
chain, though.
that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off. He's talking a lot.
This is poor.
But he doesn't actually threaten anybody, doesn't actually hurt anybody.
He tried to. He was about to.
They're pushing him around like he's a tiny little person, which frankly he was.
I'm on the state side now. Rosenbaum was a tiny little man, a tiny little.
And in the
member
background of
Munchkin
this video,
Guild.
you will hear somebody say, point your gun at me or something like that.
Shoot me.
That's Joseph
N-word.
Rosenbaum. He's upset because somebody
Play
pointed
it.
a gun and that
Quote him.
triggers him,
Play it.
Quote him.
which is
Play it.
understandable.
Play the
I
video.
think most of us would be
Screaming it.
triggered by that sort of thing. And that's what's upsetting to him.
Yeah,
But
that's why
he
he's
gets
the
right in the
N-word.
face of people who have AR-15s. Never reaches for their guns. Never
Except the
rears
time he
back to
does.
punch anyone. Never even lays hands on anybody.
Yeah, because it was a fucking group. And he was chasing down Kyle, who was on his own.
Being interrupted by his own
You're
video.
going to watch this
Right.
confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side.
how
And none of the
stupid.
people with the AR-15s
Tactically
feel their
dumb,
life is in
Greenberg.
danger. None of them shoot their guns.
Oh, do we get to see him say the
They
N-word
can
over and
handle
over?
it.
That'll be
That'd be
that'll
nice.
be
That's
fantastic.
Just loop it.
Good
Right.
optics. Yes, he walks right up to them. Brilliant.
That sound you
Oh,
heard
they
was
cut it
somebody
off. Of course they
throwing
cut it
some
off.
sort of plastic
Aw.
thing
Yeah,
at
but-
one of the stanchions underneath
They're
the
not that dumb.
gas station,
Except
and it makes a
the
sound
jury's
that
now
almost
thinking
sounds like
it.
a gunshot.
Yeah.
Yeah.
Well,
Add that into the
who
mix.
isn't
You've got
thinking the
people with
N-word right
guns,
now?
Loud voices, clear hostility, and the sound
Well.
of something that, frankly, to me sounds like a gunshot, and yet
See a
everybody
picture of
keeps their
Rosenbaum
cool.
screaming it.
Nobody hurts anybody. Nobody fires a
Everybody
gun.
keeps their
And
cool.
watch how they push Joseph Rosenbaum around like a rag doll.
Which, by the way, would be a battery if it were not justified.
I think I want the video of the guy with the green shirt there because he looks like Kyle. So someone who's not doesn't know about it. Makes you think of Kyle waving the gun around when they show this guy.
Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. Wow. I guess it was a different guy that did that, but they're shoving him around like a rag doll.
Well, I guess not. But
Watch as I don't even know
what I
my own
mean?
case.
Mouthy little guy. He's a little dog that barks.
So are you, Bingo.
Little dog that barks.
He's just a little itty bitty guy.
Is the framing here designed to?
And you know what he's going to do now? He's going to tell him, hey, I need to go grab my bag. I don't have my bag. So they let him on through. There he is about to reach down and grab his bag off the ground. That's Joseph Rosenbaum.
You notice how they've selectively edited out the key moment.
Of
That
course.
was really weird. I don't know.
You've
why.
heard testimony that he tells people,
Yeah, why
shoot
would they
me,
use that?
It's terrible.
asking
That was
them
weird.
to shoot him.
Quote it.
Just
Curious
let the
how
hard
that is
R
a
fly.
threat to anyone else.
He's not.
triggered,
He
as
knows
we saw
he'd
in the
make the
video,
news with
by
that.
people pointing guns at other people, which is reasonable. Most people would feel that same way.
By the way, this
And
stream
then
is
we
listed
get
as a
the
stream
crux
for
of the
children by YouTube.
This threat that he supposedly
I don't know.
made to the defendant.
I think you get to choose that, don't you? You could say it's not
Yes,
good.
and I chose
The
correctly because it defaults to
would
the correct
love
choice.
To be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night. From
Gee, which
multiple
minute
different
didn't you
angles.
show us?
And yet, you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript.
You have his.
Maybe we do.
We don't have his sister. I can imagine. Hang on.
We have.
That reminds me of that. There's a scene in I think it's one of the Police Academy movies. The cop car pulls up. There's a crowd. There's a riot. No, it's the Simpsons. It was the Simpsons. It was Chief Wiggum. Car pulls up. There's a riot. They're pushing on the car, and he goes, "Back off. We're prepared to use We're prepared to use force." And then you hear him go, "Wait, what? We're not prepared to use force?" And the crowd just goes, "We're prepared to show you." Wait, what? We're not prepared?
Have his testimony, and what he says is there was an incident in which Dustin Collette had put out a dumpster fire and said something to the effect of "fuck around and find out." And Balch steps in, and he has an exchange with the protesters, and he turns around, and Rosenbaum is right there in front of my face yelling and screaming. And I tell him to back up. And he goes, "You know what? If I catch any of you guys, blah, blah, blah." So that's the timing.
What's the blah, blah, blah?
What's the blah, blah, blah?
Right after that
Most
dumpster
important
fire.
part.
Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there,
They can
during the
legitimately
dumpster
pull
fire,
apart
but he stays
each
with Ryan Balch
of
and
these
or the
claims
defendant for the next 6 or 7 minutes, recording everything.
by
And I
just playing the
played this
videos
video
and
for
saying,
you.
"Mr. Binger said this, but here's what happened. Play the video."
It is Exhibit 18. And I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, "I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum, hearing this threat?" And he said, "No." And then I said, "Okay, well, maybe you missed it because, there's a lot going on. So will you rewatch your video for me and tell me, is it in there?" And he said, "No." This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it
Absence
for
of
you here as I'm
evidence
talking.
definitely means evidence of absence. That's how that works, right?
Joseph Rosenbaum is
Well,
invisible.
It's certainly
Now, I
elevating
submit to
video
you
evidence.
that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed. He can't kill him.
I mean, he
But
could kill him.
the defense has pinned a lot of their case on a threat that didn't happen and they can't prove. It's not on video. It's not there.
Yeah, the implication
Pixar
that
didn't happen,
pull up
basically
exhibit
what he's
18,
saying.
Happen.
the Rundown Live video, and I'm going to go to that mark.
Kriston T. Harris here at the Rundown Live, and I'm here with a bunch of... Kriston T. Harris here at the Rundown Live. If you are live, share this in all your groups, your forums, start watching. Protect it. Just like the year, man.
So here's the dumpster fire.
I can use a doobie right now.
Joseph Rosenbaum is not in this video. Here's
So?
Dustin Collette.
Weren't you the one that said that he was just off the side?
Neither is Kyle Rittenhouse, you fucking nonce. Sorry, I'm frustrated at this point.
He shouldn't be. He's burying himself. This is great for the defense. Yeah, this is like so irrelevant, this video, that you have to wonder how it got in. If you had any competent defense counsel.
It's a reverse.
You don't have the defendant, you don't have the victims, you have nobody in jail.
I have to agree with her.
There's Ryan Balch standing right next to Gaige Grosskreutz. Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message.
No,
as long as you stay on your property, but don't go out there and cause trouble.
I thought the important message was I could use a doobie right now.
I have to agree with her. They shouldn't be on the street. They're just protecting their property. One guy's an asshole. I thought they were yelling at them. I was like, no. They did it. One of the guys losing his patience. You should go inside. Yeah, if you guys can switch them out.
He's talking to Ryan Balch right now.
He's got a lot of rage. He said the wrong thing. This whole problem is guy's life.
This is all irrelevant because Kyle Rittenhouse is not involved in this discussion.
And not being described in these discussions. He's trying to imply that they're talking about this guy with a lot of rage.
This is where Ryan Balch goes and talks to a protester.
We got to be coming up on the 2 hours that he said,
We are.
right?
We are, definitely.
Oh man, I would love to see the judge just be like, and stop.
Well, he has 2.5 because he gets to reserve a half for his rebuttal, but he may stop him in his rebuttal.
That'd be great.
I would actually let him continue to talk if he gets to 2.5 and I'm arguing.
If exhausts his time.
Yeah, then he loses his rebuttal entirely.
I think he's pretty far from the plot. I don't.
I agree. This is not very tightly woven narrative right now.
It opened up good, and it's been a disaster. It's like a
Really
full
That
good
part
blow.
just hasn't been tight.
I know you are, but like, they got their own medics. And,
Like, what's the point in showing this? Why are we watching this right now?
They're trying to do evidence of absence, right?
Yeah.
But
Well, he's not calling anyone the N-word here.
as you can see, nothing happened in that 4 minutes. Okay.
It's almost like Binger's run out of stuff to talk about, so now he wants to just say, hey, here's more video.
I was saying he's probably going to try and drag out his opening as long as he can to try and bore the jury.
I don't know why you
My
do
guess.
that though, because
Yeah.
before the break.
Well, they're
he was
not going to
so
get a
good.
lunch break now.
Yeah.
They already got their lunch break, so it's probably going to go direct to Richards.
But
Not
they
that
might
that's
do
a
it.
good.
When the
I mean,
They
he'll
might
get
do a
The
quick
rest of the
recess,
video is
though.
the crowd
he'll
being
get a brief break.
warded off by gas launched by the police. They launched tear gas, which affects the defendant, which affects Ryan Balch, it affects Kriston Harris. And that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there.
Peace Richards
Trust
is
me.
taking notes.
The defense had it. They'd play it for you.
Thank God for that.
Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night,
Who the fuck
Joseph
cares?
Rosenbaum is wearing
As if he's-
a red
he's
shirt
not so
and a
easy
blue
to identify.
bandana.
He's the
If someone threatens me and says, if I get you alone, I'm going to fucking kill you, I don't care if I know them or not. If I can recognize the guy that's chasing me, and it's the same guy, the threat is still valid.
But by the time he's killed, he's got no shirt on.
Didn't he
He's
just
got no
spend
blue
10
bandana.
minutes establishing
This is someone the
immutable
defendant has never
characteristics of
even
this
met
person?
before.
Yeah.
He
one
is
of hundreds
uniquely
of-
short
you know,
and
recognize him.
weird.
Man,
And
what?
yet,
But
we're
you could
expected
never
to believe that in
recognize
a
him.
split second, the defendant remembers this guy. I don't believe so. So then, that video that I just showed you leads off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. Wasn't much danger to begin with. Wasn't anything left there to protect. But by this point,
it wasn't in danger because it's
That's an
already
interesting
a
idea.
hollowed out shell.
Everything
as
already
law
been
enforcement
destroyed.
comes through, you've heard this video where they tell the defendant and his group, we appreciate you, and hand him out bottles of water. As long as you stay on that private property, yeah.
That was
No
not a
one is
condition.
saying you don't have the right to stay on private property and protect private property.
You
What people
literally
are
did.
saying, what the crowd is saying is stay there. Don't go out looking for trouble.
Binger
we burned down the
literally
rest of the
said you
defendant
don't have the right to
Here's
protect
this
private
message
property.
from the police and takes it the wrong way. He thinks, oh, well, now
To
I'm
be fair,
junior
he said you
policeman.
can't use
I can
legal,
go run around stopping
lethal
crime.
force.
Now he's
Protect
bringing
private
up that the cops.
But I asked him and I asked some other witnesses, if the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place. But why are you still sticking around?
Why shouldn't he have been there?
And interestingly enough, you know, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship.
Like rats.
You
Good
know
description.
all about that.
That
Wait,
is a
he's
good
talking about the
description.
But it's
rioters?
boring.
He's talking about the rioters
59th
or the
Street.
people with.
There's no protesters.
I think
No, the
proud
rats all
people.
have
No action.
AR-15s, actually, Joe.
So the defendant decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly.
Not Mandy.
And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, you just pointed your gun at me. And the defendant says, yeah, I did. He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him.
Just
Do you think he
peacefully
just sat
minding
there and
his own
thought,
business
I'm
with
going to make up a
rocks.
lie about this guy on the
That was
spur
an
of the moment?
objection for hearsay.
Or did it
out-of-court
really
statement
happen?
for the
And is
truth.
it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car?
He doesn't sound like him exactly.
Does he
No.
strike you as the kind of guy that would threaten deadly
There's no
force
evidence that he ever did.
Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes
Okay,
into
so
the
where is the
trial
man
and
in
says,
yellow
"Oh,
pants
I
to
was being
give
sarcastic,"
testimony to that?
like he's a little 17-year-old and he wants to get out of it.
He literally
He
was
was
a
a
little
17-year-old.
Shortly after that, the defendant loses track of his protector.
That was a
Ryan
terrible
Balch.
argument.
So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch.
Supposed to.
He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, I work there. That's my business, which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through.
I
shortly
forgot where
thereafter.
he's going with this.
But the defendant gives
So
up.
is he.
I think
He
that's the
could go one
point.
block in either direction and make it back easily if he wants to. But he stops.
And
He
this is
decides,
why
"You know what, I'm
having
gonna
too
stay
much
here
time
and
for a closing argument is dangerous.
Maybe see what's going to happen.
He's gotten off the PowerPoint.
So then he talks to these
If
people
you
with
can't
fire
convince them,
extinguishers.
confuse
And
them.
he's going to go down to 63rd Street and he asks one of them to come along.
Writing a 2-hour
And they
speech
say
is
no.
catastrophically difficult,
Now, at this point-
by the way.
Doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy. And yet he decides to go it alone. He decides
How
to run
dare
down to
you.
63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed, but he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody
Literally
asked him to do that. Nobody
was
gave
a
him the
junior
right. Nobody
cadet.
deputized him. Ryan Balch says, the police told me the crowds, we're going to push them down by you. You're going to deal with them. The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this?
That is a
The
dangerous
wrongness.
situation to be in.
Oh, well, now I've got the power. I've got the gun. I'm going
Oh.
to go confront these bad guys. I'm going to stick
Yeah,
my
by-
nose
by-
in things.
Offering them first aid.
So
if
what
he
does he
had
do
been
when
a
he gets
cop,
down to
there would be no
63rd
question
Street? The
about
first
this
thing he
shooting.
does, we showed it to you at the very beginning, that drone video. grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're what? About to mess with some sort of fire?
Shoot a gun
They're
in
not
the air?
threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself.
What?
He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground.
They need to
His
object to
AR-15
this
isn't going to
here.
put out a fire.
Well, maybe not. I don't know.
So why
but-
is he really there?
Yeah, I don't think so. This is all
And we all
stuff
agree
that can come up
you
in there.
can't use or threaten deadly force to protect someone else's property.
It's just repetitious.
Yeah.
He drops the fire extinguisher and runs for
You are
his
here
life.
to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you.
Oh, jeez.
As a teacher, when a student says to you, the dog ate my homework, that's an
my
excuse. It doesn't get
This
you out of
is
the homework
awful.
assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications.
No, I'm scared
No.
is literally a legal justification.
Did you hear that if you put
Your
yourself in a
personal responsibility
situation,
for your
that
own
sounded a lot
actions.
like you lose your self-defense right.
Yeah.
That's what he's trying to suggest
The
here.
court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives.
Without a justification.
I think this was the third part of his outline from the intro.
Yeah.
He was going to talk about the instructions.
Right.
He's wrapping up soon, I believe.
I think so.
Oh,
I mean, this is
Poor
this is
daddies.
degraded into
And
nonsense.
poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass?
No.
Do we think that's okay?
What the hell are you
Do we
talking
think
about?
what he did was right? That's the question you have to
Not
answer.
right. Justified.
And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first
Come on, long crime. Stop
degree
doing this.
intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill.
It is absolutely
Expert
not.
evidence.
It is not in any way
Yeah,
certain.
we all know this case comes down to self-defense. But there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force, which is intended or likely to cause death or great bodily harm, only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant?
Yes.
No way.
That's the question.
100% yes.
Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant?
No.
Yeah.
He did it. He caused damage to his
Jump
head.
kick man or Gaige Grosskreutz?
You could have killed him with that first blow.
He
None
just said
of
for
these
Gaige
movies.
Grosskreutz had a
Posted
gun
imminent
pointed
threat.
at him.
This is when he loses
Cause great
credibility by
bodily harm.
pretending Grosskreutz did not pose a danger.
The standard,
everything loses credibility.
when you make this decision,
I'm sorry, what
is
credibility
what
did you have to
a person
lose?
of ordinary
I'm sure he's gotta
intelligence
know
and
what's right.
prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and
Yes.
not from the viewpoint of the jury now.
Yes,
So put
exactly.
yourself in the defendant's position.
Do it.
Would you have done the same thing?
In those videos.
Every one of them
Reasonable
would have.
person have
With
done
the
same thing?
chanting and everything else.
Would you have engaged in the reckless conduct that led to this course of events?
He should
Would
have
you have
not
gone out
strayed
after
into
curfew
the law
with an
here.
AR-15 looking for trouble? Would you have aimed
No.
at other
What's
people?
that? What's
Would
that?
you
How's
have
that
tried
relevant?
to use the gun to protect an empty car lot? No reasonable person would have done these things.
None of that is the
The
standard.
court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense.
Oh,
By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything.
Oh my, no.
And if he
Bringing
does
the gun
that,
there is a
he
mistake.
has
Got
to
to
exhaust all reasonable means to avoid a confrontation. All reasonable means.
Like running away.
So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life.
How not?
And
Maybe
not
that's
only is
for
the
new
defendant
jury
expected
instruction.
to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help.
This idea
do
that
all
Rosenbaum
sorts
is
of
a
other
rag
things
doll.
Besides
It's
just
pretty funny.
turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum.
Well, it was
He
done in
put
self-defense
Richard
and it wasn't a
McGinnis's
crime,
life
so yeah, there's
in
every
jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gaige Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
I mean, it was a good last line.
Yeah.
Yeah.
Let's
This
take a
was
break and
such a disaster.
about,
Such a terrible job he
2:25
did.
hopefully.
Disaster for
I've
disaster.
got to go relieve my pregnant woman bladder. I'll be right back.
I'm gonna break down for you. I'm gonna break down for you all the mistakes that he made there. So first and foremost, you have to understand, and because I said I counted.
All right, what I'm going to do is I'm going to let Joe go through his analysis of the mistakes, because I want to hear that. But we're now coming up to the 6-hour mark, and I do have things that I have to do today. So we will follow up with the closing arguments probably tomorrow or the day after. I will put things up. But yeah, I'm going to let Joe go, and then we'll call it a day.
4 or 5, I finished with 13 tactical errors that Binger made. Okay, so first and foremost, he needs to retain credibility for 2 key points. First is he's trying to get the jury to believe in his whole theory about Kyle waving the gun, which is something that there's no reason that we should. I mean, it's very,
Yeah, well,
very
he already
sus.
did that.
So he's trying to get them to believe in that. He also wants them to believe that Rosenbaum never threatened. And even though Kyle got up there and his own witness got up there and testified about this threat that Rosenbaum made, so he wants the jury to believe him that this never happened. So he needs to retain that credibility. There was literally, I counted 6 different statements which he made, which made him very difficult to believe.
I wondered if I'd have given
It was difficult to believe when he says that all they did was knock his hat off. When everyone there saw that he's getting clubbed over the head with a skateboard, he's making comments saying that this was the least intrusive way that any reasonable person would have come after him, saying the police are right there, and that the police, when everyone saw the police is not close enough to help. The police being 3 blocks away is not the police being right there. That's
you could have
straining
gotten away with
credibility.
murder because I wasn't
Saying
I
when
wasn't
he's
timing it.
trivializing the efforts
after having-
that
Yeah.
Kyle
You were
made as
hollering
a
at your
medic.
truck.
Hold on, what's the judge saying?
The judge just said he wasn't timing the presentation.
Yeah.
What's
Yeah,
that?
Joe's right.
Well done, Your Honor.
Well, why don't we call one of the networks and they can tell us
And
because
painting Rosenbaum as an angel and a
Right.
rag doll, while he's
Yeah.
also
Hold on,
playing
trying to-
video,
trying
he's
to
saying
figure out-
shoot me
Well,
and
that's
over
gonna
and
be
over and
a
over. I mean, he didn't play that, but he played
work it
video
out,
leading
and
up
if
to that.
necessary, we'll,
These were terrible, terrible tactical
we'll,
errors.
have a
And
hearing.
also, he kept bringing up how he has a right to self-defense, how they had the same right to self-defense as Kyle. That's an admission by Binger that
all
Kyle
he
has a
did.
right to self-defense. You don't want to paint that into the jury's mind. They're like, yeah, okay, all of them have a right to self-defense. I think that this was such a terrible second half. The first half, look, I hated what he was saying when he was, he spread a lot of lies. But I think that his lies were effective, and they were he was making powerful arguments supported by lies. But what he was basically doing over here in the second half, he kept shooting himself in the foot over and over again. Even the 4 doors more whores, I thought, just makes Kyle endearing.
What was the judge talking about?
He
Let me
hadn't
go back.
He hadn't timed them.
Sorry, what
No one
was that?
timing it.
He
No one
didn't
was
time.
timing it, so they don't know how long it was.
Oh
He-
my
he-
god!
So he said maybe we can call one of the networks that was recording and ask them.
Call us, we're on it.
The defense should do that. The defense
Definitely was
should be
over
all
2
over that,
hours.
right?
Yeah, they were definitely
Can
over
we
2 hours.
two and a
that's
half
for sure.
hours? I'd be ending it. I'd be like, you told us 2.5 hours. They literally went 2 or even over. They should be all over.
Can we
Yeah.
appreciate that Binger just said Grosskreutz with a bullet in the chamber of a gun pointed at him at point blank range did not pose an immediate threat to his life or physical safety? Can you appreciate
go that
how
far, yeah.
dumb? He
Yeah.
must think everyone around him is dumb. Like he might have scored a point with, he might have had a better argument, but still a bad one with Rosenbaum. He has no point with Huber because we saw him hit him with a skateboard, which is literally physical harm. And to say that a man pointing a loaded gun at an individual is not an immediate threat. I mean, you have to think everyone around you is an idiot. And
He just wanted to give him a hug with a bullet to the head.
No, but he wasn't pointing it.
JH
Go for it.
says 2 hours and 8 minutes. Dad says 2 hours and 43 minutes.
We'll
so
get
it's,
there.
It's hard to say how long.
But thanks
it
for
was.
the super chat,
I'm
Carl.
getting a report
Can't
by
wait
the
for your
way
reaction
that,
to Chubb's rebuttal to
that
Richards.
apparently the copyright kerfuffle was a quote unquote mistake.
Oh.
Okay, well, we
It's
feel
been-
better about that now.
I don't know where the
Which is-
report is, but someone said it was reported as an accident.
Yeah,
Okay.
bullshit.
Multiple times, multiple
Well,
accidents.
someone else has 30,000 viewers. That's what I'm saying.
Yeah, 40,000. But we are now within 5,000 of PBS. No, we're actually we're competing with PBS right now. They have 70,000 and we have
Can we go back to full screen as long
70,000.
as we're waiting?
Awesome.
Yeah, yeah. Sorry, I was just showing that as we were here, but no, I agree with Joe. The second half was terrible. It was
Right.
it was absolutely not helpful for the prosecution. It may have been harmful to sit there and it depends on how the defense picks it up and if they incorporate it. But I want to welcome to the stream someone who popped in, Mr. Robert Grueller.
Oh, sorry, Viva.
Welcome to the show, buddy.
What's up, everybody? Thanks for having me.
Hey, Robert.
Hey man, how's how are things looking today? What are you thinking?
So I got caught up earlier this morning. I agree with basically what Joe said. First half was pretty good. When I was listening to Binger at sort of double speed this morning, I liked the theme that he was going for. I mean, in terms of a prosecutor, obviously, but what's happening, I think, here is not unexpected. A lot of this, I think, was prognosticated. It's sort of death by 1,000 cuts. He's trying to show that Kyle Rittenhouse has committed a number of unsavory things, whether they're illegal or not, sort of driving without a license, traveling across state lines, being on property that he shouldn't have been on. All of these are the claims that the prosecution is making. And the second half, I was sort of questioning at first why he was playing those videos. I thought that those were problematic for the prosecution because it sort of looks like a war zone. I always thought that what the government was trying to do here is sort of synthesize this all into, extrapolate this all into a big long sequence of events, whereas Rittenhouse's team wanted to synthesize this into like, seconds versus hours. And the government here is turning this into an hour-long thing, a multi-day thing. And they're trying to show that Rittenhouse has been sort of continuously breaking the law. And, it's really, I think it comes down to provocation, and that's why they played those videos. They want you to see, or they want the jurors to think that any kid or any
OAP,
17-year-old in
I'm not doing
Rittenhouse's
any actual
position,
work.
if he was
Don't
sort
worry
of
about that.
leaving that property, that was de facto almost reckless. And so, I thought it was as good as they could do with a pretty bad case. I've been saying this a long time. If you have if you have good law, you pound the law. If you have good facts, you pound the facts. If you have neither, you pound the table. And here we've seen sort of a lot of the pounding of the table. But at the very end, at the conclusion of this case, when you sort of want to put a bow on it, I think that he did what he had to do to sort of make the provocation claim. Kyle doesn't have self-defense because he caused all of it, is really the only argument that they have. And I think, with a pretty weak case, he's done a pretty decent job, actually.
Yeah, I think that's correct. Except
That was my
I think the
prediction at the
second.
beginning.
What was that, Nate? Nate.
Nate
I'll
can
do
decide
it.
whether he wants to be muted or not.
I
Oh
can't
no,
get-
I'm sorry. No, I said that was my prediction at the beginning. They're going to pound provocation to death, and that's exactly what he did. He just pounded provocation.
He said that Grosskreutz did not pose an immediate threat to life or physical safety. I mean, if anybody was following him up until that point, they now look at him and they see nothing but a bold-faced liar. Like, there's no way anybody can say, hey, if I'm in Rittenhouse's position, looking at Grosskreutz, I don't feel immediately threatened where I need to use lethal force. They will lose him there, and I don't think he'll ever get anybody back, even if they were with him in the beginning half. That was reputation compromising stupidity that he uttered in one sentence that undermined everything he said up to then.
It is very strange for the prosecutor to ask you to put themselves in the defendant's shoes. That's very, very weird.
Yeah.
It's like put yourself in the victim's shoes, put yourself in the crowd's shoes. But the prosecutor saying put yourself in the defendant's shoes, would you have
He
done
did that
this?
because he read the full definition, right? He didn't do some. Should have edited it a little bit, I think.
He doesn't need to make it abundantly clear, though. He doesn't need to bring it to their direct attention.
No, I agree. And I agree with the fact that those videos sound like the war zone. That was the thing that jumped out at me. I hadn't seen all of those videos, so I was a little bit of a new eyes there. And I looked at that and I said, wow, that looks to me like there's a whole bigger swath of reasonable behavior when you're facing a circumstance like that. And I don't know how that'll be taken by the jury.
That's the problem with writing real quick. That's the problem with doing a slideshow, right? He was not able to adapt to this morning, and he's locked into what's on the slides. That's why you typically don't do a PowerPoint presentation for things like this. Sorry, Alita, I didn't mean to step over you.
Yeah, no, I was going to say that, and some of the stuff that he was saying was also kind of contradictory because, on the one hand, what was he doing, going and carrying around this gun? Because by carrying this gun, he was provoking everyone else. But then on the other hand, he was like, well, no reasonable person would be there because everybody knew that this was chaotic. Everyone knew that this was a war zone. Everyone knew that people were likely to attack one another. So it's like those two things don't make sense together. So if you're going to try to argue one way. Like, don't try to kind of spread it out everywhere because the jury's not going to follow your logic.
And it's different standards between every victim, different standards for every single person. So Rosenbaum wasn't justified because he didn't have a weapon. Okay, well, Huber did. He had a skateboard and he was cracking Kyle over the head over it. So does that now justify self-defense, or does an actual gun like Grosskreutz had at that moment? Now, is that good enough for you, Thomas Binger?
Yeah, really. I largely agree with the consensus on the second half. I found it to be wandering at best. Muddled, unclear, unstructured. I lost the theme and the plot. It just became a recitation of facts.
I think Robert did a much
really
better
connection
job.
Structure. Yeah,
I think
absolutely.
the second half is all about provocation. Yeah.
I think he took up
as,
the first half.
As Good
doing
Logic
that.
pointed out, there was some major errors along too, especially with they put yourself in the defendant's shoes, which seems very bizarre to me.
Also,
so, yeah.
one of the comments when he showed the video footage of Kyle shooting Huber and then shooting Grosskreutz, and then his immediate comment right afterwards was, "Look how fast that was." That's not good for the prosecution.
Yeah.
I was like, "Why are you pointing that out? That's not helping
like
your
in
case."
the first half when he said, "Look how close." Look how close he is. Oh, I mean, how far he is. Oh, yeah. Okay.
Yeah. I mean, that Freudian slip was not great for him.
Yeah, you want to go back to the frame by frame if you're him. You want to make it sound like each frame is that Fallout system, and you got time to target and re-aim, and it's all some sort of video game.
I do
right?
all my
But it's
self-defense
not
in VATS.
Yeah.
Nice. Yeah,
God,
exactly.
no video game references in that closing.
Yeah.
If Richards is watching, I don't remember. Did he say verbatim? Put yourself in his shoes, or you have to view it as though. So someone who's
verbatim, but yep.
So someone who's quicker than me on the interwebs. But I mean, if you get to Richards and you flash that image, that still shot of Grosskreutz, the moment his arm is being vaporized, pointing a gun, and you say, "Put yourself in Rittenhouse's shoes right now," and what would you do?
We got like 5 minutes. I can keep going for
there
the 5
can
minutes.
be no reasonable jury member that will say, "I would have just waited to see what Grosskreutz was going to do because he hadn't pointed the gun at my head yet." And then you have to work backwards from there. You're going to work back from the most absurd, idiotic claim that Binger made to then go back to the ones that might have been more plausible, but for the idiotic one that he ended his closing arguments with.
So all Kyle needs to win is Richards not to bore everyone to death and not completely screw it up. So we're in the clear.
So it's like a 50-50 shot.
He'll get to the. He's good on the facts. He'll get to the facts. But I mean, and Binger ended on his weakest point, and so they can start on that and then work backwards to undermine everything he said.
Can you believe that he even referenced that his own defendant testified that he's like, don't believe my own the own witness that I put on the stand who said that Rosenbaum threatened. He's like, well, don't believe Balch, don't trust Balch. You put him on the stand. You're basically
he's like,
the jury,
don't believe Balch.
disregard.
That's the idea.
Don't believe Grosskreutz. Don't believe my ballistics expert. Every witness I brought to you, you should disbelieve and believe me now. It's ridiculous.
When they qualified them as experts that they weren't, right? It's like each of them were giving expert testimony that they were absolutely not qualified to give at all whatsoever.
Someone on Twitter brought up a great point. They said, let's see Binger try this shit in a domestic violence case. Let's see you argue in a domestic violence case that hands alone are not sufficient for lethal self-defense.
Yeah.
I mean, there's no way. There's no way even a 5'4" little tiny manlet with no muscle mass like Rosenbaum apparently beating a woman into submission that she's not going to be justified in pulling a gun and putting him where he belongs. Of course he is, and of course Binger would not prosecute that case, right?
Yeah.
Like there's no way you're going to bring that. It's nonsense. It's dishonest, and that's the problem. I'm sure all prosecutors, of course, Nate's not here right now, and neither is Emily Baker, but I'm sure they're screaming inside because Binger is doing everything that everyone actually hates about prosecutors right now.
Damn straight.
It's really frustrating because I rip on prosecutors a lot, but one of my friends is a prosecutor down in the South. Like this guy does prosecutions and he puts bad people away, and it's like. But Binger is making it like every prosecutor is on him right now. It was the same in the OJ case. It's like when you are a nationally recognized case, you have a burden. You have a burden that you maybe shouldn't have, but you have to recognize that it's there.
Well, and the firearm stuff was driving me mad. And I guess shout out to the guys on In Range TV's Discord who are also going insane because it's a Discord full of gun people. Hearing Binger going off about gun facts. I don't know if you've seen that picture that was taken, when he shoulders the AR. That's now made it onto Twitter. His finger is on the trigger.
It's on the trigger.
And he's got it shoulder. He's chicken winging, and he's got the stock is riding like right up over his shoulder. He's clearly never actually held one. This is an unfamiliar item to him. He's just... And everybody who knows anything about firearms is just going insane about this because he's speaking off and he's presenting falsehoods. It's
and to take the domestic violence
Rabbit.
example one step further, not just about the fists versus firearm defense, but just imagine had the victim just done what the abuser said, not leave the room or not leave the certain part of the house. Had they just done that, then they wouldn't have provoked the attack in the first place. I mean, basically, you have Binger saying, these guys, had they just stayed on their private property and not walked the streets freely, as is their right to do so, they wouldn't have provoked the assault and relinquished their privilege of self-defense. Had the abused spouse just done what the abuser said, it wouldn't have provoked the attack, so they forfeited self-defense. The only difference being it's a young kid with an AR-15, so it's much different to view that kid in the way you would typically view a domestic violence victim.
Yeah,
it's even worse though, Viva. It's even worse because they called not only that, but he went and would call the domestic abuser a hero, right?
Yeah.
Because that's what he went out and called Huber and Grosskreutz.
And Rosenbaum. And it's exactly the same thing as she had it coming. This is
Yeah,
exactly
we're-
the same thing as she
we
had
are
it
a
coming.
half
She was
step
dressed like
away.
that. She had it coming.
He pays his
We-
taxes.
We are a
Did you
half
said
step
both?
away from it's Mardi Gras. There's a lot of men out that are full of alcohol and looking for a good time, and this woman was wearing a scantily clad dress. What did she think was going on?
Oh, here we go. Here we go.
All right.
For the most part, on the
Okay, so 5 hours, 38 minutes, 16. Guys, I'm going to end it there so that we can get stuck straight into closing arguments. Look at this. We've got a video within a video within a video. Yeah, this was Viva before the trucking protests, so... Alrighty. I'm going to end it there. So thank you very much for everyone that has stuck with me for the last 6.5 hours. Please remember to feel free to like, subscribe, share, double check whether or not you're still subscribed, because YouTube sucks and is sucking subs off. Not in a good way. I just realised how that sounded. They're removing subs. They're slicing them off. You too, Glitterfart. As always, guys, please remember, you watching are very much not a piece of shit. You are not a binger. You are not the binger. You are not that binger, anyway. You do contribute to society, even if all you do is hit that like button for me. As always, guys, Aussie Overlaw'd checking out. Stay healthy, wealthy, and wise. Love yous all. And let's hit the outro, wherever it's gone. I've got to move that. Adios, guys.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.